I'll just pop up on your screen. There I am. So, good morning. Hello. I am a little towel. I am not going to go on a rant this morning. I want to talk a little bit about my grandfather, Ed Murphy, and I think that's something that's important to me, so that's what we're going to do. And I also will get us ready for the 9 a.m. Brian Walshe coverage. Maybe I'll play a video of some kind, depending on if I don't want to talk. But I don't know. My grandfather was a very good man. We've talked about him on this stream before, and I think the easiest way for me sometimes to talk about not only someone that's close to me, but a person, someone's life, however they may come up, is for me to put it into words. I don't know why that is so helpful to me, but I think there are also certain people who resist during their lifetime being put into words because of how noble they are, but have this momentous impact both on a micro and macro level. And I think my grandfather was one of those people. So I'm not promising I'm going to be able to get through this very easily, but I'll try. And my grandfather was, we talked about him on the stream before, in particular, the story I like to tell about when he was down at Mar-a-Lago and President Trump, for seemingly no reason, although it was clearly for a reason, spent 3 hours talking to my grandfather. Now, they were there because of a charity that my mom used to help run that would provide resources for SA victims who had to travel to different states for their hearing. And I don't know, my mom was always in those like Bill O'Reilly, et cetera, circles. And so Bill was on the board of that. And I think they knew President Trump. It was way back in the day, before he was president. But they knew President Trump because he supported the foundation very quietly. He didn't like brag about it, but he was a nice guy. And so anyway, I've told this story before, this adage about my grandfather at Mar-a-Lago just sitting at a table for this function. And all of a sudden, President Trump comes in, and he didn't need to do this. I don't think anyone had planned for this to happen. I don't think he planned for this to happen. But he sits down at the table with my grandfather. Now, my grandfather was, ostensibly, you would think he was a simple man, but he was actually a very complex man. He was a bricklayer back in the 40s, the 1940s, in Newton, and down the lake. And he was Irish, and I think his parents were Irish immigrants, might have been his grandparents. And they came over to the United States, and Grampy worked as a bricklayer. Now, during World War II, he tried to enlist in the Navy. He goes down to the port in Boston, and he, quite hilariously, goes through the screening, tells the doctor his allergies, and they think he's fine. So he ships out, he goes onto the boat. Back in the day, they had wool uniforms in the Navy. Well, little did Grampy know, he put the wool uniform on and immediately almost died from an allergic reaction. Oh, goodness. That was Grampy's attempt to serve in the Navy. He did end up serving in some kind of civilian or different post that didn't require wearing a wool uniform. Then he went into the fire department, started as just engine driver or the crewman on one of the engines, worked his way all the way up in the Newton Fire Department over 42 years to become the chief, and retired as such in 2001. Grampy was one of those people who really embodied the old world, the sort of traditions and local bonds of community, a JFK Democrat who absolutely was alienated by the Democratic Party and became a fervent President Trump supporter by the end of his life. I think Grampy knew JFK. I don't remember why. There was some reason, some overlap there. I think it was because JFK ran for the 10th Congressional District out of Oak Square in Brighton, which was kind of near Newton. It's like right off Newton Corner there. But anyway, my point is, Grampy was a wonderful man. So I'll read you the post I wrote about him. I don't think it's possible, to actually explain the life of this man and how many people he impacted, not just within his family and his grandchildren and whatnot. 3 of his sons became firefighters. Obviously, one of his daughters is Wendy Murphy. He was just very impactful. But he himself, every, politician, mayor, even President Trump knew Grampy. I don't know how. He was just a very, he liked golf, and he loved the firefighters, and he loved the, service, public service. But he would, he had this side of him that was very congenial. He'd walk into a room. It didn't matter if it was a giant political function or, a family gathering, and, he was Grampy. Just him. Well-known, well-liked. And, I don't know why politicians liked him so much. I think it was because he represented this very authentic kind of everyman working class sort of view, and it cut through a lot of the noise. So if you needed somebody to just tell it like it was, Grampy was your guy. So a lot of politicians, like mayors, governors, whatever, they really liked him, or sheriffs, whatever, because he would just say, here's what's going on, cut through the bullshit, this is what we need to do. And that's why he was a fire chief. He was very good at efficiently administering the fire department. And I'll read the post I wrote about him, but one of the staples of his life was, even when he retired, he had a scanner, and he would listen to the fire department radio all day, not because he was reliving his time as chief, it was very stressful, but because he wanted to know whether any firefighters were in danger. 24 hours a day, 7 days a week, that's what Grampy cared about. So I think there was something about that ethos that politicians really respected. They saw him as kind of a voice of a profession that's very noble, and he was very unsung about this. Maybe there was an article in the Herald once that my mom wrote up, or maybe he got a commendation from time to time, but he wasn't out there being like, I know President Trump, I'm a firefighter, former fire chief, let me tell you things. No, he just kind of went through the world, played golf, went to donkeys. He lived a very mundane existence, but for some reason, and I know the reason, his heart of gold and his insights and his legacy of service in the fire department built him all these connections in the political arena. And it was more like he was the guy that the guy would rely on for advice. And he was very good at that. So that's Grampy. And let me read you a post about him, as sadly he did pass away this week. And I don't even think it's really hit me fully yet. It's definitely hitting me in waves. I've heard that grief is like shipwreck in a storm. Being in a shipwreck in a storm, the waves are very big at the beginning. Then there's a lull. Then they become less frequent. I don't even think the first wave is hit. I kind of think I'm looking out at the tsunami because I just have a way of processing things, and I see the waves coming, and I'm just like, maybe if I talk about it, the waves won't hit as hard, or I can surf over them or something. I don't know. Psychology, amateur psychology with Towel. But let me read the post. There are those that walk among us, quietly at that, who embody something larger than life itself. My grandfather, Ed Murphy, was a bricklayer turned fire chief who could hold a 3-hour conversation with President Trump and then head home to play golf and sip donkeys in Natick. I love you, Grampy, and I'll miss you very much. Thank you for being the kind of man this world needed as we confronted the shift into the digital age. You helped me learn values, safety, country, God, family, that will endure despite the chaos. And somehow you got me to support President Trump. Side note, Grampy will be very pleased with that up in heaven. I'm telling you, that was his life goal. He just wanted me to support President Trump. He spent 20 years on it. Grampy loved his country, he loved his family, he honored his God, and he always put the well-being of those around him above himself. Even when he retired, Grampy would sit with a fire department scanner every moment he was awake. When I asked him why he did that, beyond the obvious, he told me, I get worried when I don't know if the guys out there are safe. Should have heard the arguments that Mom and Grampy would have about women firefighters. Grampy was like, they can be firefighters, but they got to pass the same exact test. Grampy had every single firebox in Newton and parts of Boston memorized, and I used to quiz him well into his 60s and 70s. He never got a single box number wrong. That's true. I'd be like, Grampy, I'd get the map, and I'd be like, Grampy, what's the box number at the intersection of California Street and whatever? And he'd be like, 67481. And then I'd say another one. I'd be like, whatever. Wow. He had a very, very good memory of the entire firebox network. By the way, before it was common that we had cell phones, to get the fire department, if you didn't have a house phone, you had to go out into the street to your nearest firebox and pull the firebox. So, of course, Grampy, being the fire chief he was, had to memorize all the box numbers so he could be like, we got a call from box 64841. Oh, okay, send engine 3 from station whatever, because he had to know the closest station, what the box was, residential potential, commercial potential. He was just a brilliant man. Grampy embodied a version of family that is fleeting. Yearly Christmas Eve celebrations where Grampy Claus would make up rhyming poems on the spot as he handed out presents. It is possible the rhymes, after a few glasses of wine, started to combine. See what I did there? Triplet rhyme scheme, and then I punned on the word combine. I'm a little towel. I clearly got some of his poetic brain. Even with nearly 60 grandchildren, Grampy managed to find time for us all, and his momentous impact can only be understood, like Citizen Kane or Big Fish, from the manifold number of lives Grampy impacted on this planet. Truly, the measure of a life well lived for a man who, thankfully, was always told how much he meant to those around him at every turn. Honorable, noble, dedicated to the service of others, a quiet hero with a legacy that will endure in so many ways. And that is true. Ladies and gentlemen, it is true. My grandfather was a very noble man, a very honorable man, and I'm so glad as we start today that I was able to say that to you all. Good morning, Marvin. Good morning, Monica. It's so good to see you. We will have coverage at 9 a.m. of the Walshe hearing, but wanted to spend at least a few minutes talking about my grandfather, and he just left such a important legacy. And it's one that, although wasn't really told during his lifetime, and he wouldn't have wanted to have been, I think it's something that people should see as someone who was born in the 30s or 40s, grew up in an old world, saw America at its best, and then, as we shifted to the digital age, was intent on teaching the new generations those values that would help us get through the transition. He was just an unsung hero in so many ways. And I think his life was like Big Fish in a lot of ways, if you've ever seen that movie. Citizen Kane's more apropos, but I think Big Fish for a modern audience is fine. It's like you go through life as a human, and to you it seems so mundane. But there are those among us who, when you go to their funeral or you talk about them in retrospect, you realize that they touched like every sector of society. They had friends everywhere, every state, every country. All these people knew them. And then you see the measure of a life well lived is embodied not so much in what you're doing day to day or what you're thinking, although those are important. It's the lives you impact. And there are some people who won't just have a funeral where people go and then they move on to what's for dinner. There are some people whose very existence shaped and molded, guided and binded the development of not only their family, but the larger sort of path of society. Was Grampy out there on TV making speeches? No, but I think his impact in a lot of ways not only embodied reciprocally the development of the unheard part of the polity, but also Grampy was a thought leader in that he was speaking to a lot of powerful people behind the scenes, and they would listen to him, and then you would see symbiotically his views start to emerge. So I just can't say enough about the role he played, how he played it, how much an impact it had on my life, and why a lot of what I think, how I think, and how I approach my work comes from the values that he didn't really say, but embodied. He didn't need to say it, because the moral lesson was in how he lived his life. And that's what we need. And that's why I really loved him very much. And I still do. So, love you very much, Grampy. And this show today is certainly in your honor. And God bless you. Ange, thank you so much. God bless America. And thank you. Ange says she loves the story of Towell's family. There are many stories to tell. Grampy was afraid of planes. He had an opinion that he would not go on a plane. All right. It didn't matter what plane it was. He told me that. I really pushed this with him one time. And he told me that if the government came to him and said, you have to go on a plane because we need you to do X, that he said he would do it, but he would make them drug him. And he was like, that's the limit. Like, if the government commands me to go on a plane, I'll do it, but they're drugging me. And he was like, he just couldn't do it. So when Grampy would go places, he would drive. So his yearly trip to Florida, he had it all planned out. They would drive down. His trips out to the western part of the United States, they would drive. And so Grampy, for whatever reason, he was like the quintessential American everyman, could go to every state, liberal, Northeast, Midwest, South, West Coast, it didn't matter. And he just knew everybody. They liked him, he liked them, and somehow he would always find himself in a room with very powerful people who would listen to his talk, his speeches, and then they would say to him, please talk to me more, even though if you just like met him, he would never say this. He'd be interested in golf and politics and firefighters, all this. But in reality, he was always in the room. Whatever the room was, the decision-making room, he was in it. So that's Tao Grampy for you, Ed Murphy. God bless him indeed. Let's play a video. I don't know how much I want to talk this morning. I'm sorry. I'm not that inclined to yell about things. If there's like news that happens, I guess we can talk about it. We can talk a little bit about the Proctor motion. Maybe, I guess today's going to be a little bit busy because we're going to be going from the Walshe hearing. We don't know if Walshe is going to put on a defense, and then maybe closings, and then we have the CCC hearing where the final social consumption regulations are going to get voted on. So I don't even know how much time we're going to have to go over things. I just don't really want to. I guess we could have the AI voice read the Proctor motion, okay, and then we'll see the judge's order. I think that's fair, right? Is everybody all right with that? We'll have the AI voice read the motion so I don't have to, and then I'll talk about it after the AI is done. It's a short page, and we'll pick a voice that isn't the one we picked for Cosgrove, because that was maybe a little spiteful. But you know what? It's art. It's art, ladies and gentlemen. If I'm having an AI voice read things, that's my artistic license, all right? And sometimes you got to be an artiste when you're doing this. All right. Let me pick a voice. All right, what are we going to go with? How about this? Let's try it.
Read Aloud is a Chrome and Firefox extension that uses
I need it a little
Read
faster.
Aloud is Read Aloud is a Chrome and Firefox extension that uses text-to-speech technology to convert web page text to audio.
All right.
It works on a variety of websites, including news sites,
you can
blogs.
Stop now. All right, I'm going to try to get this to work for us. There's no guarantees this is going to work. However, I do like the voice, and if we're going to listen to the new motion from Rosemary, then we should do it this way. All right, let's see if it's going to work. No promises. Come on now, you can do this. I have faith in you, program. Oh, what do you mean you didn't find any text? That is a Travis mockery. I am offended. All right, hold on. I now got to do it the annoying way. I guess I shouldn't say it's annoying, but it's not necessarily the most user-friendly to have to go over to the service, and then you got to type this. Oh, hold on. It's going to make me pause my camera. You got to go over to the service. I'll just talk you through it. Then you got to, if the PDF is not OCR readable on a first pass, you have to go over to a different service. You have to get the machine readable, the non-machine readable PDF, and then you got to convert it to a format that is machine readable, and only then will it render you a text document that the text-to-speech program can use. And that's why I say it's not really about me. I just wish, like lawyers, you just have to click a button when you're generating a PDF that will make the text scannable by OCR, and then we don't have to do this. It's not the biggest deal in the world. Other than people who are disabled or who like to have documents read by an AI, no one really cares about this. So if there's nobody's like thinking about it, but I think we might have to have a rule for disabled people for accessibility purposes that if you're going to do this kind of thing, if you're going to make a PDF, there should be some requirement, if whether it's scanned by the clerk that into text-to-speech format that's accessible. It can still be a PDF. It's just a type of PDF. And the or the lawyers themselves, if they're uploading it to through ECF or through whatever the mass court's attorney portal. There should be some requirement in the filing rules, not the court rules, like a broader rule for every court, that it's accessible. Is it the most important thing? No, but it's an accessibility issue. All right, so let's read Rosemary's motion. Let me zoom in on it for you because it's hard to see. And this has to do with Michael Proctor's cell phone, and then I will yell about it. Maybe I won't yell. We'll see. We'll see how I'm feeling. Sometimes I yell. You know what I'm saying? Only occasional yelling, you know? All right. Please read it for us in that wonderful voice. AI, take it away.
2Z, Cent, 20. L. GQ'd. Commonwealth of Massachusetts. Norfolk, SS. Superior Court, Norfolk. Docket No. 2282CR00268. Commonwealth. VV. Sean Johnson. Defendant's motion in response to the Commonwealth motion to provide law enforcement bodies information derived from a former state PROLICE trooper's personal phone and to vacate and or modify the protective order. Now comes the defendant, Sean Johnson, in response to the Commonwealth motion to provide law enforcement bodies information derived from a former state police trooper's person's cell phone pursuant to Mass. R. Crim. P14, 7, and respectfully requests that this Honorable Court allows the Commonwealth's motion and vacate the protective order issued on October 24, 2025. The order specifically reserves the right of any party to move to modify the existing order. As reasons therefore the defendant states 1. With the exception of the Proctor personal cell phone references to a sexual assault victim and accompanying photographs, and any photographs of any children which may be contained in the Proctor personal cell phone, each of which are prohibited from disclosure by other statutes, the purported concerns raised by the Commonwealth in its related protective order are not justified based either on information provided by the Commonwealth in any affidavit or motion, or based on a counsel for Johnson initially assented to this protective order and has not received the two filings from the Commonwealth. 4. Review of the initial discovery produced by the Commonwealth, and this particular situation fails to satisfy a finding of any recognized security interest that would warrant a further protective order. 2. The Commonwealth has not presented any affidavit or evidence of any proposed safety concerns from any of the participants in theses text chains, voicemails, or email chains. 3. No actual information was provided, or is apparent from any of the materials produced, that give rise to the Commonwealth's purported concerns of disclosure of any personal cell phone numbers or personal emails, and neither of these reasons justify the protective order. 4. Any claimed risk of security of any of the participants in these text chains, voicemails and email chains fails to justify precluding the defendant from accessing crucial material necessary for him to fully and plainly, substantially and formally understand the allegations and charges in light of claims of bias. See Mass. Decl. Rights Art. 12. 5. Johnson has rights to due process and a fair trial pursuant to the 6 inches and 14 amendments to the United States Constitution as well as Article 14 of the Massachusetts Declaration of Rights will be violated as Johnson is not allowed to investigate the bias contained within these texts, emails and voicemails. The current protective order prohibits Johnson's investigator from discussing the content of any of the materials on Trooper Proctor's personal phone with any potential witness. 6. As such, Johnson requests this court allow his motion to vacate the protective order. Respectfully submitted. Sean Johnson. A. Oft. Boston, Massachusetts, 02109. 617-263-7400. BBO number 558312. Commonwealth of Massachusetts. Norfolk, SS. Superior Court, Norfolk. Docket No. 2282CR00268. Commonwealth. VV. Sean Johnson. I, Rosemary Scapicchio, state the following to the best of my information and belief. 1. I am an attorney privately retained to represent Sean Johnson on the above captioned case charging Mr. Johnson with murder and other offenses. 2. On October 24, 2025, the parties agreed to a proposed protective order involving Trooper Proctor's personal phone. 3. This court endorsed the proposed order on October 24, 2025. 4. At the time that the order was made, the Commonwealth had claimed that a protective order was necessary to protect screenshot posts by non-participants, images of non-participants, full phone numbers and/or personal MI addresses of the text chain participants. 5. The Commonwealth further claimed that non-participants who appear within the produced materials may have a security interest in not having their personal identifying information released to protect against harassment. 6. Posts to social media are not private and do not justify a protective order. 7. There is no reasonable expectation of privacy in personal cell phone numbers and personal emails addresses of participants to these texts, emails and voicemail chains. 8. Once a text or email or voicemail is sent, the sender has no right to privacy in the text, email or voice message itself or the content contained in the text or email. 9. Because the Commonwealth cannot meet its burden of continued need for a protective order, the order should be vacated. Signed under the pains and penalties of perjury, this, YD. 2026. Commonwealth of Massachusetts. Norfolk, SS.
Hello and good morning. It is Wednesday, August 6, 2025, right after 9:20 a.m., and my name is Grant Smith Ellis. I won't be doing my regular live stream today. That was scheduled for 2 p.m. Eastern. I will be moving that to tomorrow, Thursday, August 7, 2025, in the afternoon. But I did want to take a few minutes to talk about some questions that people have asked about what is the nature of the ongoing overlapping concentric social circles that could be related to the federal probes out of the Moakley Courthouse in Boston. Now, people, as we know, have heard that the federal grand juror leaker, Jessica Leslie, on Monday pled guilty to leaking about at least 4 different active federal investigations. We know that those 4 active federal investigations spanned, or at least the leak spanned August of 2022 through March of 2024. Now, I have a big chart up on the screen, which those faces and names will come to have meaning as we go through this. But to begin, let's talk about how August of 2022 is the exact month, and there's Jessica Leslie's information that she pled to up on the screen, public court document from Pacer. And of course, there is the document showing Alan Jackson joined Karen Reed's legal team in that same month. Now, why does this play into the larger picture? Well, Jessica Leslie was leaking during a time when the U.S. Attorney's Office in Boston, under then U.S. Attorney Rachel Rollins, and then her predecessor, the person who took office after her, Josh Levy, were, according to reports, weaponizing the U.S. Attorney's Office as an arm of certain factions of the Democratic Party within Massachusetts to leak derogatory information about targets of their ire in order to manipulate the political process. This started between May and September of 2022, when Rachel Rollins attempted to weaponize the U.S. Attorney's Office in order to interfere in the Suffolk District Attorney's Office primary between Kevin Hayden and Ricardo Arroyo. Ricardo Arroyo was then an ally of Rachel Rollins, according to a DOJ OIG report released in May of 2023 that led to Rollins resigning her post. And Arroyo was someone who was going to keep up Rollins' hyper soft on crime, extra liberal prosecution approach, and Rollins thought it was important to cement this legacy. Kevin Hayden was a moderate Democrat appointed to fill the vacancy created in Rollins' position when she left the Suffolk DA to become the U.S. Attorney in Boston, which, by the way, I'm pretty sure was a result of Rollins getting a favor from the Biden White House and Senator Ed Markey, because Rollins and Aiden Turtleboy Kearney worked together in 2020, I believe it was, in that Senate primary in Massachusetts between Joe Kennedy Jr. and Ed Markey. okay, in order to send a Republican operative named Rayla Campbell to Joe Kennedy Jr. events in order to sabotage the race and allow Markey to win. Now, you might say, why would the Biden White House care in 2020 about a Senate race between Joe Kennedy Jr. and Ed Markey? And why would Rachel Rollins be working with Turtle Boy to send a Republican operative to Joe Kennedy Jr. events? Well, think about it. It was 2020. Joe Kennedy Jr., I think, was representing the 4th District in the Federal House of Representatives at that time, which is the seat now occupied by Jake Auchinclosh. Okay, JFK in the 50s went from the old 10th District in Massachusetts. His campaign headquarters was down near Lake Street in Brighton and Oak Square, near BC. Tell loves BC. Ladies and gentlemen, JFK went from the 10th District in the Federal House of Reps to that Senate seat, the junior Senate seat in Massachusetts. His desk in the Senate is very famous. People write their names in it when they're in that seat, in the desk, because he did, okay? And then he ran for president, because you get foreign policy experience in the Senate, traditionally, okay? Domestic experience in the House, foreign policy experience in the Senate, run for president. That's especially the Kennedy route. Okay, that's how JFK did it. If you're the Biden White House and you're looking forward to 2024, you don't know this chaos is going to happen with Biden not running and Kamala running. You don't know that's going to happen. So you're thinking about, especially the political machine around Biden, can you insulate Biden from a primary challenge? Well, Rachel Rollins becomes very helpful in that regard if she used Turtle Boy to influence that primary, does she not? Does that explain why Rachel Rollins got appointed to the position of U.S. Attorney? Does that explain why part of the reason Rachel Rollins got forced out of office, according to the DOJ OIG, was that Rollins used an official government vehicle and a driver who worked for her at the U.S. Attorney's office to go to a fundraiser in Andover for Dr. Jill Biden? I don't know, but it's certainly a question worth asking. But so we have to remember, there's the political weaponization of the U.S. Attorney's Office. Potentially, that was because Rollins got into the position because of political reasons, okay? Then you have the May through September 2022 influence in the Hayden Arroyo primary. Then, okay, you have Rollins in 2023 and Levy leaking about the ongoing situation related to State Treasurer Deb Goldberg and Shannon O'Brien, the former chair of the Cannabis Control Commission, after O'Brien stumbled onto a bunch of internal issues in the commission related to nepotism, misconduct, abuse, cover-ups, etc. And O'Brien tried to deal with it, but got taken out by a collective of staff who were, interestingly enough, connected to Rachel Rollins, because Sean Collins, the former executive director of the Cannabis Control Commission, was very close friends. She, a deputy treasurer, in fact, before he went to the Cannabis Control Commission with Deb Goldberg. Who else was friends with Deb Goldberg? Rachel Rollins, who was appointed to at least one state board by Goldberg during this time in question. Now, you may have seen my reporting in recent weeks that, according to my sources, Collins tried to unilaterally appoint Rachel Rollins to the position of CCC Chief of Investigations and Enforcement before Rollins became Suffolk DA. Okay, that shows how tight this network was. So you have leaks about the Arroyo and Hayden primary, weaponized leaks by the U.S. Attorney's Office by the Liberals. Okay, then you have weaponized leaks about the Shannon O'Brien and Deb Goldberg case by the Liberals to help Deb Goldberg and Sean Collins and Deb in that group, and to hurt Shannon O'Brien. Okay, so targeting Kevin Hayden, targeting Shannon O'Brien. These are kind of like not necessarily people willing to go along to get along with the Democratic machine. You seeing a pattern? Okay. And then we get Josh Levy having a meeting in November. '22, right? As, by the way, you know who took out
Rachel Rollins from her position. You know who cooperated with the OIG investigation? You can read the report from May of 2023. Rollins' first assistant, which was Josh Levy, the then head of the criminal division, still head, Bill Abley of the criminal division in Boston. Dustin Chow, the then head of the public corruption unit. I think he's gone. I'm not positive. And then the then executive assistant or executive officer and press officer, who's been there for like 20 years. I'm pretty sure I know who it is. That person's a boss. Okay. So these people took out Rachel Rollins because Rollins weaponized the U.S. Attorney's Office. Okay. They know she did. They reported her. I read the report. They all know what she did in the Hayden and Arroyo primary. Then jump in, okay, to November of 2022. That's when the DOJ OIG is moving. Okay. They're about to interview Rollins in November and December of 2023. They actually make a criminal referral because Rollins lied to them about the way she went about leaking a recusal letter to Sean Philip Cotter, who was then with the Herald. It was bad. Okay, Rollins was going to get criminally prosecuted, but I think for her friends in the DOJ hierarchy up near the White House, who potentially protected her. Okay, that was the criminal referral was made in January of 2023 and was denied by the then very liberal DOJ hierarchy in Washington. Okay, so the DOJ OIG, as they're moving to interview Rollins in November of 2022 and December of 2022, she knows she's on her way out. Okay, they got her. Levy then really starts running the office. We know this because he's the one who takes over when Rollins formally resigns in May of 2023, but she was already on her way out, starting as early as September. They caught her. They took her out right away. Rightfully so with the DOJ OIG because she was weaponizing the office. But then the issue is, so Rollins, when she became Suffolk County District Attorney, had David Yannetti on her transition team. And Alan Jackson in August of 2022, as we talked about Jessica Leslie, I think started to get leaks from that federal grand jury. But you might be saying to yourself, wait a minute, there was no federal investigation into the death of John O'Keefe in 2022. That didn't really start up until in August of 2022. That didn't really start up till November of 2022. It didn't really heat up until the summer of 2023, and it didn't really close until February of 2024. So what could Jessica Leslie have leaked about potentially to Alan Jackson in August of 2022 as he was beginning to map out his defense strategy for the Karen Reed case? Well, I'll tell you, folks, and you got to remember this because this is the key to it all. I think that Sandra Birchmore, who was a young woman in Canton, Massachusetts, who was murdered on February 1st, 2021, according to allegations by the federal government, by Matthew Farwell, a former Stoughton police officer, okay, at 9:23 p.m. or so. That murder, okay, was touched on a ring of cops, okay, who went from Stoughton, Yuri Buchanan and John Fanning in particular, to the Massachusetts State Police Unit, detailed to the Norfolk County District Attorney's Office, the same unit that investigated Karen Reed for John O'Keefe's death. Now, this is where this really starts to get a little spooky. I have reason to believe that Ken Berkowitz, the former chief of the Canton Police Department, reported to the FBI sometime in 2022, probably before May of 2022, that the Stoughton Police and the Massachusetts State Police Unit detailed to the Norfolk DA covered up Sandra Birchmore's murder. Now, the reason I think this is that the Canton Police Department on February 4th, 2021, they were the ones who initially processed the crime scene at Sandra's apartment where she was found murdered. They got evidence, the Canton Police, they're good people. I believe they're really good people. They got evidence right away that Matthew Farwell was on video at 9:23 p.m. on February 1st, 2021, murdering Sandra Birchmore. Like he went into her unit and then he went out. They got her. Then they went to the maintenance worker, and the maintenance worker told the Canton Police that was the same man on video that had moved Sandra into her apartment, Matthew Farwell. Then the Canton Police went to Sandra's school where she worked as a teacher's aide, okay? And they got interviews with her coworkers who provided them evidence that Farwell was saying to people that if Sandra refused to if Sandra wouldn't get rid of the baby, the unborn baby she had, if she went through with carrying the baby to term, she wouldn't get rid of, in his words, the baby, then Farwell would, quote, take care of the problem himself, okay? Now, Farwell was under the impression that Sandra Birchmore was pregnant with his unborn child. We've come to find out in recent months, according to reports, that was not true. The DNA testing has confirmed Farwell was not the father of the child. Now, Why does this tie in? Well, Sandra was being abused since she was a child, something the Canton police also found out on February 4th, 2021, and included in their report, according to an audit of the Canton Police Department done in the April of 2025 and presented in public, or concluded in April 2025 and presented in public around then, starting on page 99. Now, if you go to that Canton Police Department audit report, you will find that Sandra Birchmore, the Canton police also knew that Sandra Birchmore was being abused as a child by Matthew Farwell. Now, the Canton police, took all of this information, okay, and handed it over to the Massachusetts State Police. Now, the person who wrote the report for the Massachusetts State Police exonerating Matthew Farwell was John Fanning, who used to work in Stoughton as a cop. The unit commander at that time was Brian Tully of the state police unit. Remember that name. Now, Uri Buchanan also used to work in Stoughton, and I have sources who indicate that Uri and John Fanning used to go around to high school parties when they were perhaps older than in high school. Okay. And we also have to remember that Matthew Farwell is linked to Billy Farwell, William Farwell, and Robert Devine, and they're both linked to Sandra Birchmore. This is very clear evidence that there was a ring of cops, at least Robert Devine, William Farwell, and Matthew Farwell, abusing children in Stoughton. Perhaps it may have also included some other people on that list, and that breaks my heart. Okay? But people shouldn't do this, especially in positions of public trust. And it's possible, it's more than possible, that Sandra Birchmore was being abused. We cannot frame this as she was sleeping with. She was being abused by these people in positions of trust. She was hunted. She was found by these police officers in the cadet program when she was an underage child, like 13 years old. And there was a ring of cops, clearly, who were in Sandra's life. And you have to wonder, and it's pretty clear, were there other girls too? Were they abusing other girls? Was Sandra not the only one? Was Sandra not only being abused by more than one cop? Was there a ring of cops abusing a ring of girls? Was this the Jeffrey Epstein on a small scale? Matthew Farwell, was he the Jeffrey Epstein of Canton and Stoughton, Massachusetts? So you have to imagine that if the DOJ and the FBI got a report from the chief of the Canton police at the time, Kenny Berkowitz, that his officers turned this all over, and somehow the state police, who had the unit tied to the Norfolk DA, who had ties to Stoughton, two of them at least, and Farwell, and this ring of cops, exonerated Farwell. You don't think that might have led the DOJ to start a probe? And you don't think maybe impaneling that public corruption grand jury reportedly in May of 2022 was because of that report, a very serious report from former Canton Police Chief Kenny Berkowitz? Well, folks, I'll tell you, it's more than likely. I think it's very, very, very likely. And in that regard, you have to understand that not only did we have the weaponization of the Department of Justice in Boston by these liberals, which is one component of this investigation, okay, we also had a unit of the state police run by Brian Tully that we will quickly come to find out was involved in more than just the cover-up of Sandra Birchmore's murder. So you have the DOJ in this position where Levy, after Rollins gets forced out of office, I think he's still, because Levy and Rollins and Dustin Chow, I think at least Rachel Rollins and Dustin Chow didn't like the Norfolk DA, Michael Morrissey. Two different reasons, pretextual. One, in 2015, Chow's wife got passed over for a promotion. What really happened was she was a superior court prosecutor who got assigned to district court. Her pay was going to be kept the same, but she didn't like it, so she left the office on bad terms. Chow at the time went around saying he was going to do anything in his power to burn down Michael Morrissey's reputation. Okay. Rachel Rollins, when she was Suffolk DA, had two positions that were very controversial among other even liberal Democratic DAs. First, Rollins didn't prosecute like a list of 25 low-level offenses. No one ever did that again. It was bad. It was not a good idea. It ruined the city of Boston, in my opinion. But it caused other DAs to comment against Rollins in public, and then she lashed out at them, including Michael Morrissey. That was about 2019, 2020. Now, similarly, Rachel Rollins had a position that she took that she would not seek life terms in prison for youth murder offenders under 25 due to their fact that their brains weren't fully developmentally ready. Okay. Now, Rachel Rollins Ended up being vindicated on the latter point by the SJC in 2024, and that's now the standard. But you got attacked. The other DAs, including Michael Morrissey, and four of them filed an amicus brief in Rollins' case when she tried to take that position because they did not want that position. And so, setting aside the merits of it, Rollins did not like Michael Morrissey. So in November of 2022, as Rollins is kind of going out of office, and remember, Dustin Chow's not. Dustin Chow took Rollins out. Josh Levy has a meeting in his office in November of 2022 with Karen Reed, Alan Jackson, David Yannetti, okay, in his office. I think Josh Levy already knows about the Sandra Birchmore cover-up at that point, and now he's got someone else coming into his office. Now, I don't think Levy, in my opinion, ever believed, or Dustin Chow ever believed that there was a cover-up of John O'Keefe's murder. I think what Levy and Chow did, they're very smart. This is the highest levels of power in the federal judicial system. I believe what they did, Levy and Chow, was they said to Karen, Alan Jackson, and David Yannetti, we want to investigate the state police for Sandra Birchmore. You cannot tell anyone about this. But we don't want them to know either. We are going to run a grand jury into John O'Keefe's death that won't really be into John O'Keefe's death. It's going to be a backhand or a backdoor way of investigating Brian Tully's unit. You are to just go along with this, and in return, we'll let you in public have all this fodder because we want to pressure them a little bit. We want to do what's called a limited hangout, where you bump them a little bit. They'll release a little information that they're under investigation. They know they didn't cover up John's death. They're going to be so focused on that, it's going to cause chaos in their life. Then you can backdoor the investigation of Birchmore. I think Karen, Alan, David were in on that from the beginning. I think it was an operation. Okay. Then in the spring of 2023, I think what happened was around April or May, Aidan Kearney and Karen Reed got linked up via a woman named Natalie. Okay. And Aidan Kearney, it was rather through Jen Altman and Natalie, but Aidan Kearney and Karen Reed then started communicating. I don't think Aidan Kearney, actually Aidan Kearney was brought in on this. I think the reason Aidan Kearney was facing something in his life in April of 2023, Natalie Haskins, some woman out of Rhode Island, had accused him of wiretapping, and he had used a Rhode Island phone number to call her, but he was in Massachusetts. Apparently he thought that would get him around the Massachusetts wiretapping statute. I don't really know. The point is, he tells Karen about it. Karen tells him to call Alan Jackson. Alan, David Yannetti, and Turbo Boy start talking directly around April 20th to May 3rd of 2023. In those conversations, Alan Jackson is, according to my sources, helping Aidan Kearney because Aidan Kearney wants his wiretapping charge to go away. Now, for reasons unknown, a few weeks later in May of 2023, a field agent from the FBI in Worcester, Samuel Weiner, that is his real name, starts reaching out to people in the orbit of that specific federal criminal investigation of Aidan Kearney, the wiretapping charge with Victoria Haskin, and it goes away. Okay?
Just to weigh in here, I'm not exactly sure that actually happened in hindsight. It has something to do with Kate Peter, but I'm not sure it actually happened. Someone should ask Kevin Linehan about that specifically.
Then over the summer of 2023, Aidan Kearney runs a bunch of blogs, okay, unlike anything I've ever seen before or since, on his page, about the federal grand jury into the John O'Keefe and Karen Reed case. Now, if you look into Buffalo Jim and Steve Miller, one journalist and a wrestling school owner in Las Vegas in the early 2000s, who Buffalo Jim had a wrestling school next to an establishment called the Crazy Horse 2, which was a front for the mob. And Steve Miller was a journalist who was Buffalo Jim's friend. Steve Miller was given an assignment by the FBI in protected status to write blogs about the Crazy Horse 2 for the purpose of attracting tips for the FBI. And Steve Miller talks about this openly. The FBI had Steve Miller writing blogs that would allow him to, they would SEO, search engine optimization, the blog, so his name would pop up first if you search Crazy Horse 2. They edited the content of his blogs. They gave him scoops. And then they also planted his email address in the articles because they said if you get any tips about these people, not just the Crazy Horse 2, the people running this, refer them to us, tell them to expect a call from the FBI, and we will call them. Okay? I think for 3 months, the summer of 2023, Aidan Kearney was allowed to do that by the FBI, okay, and the DOJ in Boston. Not because of the John O'Keefe and Karen Reed case, but to get attention on the state police unit so the DOJ could drive tips. Is it any coincidence then that in August of 2023, the real probe of Matthew Farwell starts up, according to remarks from former U.S. Attorney Josh Levy when the Farwell indictment was announced in August of 2024. Then Aidan Kearney becomes kind of useless in all this, right? You know, he was only really useful for driving enough tips to get Tully's unit for covering up the Birchmore probe. But in the fall of 2023, something else happens that also intertwines all of this, which is on November 28th, 2023, Aidan Kearney puts in writing to Karen Reed, not just to Karen Reed, but Aidan Kearney puts in writing to his then romantic partner, Lindsay Gattani, just a brilliant human being who's going to come to be central to this story, as you can see on the side there in a second. But take a look. That is messages from Aidan Kearney to Lindsay Gattani on November 28, 2023, saying that Josh Levy, a full year after Karen and Alan Jackson and David first walked into Levy's office, and when Rachel Rollins is already gone as U.S. Attorney, Josh Levy was revealing ex parte information about protected grand jury investigations to Karen Reed. Now, this becomes a big deal because Aidan becomes a liability for Karen, okay? Now, on December 23rd, 2023, Aidan Kearney comes to find out that there was an ongoing he knew there was an ongoing criminal investigation. He had been charged with 16 felonies in the fall of 2023 related to Chris Albert and Colin Albert and other witnesses in the Reed trial that had been tormented by Mr. Kearney and Miss Reed, allegedly. Now, on December 20th, 2023, a grand jury binds over those 16 charges to Norfolk Superior Court, from Stoughton District Court to Norfolk Superior Court. But then Lindsay Gattani gets a subpoena from Brian Tully, a state police trooper investigating Kearney, for another grand jury. Okay? Now, Kearney must realize right away that the only thing that can mean is that Tully is investigating Karen and Aidan and potentially the U.S. Attorney's Office for what they were doing related to the case. But then you realize there's another piece of this puzzle. Brian Tully was asking questions in his official capacity as a state police officer in early December of 2023 about what the federal probe was about at that point in time. Now, we know in hindsight, okay, that the federal probe into John O'Keefe's death closes permanently in February of 2024, okay? Just a few months after Brian Tully's asking these questions, but the probe of Farwell continues. So why is Brian Tully only really interested in the investigation of Aidan Kearney to find out more about the federal probe of Sandra Birchmore's death? Well, as I was mentioning, on December 21st, 2021, Aidan Kearney goes over to Lindsay Gattani's apartment. And by the way, let me just show you these pictures from the search warrant of Karen Reed's phone. Now, it's paragraph 77 through 81, okay, and we're going to zoom in. This is mentioning Jane. Jane is Lindsay Gattani, okay. Karen Reed's phone ends up seized in January of 2024 because of information Lindsay gives to Brian Tully about Aidan's contacts with Karen. Now, one thing we want to look at as we zoom in here is this paragraph. Jane stated she was told by Kearney that Reed's attorneys and Reed were working with the U.S. Attorney's Office, specifically acting U.S. Attorney for the District of Massachusetts, Josh Levy. Kearney would talk a lot about the federal grand jury and Levy with Gattani. Gattani stated Karen Reed was interviewed by federal law enforcement. Gattani also shared other information. Gattani also shared other comments Kearney learned from Reed that are corroborated by other information known to this affiant, which is Brian Tully. That statement was that Brian Tully and the Norfolk DA were the targets of a federal probe. Brian Tully, when he asked that question to Lindsay Gattani, to be very clear, knew full well about Exhibit O. Okay, he had already obtained these text messages, and he knew Aidan Kearney was revealing that Karen Reed was getting protected grand jury information from Josh Levy, which gave Tully a motive to think maybe Lindsay knew something about the Birchmore probe, in my opinion. Now, that ties that together, but I want to go back to this second paragraph here, paragraph 82. You can see that Lindsay Gattani, was served with a summons to appear before the grand jury on December 22nd, 2023. Now, that's when she was served with the summons. Now, you got to think as Aidan Kearney, if there's another grand jury, you just got bound over, right, on 16 felonies. Why is there another grand jury? Oh, it must be into Karen Reed and Aidan Kearney. Kearney, against his better judgment, and he has said this multiple times, Karen Reed told him not to go to Lindsay's apartment that night. and along as did his lawyers. Okay, now the week before, Lindsay and Aiden had kind of been talking about whether he would come over. They were broken up by that point, but she asked him to come over. Then he didn't want to come over. But on this day, after he finds out he gets the subpoena, he starts texting Lindsay trying to come over to her apartment. Eventually, she yields. And he comes over on the night of December 23rd, 2023. Now, listen to what the affidavit here alleges. During this meeting, Kearney told Jane to tell the grand jury she did not remember anything, delete evidence from her phone, and told her he would hire an attorney if she cooperated with him. Now, the allegations are that Kearney pushed Catani on a couch because Kearney used Lindsay's notepad to take notes about conversations Lindsay had had with a woman named Kate Peter, who was a private investigator working for a man named Marty Kraft. Okay, Marty Kraft was a private investigator in the orbit of Brian Tully. We're going to get to this in a second because this ties it all in as well. Now, allegedly, Kearney was also witness intimidated Catani and was charged with that as well. Now, further charges would eventually come out from that night that Kearney put his phone in his pocket and illegally recorded Catani. There's evidence in the court record of the unedited recording that is out there, and then Kearney submitted an edited recording to make it look like Catani consented to the recording, which itself is a whole bundle, sort of Pandora's box of issues as to Kearney's lawyers submitting potentially manipulated evidence, etc. But Kearney gets arraigned on December 26th, and he gets his bond revoked on the existing felony charges. Okay, and that bond revocation leaves him in jail for 60 days, where he has admitted he was offered the opportunity to flip on Karen Reed, because in reality the investigation of Aidan Kearney wasn't just for Brian Tully to get intel on the federal probe, which I think he found out quickly was about the cover-up of Sandra Birchmore's murder, but also to get Aidan Kearney to flip on Karen Reed as sort of this double sort of pressure tactic on Karen, because she was facing the murder trial, the first murder trial at the time for John's death. Now in March of 2024, the Norfolk DA, the special prosecutor or whatever, did try to indict Karen Reed and Aidan Kearney. That came back with a no true bill, but it goes to my point. There was a dual point in investigating Aidan Kearney. Now, this gets even more interesting, okay? Because something wild happens, okay, in March of 2024. Karen Reed starts saying that Aidan Kearney is a risk. She's been careful to lay low, and Aidan blew it all up. And there's Karen Reed saying Brian Tully took Karen's two phones. One of them had tons of info on it, and that's all from, quote, the Lindsay Catani mess. And then Karen says, I can't expose myself to that anymore. This was a leaked text message. Now, as you can see here, so you had simultaneous things going on. The weaponization of the U.S. Attorney's Office in Boston in multiple different areas.
All right, session. Sorry for the rapid switch. I told you I didn't want to talk a lot this morning. Thank you all for your indulgence and for watching. Let's go right over to the Walshe case. Judge is in session. All right, let's see what Judge has to say. It literally started early, not on time. How rare is this? We are early, ladies and gentlemen, for today's coverage of the Brian Walshe case. My name is Towel. Thank you very much for being with me. And thank you for watching along. Let's see what Judge has got to say. All right, early morning. We're not only on time, extra on time. Oh, Judge was there wicked early. Oh, my goodness. We started at 8:50. Ladies and gentlemen, here we go. Let me unmute this for you. Let me get the volume. Go.
You are. In the matter of the Commonwealth versus Brian Walshe, Norfolk Indictment 2023-0091, continuation of jury trial. Counsel is present in court. Counsel starting with the Commonwealth. Kindly identify yourselves for the court and the record.
Good morning, Your Honor. Greg Connor for the Commonwealth.
Good morning.
Good morning, Your Honor. Ann Yass for the Commonwealth.
Good morning, Your Honor. Tracy Cusick for the Commonwealth.
Good morning, Your Honor. Good morning, everyone. Kelly Porges on behalf of Mr. Walshe.
Good morning, Your Honor. Larry Tippett.
Good morning. We need the defendant.
Wanted to alert the court with regard to the expected testimony of Mr. Walsh today. As an initial matter, does the defense still intend to call Mr. Walsh today?
We do not.
You do not? All right. Does that moot? All right. At the close of yesterday's day, the defense raised with me what I have listed as 5 separate issues that it wanted to alert the court with regard to the expected testimony of Mr. Walsh today. As an initial matter, does the defense still intend to call Mr. Walsh today?
We do not.
You do not? All right. Does that moot every issue that I researched last night?
I apologize, Judge.
No, I just want to make sure that the 5 issues that you raised and the issue with regard to the plea are no longer on the table. All right. I will conduct a colloquy with the defendant then now, and my intention is the defense intend to call any other witnesses.
We are not.
All right, then we'll close tomorrow. We'll do the charge conference immediately after the rest of the day. Let me just put in the record, so the record is complete. The Commonwealth previously, and I ruled on this at the side of the bench previously, the Commonwealth previously asked this court to exclude the defendant's plea of guilty. And I guess the only way that would come in at this point is if he were testifying. But I just want to put in, to the extent that I previously disallowed the defendant to go there with any other witness, and I frankly don't recall if I have previously, I want to put in the reason why I excluded that testimony now. The Commonwealth did file a motion to eliminate to exclude evidence that the defendant pled guilty to misleading the police into Anna Walsh's disappearance and improper disposal of her body. After consideration, I allowed and still am allowing the Commonwealth's motion for 2 reasons. First, the defendant has failed to show how such evidence is relevant to the remaining charge of murder. And I specifically acknowledge that I read this morning the defense's motion to admit the evidence of his guilty plea, which has been docketed as 216. That was filed on December 11th, 2025, this morning, I believe. I have read it, but it doesn't do anything more than to set forth the elements of the crimes of murder. Based on defense counsel's opening statement, it appeared that the defendant was going to testify in this trial. And at that time, he could have made reference to his plea if I so allowed him to. But whether or not he is charged or pled guilty to such actions relating to his prior plea of guilty before this court is irrelevant to whether he murdered his wife. Second, the inclusion of the evidence of the defendant's guilty plea on the 2 charges would risk the introduction of extraneous factors as part of the jury's consideration on the murder charge. As explained by the SJC in Commonwealth versus A Juvenile, 396 Mass 108, 112, it's well established that a jury's verdict must be based solely on the evidence in the case without regard to the possible consequences of their decision. And there's a specific instruction in my draft jury instructions that addresses this. Continuing with this case, the role of the jury is to make findings of fact and determine the guilt or innocence of the accused without regard to probable punishment. To inform jurors of a sentencing consequence of their verdicts is to invite a results-oriented verdict and possible deviation from the basic issues of the defendant's guilt or innocence. I also cite to Commonwealth versus Sanchez, 70 Mass Appellate Court, 699-701, 2007. While the defendant here is not seeking to enter evidence of the possible consequences of a guilty verdict on the murder charge, the rationale behind the holding in A Juvenile applies with equal force. If the defense was permitted to tell the jury that he pled guilty to the 2 lesser charges, there is a risk, substantial risk, that the jurors will consider the defendant's impending punishment on those charges when determining his guilt on the remaining murder charge. Indeed, the defendant has not offered any other rationale for the entrance of such evidence. And as was stated in Commonwealth versus Ferreira, 373 Mass 116 124 1977 case, the jury's function is not to weigh possible verdicts with an eye towards dispensing mercy in certain cases or imposing heavier penalties in others. Rather, the jury's function is solely one of fact-finding with respect to the legal standards regarding innocence or guilt. Accordingly, the defendant is not permitted and has not been permitted to give evidence before the jury of his prior guilty pleas in this matter. And Madam Clerk alerted me to also file this morning 321 pause. The Commonwealth supplemental motion to eliminate to exclude evidence of the November 2025 guilty plea, which I will concede I did not read because I just got it when I stepped up the bench, but I'm not sure it makes a difference in light
I
of
think
my
it's
ruling.
moot at this time, Your Honor. Thank you.
All right, is 216 something you filed earlier? Why does it have this number?
No, that's my error, Judge. That's my error. I corrected it on the original. It should be 318. It's my poor vision.
Okay. So just so the record's clear, when I said a moment ago I did review what the defendant filed this morning. It's just not 216, it's 318. All right. On the docket. All right, I see that I have two other pleadings up here, which I will address in brief. One I was going to address anyway. It's in substance, maybe not exactly as it's presented. Those are items number 319 and 320. Let me talk about 319. I haven't read it either. It's a motion to prevent the Commonwealth from basically, I believe, an Attorney Tipton, you can, or Porges, you can illuminate me greater, but you don't want them saying he promised you something in the opening statement that he didn't deliver.
That's right, and after consulting with the Commonwealth this morning, they had no intention, they told us they had no intention of doing that.
So I have already pulled out some case law on this and where the boundaries are. I was going to give it to you in the charge conference anyway to make sure that you were aware where the boundaries are. SJC has spoken on this issue of what's permissible and what isn't. The Commonwealth is allowed to get into it a little bit. I will alert you to those cases, and that's where I intend to draw the line as to what's permissible. I probably have them on my bench right now, but I couldn't tell you where they are. But when we get to the charge conference, I'll give those to you so you both have the benefit of my research on that issue. The other motion, 320, is I expect the defense will renew after I bring in the jury, ask you if you're going to present any evidence, and you will rest. And I'll hear you at the side of the bench with regard to that. So now, I do want to conduct the colloquy with the defendant at this point.
Would you like me sworn, Your Honor?
Hold on a second, because I'm not sure I have my colloquy with me on the bench, despite the fact that I have quite a few binders here. I think the one I need is in my office, so stay tuned. Nobody move. If you do not testify, I'll need to...
The cause now in hearing truth, and that you shall give all true answers to all questions as put to you by the court in the cause now in hearing, so help you God.
I do.
Thank you.
Excuse me.
You can be seated. I just didn't, was wondering if you were asking me if I wanted him over on the witness stand. I do not. Mr. Walsh, one important decision that all defendants in every criminal trial need to make is whether or not they're going to testify in a particular case. You have an absolute right to testify at this trial. and your right whether or not to testify is solely your decision. This means that you are not required to take your attorney's advice. I'm sure that your attorneys, Attorney Tipton and Attorney Porges, have told you that if you do testify, the Commonwealth has the right to cross-examine you. That is, the right to ask you questions. If you do not testify, and you and your attorney request me to do so, during my final instructions to the jury in the law on this case tomorrow, I will tell the jury that you, like all persons charged with a crime, have the right not to testify, and that the jurors may not speculate about your decision not to testify. First, I'm going to ask you some preliminary questions. Sir, in the last 24 hours, have you had any alcohol or alcoholic beverages?
No, I have not.
In the last 24 hours, have you taken any prescription medicines?
I have not.
In the last 24 hours, have you consumed any legal or illegal substances?
I have not.
Is your mind clear here today?
It is.
Tell me in your own words, what are we discussing?
Whether I'll testify or not in my trial.
Right? Have you discussed with your attorneys the decision about whether or not to testify in this trial?
I have.
And have you had enough time to discuss your decision with your attorneys?
Yes, I have.
Have your attorneys discussed with you the pros and cons of testifying and not testifying?
Yes, they have.
And do you understand what your attorneys explained to you about your right to testify?
Yes.
Has anyone threatened you or promised you anything to get you to give up your right to testify on your own behalf?
No.
Have you made a decision about whether you wish to testify at this trial?
Yes, I have.
And what is your decision?
I will not testify.
Does any party wish me to ask any further questions before I make my findings?
No, Your Honor.
No, Your Honor.
I find that the defendant, Brian Walsh, freely, voluntarily, knowingly, and intelligently has waived his right to testify at this criminal trial, and that he's done so with the knowledge of its consequences. I accept his decision. You can bring the jury in.
Jurors entering. Hear ye, hear ye, hear ye. All persons having anything to do with the Honorable Diane Fernandez, Justice of the Norfolk Superior Court, for your attention, you may be heard. Those here in the Commonwealth of Massachusetts in this honorable court, please be seated. Please turn off your cell phones.
Morning, jurors. Morning. Jurors, we'll start today with the 4 questions. Jurors, were you able to comply with my order that you not speak to anyone about this case? Yes. Were you able to comply with my order that you not do any research about the case? Yes. Able to comply with my order that you not go on any social media or access any news media? Yes. And you still all have open minds? Yes. With those 4 questions all answered in the affirmative, we're ready to begin today's work. Does the defense wish to call any witnesses in this case?
We do not, Judge.
Defense rests?
Defense rests.
All right. I'll see counsel at the side of the bench. Now been presented. The trial, as I sort of see it, as different chapters of the book. And another chapter of the book is just closed. And that is that all the evidence in the case has now been presented to you. I remind you at this time, jurors, and I reminded you of this at the close of yesterday, the defense has no burden in this case and has no burden to produce any evidence at all. And that's because, as you probably are all very well aware at this point, the burden lies on the Commonwealth to prove its case beyond a reasonable doubt, and it never shifts from the Commonwealth. All right? So, what happens next? What happens next is the next chapter we're going to go to as we move towards your deliberations is that really 2 things that happens interspersed. I'll explain. The 2 things that need left to be done is I need to give you my jury charge, my legal instructions to you. And then you need to hear the closing arguments of counsel. Right? So the way that happens is I will give you, when we next reconvene, which is going to be tomorrow morning, and I'll tell you why in a minute. I will give you instructions on the law that's specific to the charge that's primed here, the charge that, the crime that is charged here, murder. Then the lawyers will do their closing arguments, And then I come back and give you additional instructions. I call them more generalized instructions. So those two parts of the trial happen interspersed. A little instruction, argument, more instruction. That's going to happen tomorrow morning. And I try to be as transparent as I can in my cases. The reason for that is I don't just pull these instructions out of the ether, as you might imagine. There are instructions and guide instructions. And there, I get the input from the lawyers about what they're seeking. And that hasn't happened yet because we've moved at a pretty efficient pace. So I need to do that work with the lawyers today, and I will. And that's what we'll be doing today. What you'll be doing today is getting some rest and some sleep so you can be all rested for tomorrow morning. And I remind you, jurors, I'm going to send you off for the day. I remind you what I just checked in with you. I'm counting on you to be obedient to those rules right to the end, right? Jurors, don't speak to anyone about this case. Don't do any research about this case. Stay off of any social media, news media, and continue to have open minds as we finish these last chapters of this trial. Have a great day.
All rise in court, please. Jurors, close your notebooks and follow me.
A couple of housekeeping things. Yesterday at the side of the bench, we had a discussion about, during Mr. Mootlu's testimony, in which I asked that a certain document be marked as, I think it was M or N for identification. Madam Clerk, which was it?
N, I believe. The hammer?
No.
Oh, the other one was N, Your Honor.
N for identification. Has that been done? This is a question to the defense. On cross,
Page 53 of that transcript.
I want that
Your
whole
Honor.
document to be marked for identification. Has that been done?
Okay, I'll get that to the court this morning.
And just so the record is clear, as I understand it, that is a multi-page document of which Mr. Mootlu was asked to review a single page of, but it comprises a record of his police interview. Is that correct?
That's correct, Your Honor.
Are the parties ready to do the charge conference, recognizing I haven't given you a draft yet because of the way things played out? I did stay last night and draft the jury instructions with the benefit of two things so far that I'd considered, or three things. One was what I had marked for identification the other day, which is the first 2 pages of the model homicide instructions. I'd asked each of the parties to mark up, so to speak, those 2 pages of the SJC's model instructions. And so you did at my request, and I have had the bit of that information. I also received yesterday, Madam Clerk, if you could get me while I'm talking, the defendant's request for jury instructions concerning consciousness of guilt, emotional evidence, and bad acts. I had that. I considered that as I was drafting the draft instructions yesterday, and I'll talk to you about that. What I didn't do, and I sort of made a mental, because I ran out of steam, frankly, yesterday. I know that very early in the case, before the case started, that the Commonwealth had filed pleadings with regard to jury instructions, and I made a mental note to go back to those this morning, but I didn't, frankly, have a chance to do that. Since the day is unfolding a little differently than I expected at the end of yesterday. So I tell that to you so that you know that if there's something that you wrote in there that's still relevant now, it might still be, that I don't have that fresh in my mind anyway. All right?
Yes, Your Honor.
So, said more bluntly, if there's something in that I don't go over now that you want to persist with, just
Your Honor, there is actually, with respect to the consciousness of guilt instruction potentially. I don't know if it would make sense to take a brief break so that I could collect my notes on that topic.
All right. I will take a brief break before we, and what I'm going to intend is this. The draft instructions as I have them right now includes what I tried to do is, when I was scratching my head, saying to myself, why do they want this instruction in? I put it in anyway, and then I put it in italics, so that should be your clue that I'm questioning either why this is in here. For instance, the object of the killing must be a human being that the defense has asked for. Question mark, why are they asking for that? So the italics either means you asked for it, I'm questioning why you want it, be prepared to answer that question. Or in the instance of the instruction, I have instructions drafted right now for, and this is in part 2 of the instructions, impeachment by prior conviction, impeachment by prior inconsistent statement, and impeachment by prior bad act. And in particular, in the prior bad act, I took a swing at attempting to fairly describe the evidence that's been presented to the jury with regard to the defendant's bad acts. I tried to do it neutrally, but there may be other words that you like better. So those are in italics, even though the whole instruction isn't in italics. Who's closing for the defense?
I am.
And who's closing for the Commonwealth?
I am.
The address of the Refuse Center, 300 Forest Street, Peabody.
Yes, Your Honor.
The defense now seeking the instruction with regard to the defendant's right not to testify.
Yes, Your Honor.
I'll add it. Commonwealth seeking a mode of instruction.
Yes, Your Honor.
Again, look for the highlighted language in the consciousness of guilt instruction and see if there's some other language you would prefer that adequately captures trial evidence. All right, let me propose this. I'm going to make those edits and additions based on the information that you just provided. And then I'm going to have Madam Clerk shoot you a copy of the draft instructions. And I know you probably want to be spending your afternoons working on the closing arguments. So I think it would be reasonable, given what I think is relative to other cases, the instructions are pretty straightforward. By that I mean there also was a lot of agreement with regard to your submissions as to what you wanted in these instructions. And so it's sort of the second half of the instructions that the special instructions. I will go back and look at what the Commonwealth submitted early on in the case. Should I presume that everything you wrote then you're still pursuing today? ADA Cusick.
Yes, Your Honor. The Commonwealth was seeking a direct and circumstantial evidence instruction, a consciousness of guilt from the MCLE instructions, and an expert witness instruction.
All of those instructions are presently in the charge, in the draft charge. So thank you, because that prevents me from trying to find out where it is.
Yes, Your Honor. It's under general instructions at the back of the pleading, the preliminary request for jury instructions, and we just provided the name of the instruction from MCLE.
All right. I don't know if I probably grabbed it. I'm not a huge consumer of the MCLE instructions. I usually use other sources, but you can see what I came up with, and you can tell me whether you disagree with it. But we talked about the consciousness of guilt instruction, and it does not, I've never given, as far as I recall, a version that put my thumb on the weight of the evidence. So it presently either says you've heard evidence suggesting, what page is it on? Hold on, it's on page 27. Yeah, it's some evidence suggesting. I've never, I don't think to my knowledge or recollection, I've never used anything that was stronger than that. Yes, counsel.
I just wanted to say, I hope you haven't spent any time on this. The object of the killing must be a human being. You mentioned that this morning.
It was just not crossed out of your version, I don't believe.
And it should have been.
It's an issue.
I know. I said
So,
it should have been.
so just take it, can I take it out?
Yes, sir.
Thank you. I didn't spend any time on that. There are other things I spent, like about 5 issues that were of interest to me. But I learned quite a bit researching those, so didn't have a chance to look at those issues recently, and it's always good to remind yourself of them. I'll take that object of the killing out. All right, so let me get these to you, and I'm going to suggest, what's it, 9:30? Is 11?
You mentioned that.
It's not an issue.
I know. I said
So,
it should have been.
so just take it, can I take it out?
Yes, sir.
Thank you. I didn't spend any time on that. There are other things I spent, like about 5 issues that are of interest to me. But I learned quite a bit researching those, so didn't have a chance to look at those issues recently, and it's always good to remind yourself of them. I'll take that object of the killing out. All right, so let me get these to you, and I'm going to suggest, what's it, 9:30? Does 11 o'clock sound reasonable?
Yes, Your Honor.
Gives you an hour and a half to stew on. I'm going to get them to you in about 10 minutes. I don't have much to change here from what I drafted. 10:30?
Yes, sir.
10:30 it is.
Across the cases the court referenced about the extent the Commonwealth
I'll
can
get you
mention
those.
opening.
I will get you those. There are parameters. I looked at it about 2 or 3 days ago, maybe over the weekend, something like that. Again, something I hadn't looked at in a while, and it's always good to look at the law. But I'll get it to you.
Thank you, Your Honor.
All rise.
All right. Hello. I'm here. We got to get ready for the CCC hearing. So, that judge is wonderful. Judge had to do extensive research overnight on 5 issues in the case. Brian Walshe took the stand in his own defense. Even though BW didn't do so, Judge appreciated the opportunity to refresh on precedent. That's why people love the judge in that case. That's why people love that judge. All right, my name is Grant Smith Ellis, and we're getting ready for the 10 a.m. CCC hearing because we're now on recess. In the Walshe hearing, they're doing the charge conference. Walshe will be presenting no evidence of any kind, and he is not taking the stand in his own defense. Who's surprised by that? Absolutely no one. Now, you might be saying to yourself, do we now have a big moment because the CCC is about to vote at 10 a.m. on social consumption? Yes. Yes, indeed, that's going to happen. But the Walshe case, except for closings tomorrow, is done. He will be putting on no defense. He will not be taking the stand. It's over. It has ended. The Walshe case will end tomorrow with closings. I don't foresee the jury being out for very long. It's going to be Friday. This is going to end very quickly. Now, we are not just going to stare at a clock, ladies and gentlemen. Sorry, I started playing the replay of the last few minutes. We are not going to stare at a clock. We're going to do a few different things. We're going to get rid of this. All right, there we go. We're going to get rid of this. And we're going to prepare for the CCC meeting. Now, you might be saying to yourself, sir, I don't necessarily watch regulatory hearings. Well, that's okay. All right, I'm going to teach you all about it. We're going to be efficient little towels, and then we'll go back to the Walshe hearing eventually later in the day. So for now, we're going to learn about regulatory affairs. Hello, Irene. You came in just at the right time. Shannon O'Brien has actually been one of the most effective change agents at the CCC. If you've never read my articles about the CCC, please check out patreon.com/Grant Smith Ellis. They're all available for free. And let me just tell you, there is some good stuff. So let's take a look at this video from CBS News. It just went up overnight. It's actually about the work that Shannon O'Brien and her colleague, Commissioner Roy, who's a wonderful human, have been doing. So let's watch this news presentation from CBS here. And the CCC hearing starts at 10. This went up overnight. It was actually on CBS National, but they aired it through the local channel. So let's watch this together.
On the fast track when Massachusetts legalized recreational marijuana. But critics argue the drug's safety didn't get enough attention.
There has been contamination in some products, and some customers say they're not getting what they paid for. WBZ's Louisa Mueller has been investigating the problems and gets answers from the head of the state's Cannabis Control Commission.
Money has flowed into Massachusetts state coffers ever since the legal cannabis industry kicked off in 2018.
It's more money than comes in from the alcohol industry.
Sales have grown every single year, garnering more than $1.5 billion annually, nearly $40 million just during Thanksgiving week, and more than $250 million in tax revenue for the state every single year.
What they're doing is they're ripping off the consumer.
But Matt Gutwill, president of the New England Narcotic Enforcement Officers Association, argues cannabis consumers aren't getting what they're paying for.
I'm using a NIR Labs device.
He used this tool to measure THC, the psychoactive compound that makes users high, in over 100 marijuana samples from multiple dispensaries over the past 2 years.
I take my system and I just lay the device up on top.
In a significant number of cases, Gutwill says the THC level in the test comes back lower than what's...
All right, I'm going to comment on this a little bit. So first of all, yes, THC potency inflation is an issue, and I think you're going to hear Commissioner Roy say, because I read the article about with the quotes, Commissioner Roy is going to say it's important, but it's a consumer protection violation. The big issue, and they're going to talk about this too, is total yeast and mold fraud. Now, the other thing is, I want to talk to this organization. I'll reach out to them. They're not this law enforcement organization. They're doing good things, but you got to control when you're doing calibration testing. Or redundancy testing or secret shopper testing. So you can just go to ProVerde and they do free full panels. Just go to them or contract with them. It doesn't make sense to use this handheld device. You're not providing. It's valid scientifically to the extent that a field drug test is valid scientifically. It gives you initial probable cause to affirm your suspicion. And it might lead you to say yes, narcotic, no, not narcotic, or whatever. But you are or what type. But you cannot get a confirmatory reading from a handheld device in an uncontrolled environment. If you want to do this and make the point, just do it with ProVerde. Okay, that part can be improved. The other thing is, again, I want to really emphasize here, the manipulation of total THC is a consumer protection issue. It only has to do with the labeling and what the consumer thinks they're buying. The manipulation of total yeast and mold testing is a direct threat to public health and welfare and safety, and they are two distinct issues. They both involve testing labs manipulating results. The way the testing labs do this article I don't think really goes into it. You really have to understand PCR methodologies, plating, like as a traditional conventional methodology for testing for microbiological contamination, total yeast and mold, pesticides, etc. And then you have to understand microarray hybridization methodologies. Now, the reason why you have to understand this is trifold. It's not bifurcated, it's trifurcated. You have to understand what testing is. Okay, so what are you doing when you, what are you actually doing when you're testing for the presence of microbiological contamination? Okay, so let's take plating. That's the industry standard in the food industry. Why? Because now, I believe the period of time is 48 hours for food, but 60 to 72 hours for cannabis. You take a sample of the cannabis, you put it on a plate, it's normally a Petri film provided by someone like 3M, and you let it inoculate or whatever the term is. You let it grow, culture, over 72 hours for cannabis. Then, at the end of the culturing period, you test for the presence of microbiological contamination. That is the industry standard. I have talked to people, scientists, in every single different arena of this. Regulatory scientists, high-level scientists, industry scientists, non-affiliated scientists, research scientists. I've talked to so many scientists, I'm basically fluent in these methodologies, okay? And I'm not a scientist, I'm a towel. The point is, plating is hard to manipulate. It's not to say it can't be manipulated, but the manipulation of plating methodologies are very easy to control. It's just like how you put the sample in the bag before it goes on the plate, like how the client is sending the sample, batch selection processes for sample selection. You have to control. You can't let the cultivator pick like one bud that they cleaned off and then sent in or added like keef to. That's not good. You need a controlled sample selection process, especially if you're going to do batch testing, which is testing only a certain product out of every number of pounds. Now, going back to the methodologies, if we're talking about plating, it's very hard to manipulate. Now, if you go into PCR methodologies, some of these are really good, okay? It just is a matter of the actual testing applications of them. These are machines that are a little bit quicker in the readout, and they use more advanced genetic sort of detection for measuring levels of microbiological contamination. But what you have to understand about PCR methodologies is thus. They have inclusion and exclusion lists. So you're always going to have things they can test for and things they can't test for. Now, notwithstanding the argument on a contaminant by contaminant basis about whether some things are inert, some things are not inert, the point is you can't have things with an inclusion and exclusion list unless the regulators know about it, because otherwise your test could be producing false negatives. If you're testing for something that the total yeast and mold requirements mandate you list, but you're running a test that has an exclusion list that has a bunch of things, you're reporting passes, but really they're just not testing for certain contaminants. That's the issue with PCR. The other issue is you can run something and I want to speak broadly about this, but you run something called like the Grim Reefer. And what it does is it kills all live and dead DNA on the sample before you run it through the PCR test. And if you do a PCR test on a on a sample that has no living or dead DNA, it's going to pass every time for microbiological contamination because everything's dead on the sample. So that was an issue, but I think that's since been fixed. But that's really just controlling the testing methodology and the implementation thereof by the various labs. Now we got to talk about microarray hybridization methodologies. Now, this is very, very complicated because microarray hybridization methodologies basically are a more rapid form of PCR. I think they're like qPCR, or one of the methodologies is qPCR and the other is microarray hybridization PCR. The point is, it's kind of this black box process. Now, one of the main providers of this is called Pathogen DX. And if you look a little bit into the Nevada regulatory engagement between Pathogen DX and their regulatory body, there was a question of whether Pathogen DX was accredited. Now, all labs are accredited under ISO accreditation standards 701 or something, I believe. However, methodologies get accredited by something called the AOAC. Now, you go look into the AOAC and you find out it's a volunteer nonprofit organization. And you might be saying to yourself, oh my God, Towel, did you get so involved in this that you even had to learn about how the AOAC functions? Oh yes, you'd be surprised at how many people will just talk to Towel about things because I enjoy learning. Anyway, the point of that is that when this company got its AOAC accreditation, there was a few things with the AOAC accreditation that I found befuddling. One, the documentation changed over time. The initial documentation showed a fail rate that should not have resulted in an accreditation, according to what I understand. I'm not a scientist, I'm a towel. Then new documentation got uploaded indicating the accreditation was valid. However, we also have to think about what AOAC is. It's a network of volunteers, and then you got to understand a little bit about how microarray hybridization methodologies work. You buy or rent a machine from the parent company, which is often in another state, let's say Arizona. You rent the machine, okay, you take it to your lab in Massachusetts. You, in your lab, run the test on the sample. Then you send your results to Arizona. There's a black box interpretation process of the results, and then you get back a pass or fail from the company after a result of this black box process. Okay, first of all, that's a little weird. Second of all, it raises a lot of questions about like what exactly AOAC was doing to get it to do this accreditation. I know what they were doing because I talked to people. They went into a lab that was renting a machine from AOAC, and they got free lab time to do their confirmatory testing. All right, well, that's kind of rife with conflicts of interest. And if you're asking yourself, Grant, oh my God, did you even figure out who the investigator was on this AOAC case? Yes. All right. When I look into something, I just want to figure out what happened. Needless to say, notwithstanding me becoming an expert on plating, PCR, and microarray hybridization testing methodologies, you should hear me testify to the commission sometimes about this stuff. I want to play one of these videos. I just go up there and I'm like, listen, government, you lost Chevron deference because you are not good subject matter experts. You barely have Skidmore respect at this point by the courts. You are an independent Article 1 court, and if you want to preserve your integrity in the view of the other branches of government, the legislature and the courts in particular, as independent subject matter experts, then you must start to understand the implications of PCR testing, plating technology, and microarray hybridization methodologies. I sometimes just get up there. I had 3 minutes, and I'm just like, here's what you got to do. All right? Commissioner Roy often looks at me with like a look of wonder and glee. Chair O'Brien looks at me just kind of with a smirk. Commissioner Stebbins is oftentimes just frustrated and baffled that I exist, I think. He's a nice guy. I like him. But he's just kind of like, oh, goodness, Grant again. It's wonderful, ladies and gentlemen. The point is, I know a lot about this. Now, let me play the rest of this video, and then I'll go find you one of my speeches, and then we'll do the CCC hearing at 10. Can you see I like to engross myself in knowledge? I'm like the judge from the Walshe case. She learned about 5 things and was not even upset. She was like, it doesn't matter that I didn't have to learn about it. Didn't need to apply it. I learned it. Oh, yes, I love it, Judge. Somebody put that judge on the Supreme Court.
advertised on the product's label.
It's saying it's 12.8% and 0.1% CBD. But when we purchased this, it said that it was a 34.65% THC level.
He showed us over and over.
This is coming back at 16.8%. So if it was what they said, which was 28, we're way off. Anyway, but on the side of the pack, it's saying 34.19.
And contends it's a symptom of a bigger problem, a lack of oversight by the Cannabis Control Commission, or CCC.
No, okay, that's not right. Yeah, I mean it's right, but it's speaking very broadly about a nuanced issue. All right, let's keep listening.
The regulators, which oversee the industry.
They are doing nothing on the enforcement end.
Over the summer, the CCC suspended the license of Assured Laboratories, one of over a dozen labs responsible for testing cannabis products before they are sold at dispensaries. The CCC found that Assured failed to report evidence of yeast and mold in more than 7,000 of its lab samples, with more than 500 above the legal threshold for yeast and mold. Dr. Zoe Weiss, the director of clinical microbiology at Tufts Medical Center, says mold can have a severe impact on the immunocompromised.
It can enter the lungs and it can cause pneumonias that can lead to even areas of like a ball of fungus in the lungs that can invade the blood vessels in the lungs.
The lab sued the CCC, arguing they didn't get due process, and reopened a month and a half later after paying a $300,000 fine.
The one thing the commission did not do was pull those products from shelves. Why was that?
Is there more to do? Yes, there is. But those products, once identified, they were frozen in place, and consumers and patients couldn't purchase them.
We sat down with CCC Chair Shannon O'Brien and Head of Public Safety Kimberly Roy.
We are working to have a product recall policy in place.
So they weren't further distributed.
That's right.
But they weren't physically recalled.
Exactly.
The two did not refute that THC levels could be manipulated.
What you're referring to is more consumer and patient fraud. So you pay more for higher potency THC. So folks, patients, consumers are paying additional.
They say they're advocating for a secret shopper program, which would allow the CCC to conduct regular randomized of retailers and test their products.
The secret shopper program is something that we raised in this very room over 3 years ago. And we were actually told by senior staff that we had a secret shopper program, which we don't.
Today, the CCC has only used secret shopper to follow up on tips. All of this within a regulatory framework being built along with the industry.
Sometimes you hear the industry being compared to big tobacco, that the profits are so good that maybe regulators are looking the other way. What would you say to critics like that?
Oh, I would disagree with that. We are regulators protecting public health and safety, but this is also an economic driver in this state.
We reached out to Assured for comment and didn't hear back. Louisa Moeller, WBZ News.
All right, the government's late. Ladies and gentlemen, my name's Grant Smith Ellis, and I am here to tell you the government is late. But can you really blame them for being late for what is a historic moment? We are going to see social consumption regulations passed into law. And if you don't know what this means we're going to see like Amsterdam-style cafes, all different sorts of social consumption establishments in Massachusetts. If you're waiting for the CCC like me, they have not come into session yet. Okay, they are going to come into session normally like 10:15. Gives a little bit of time for folks to get there. This is a big day too, so they could have an audience. Now, here's today's schedule. We're going to watch the CCC do their vote. I'm going to stop the stream because I have to go to a press conference. Then, once I'm done with the press conference, the stream's going to go back up, and we're going to see Walshe charge conference, the conclusion thereof, and then we're going to watch the CCC hearing about all this other stuff they got to do, because it's going to go, because we have to know for planning purposes, it's going to go vote on social consumption, recess, press conference, return to session, rest of the meeting. All right. So, and I don't want to take the press conference live. Oh, I guess we could. Oh, we're starting. Okay, everybody ready? Here we go.
To order. This meeting is being held hybrid pursuant to Chapter 2 of the Act of 2025 and is being recorded. Commissioners Benedon, Stebbins, Roy, and myself are participating in today's meetings. All votes taken today will be by roll call. We have a full agenda today that I will generally summarize. We will start with opening comments from commissioners before we proceed to staff license recommendations. There are 4 change of ownership recommendations, 30 license renewal recommendations, 4 final license recommendations, 8 provisional license recommendations, and 1 responsible vendor training renewal. Following the approval of licenses, we will take up item number 7 under the Commission Discussion and Vote section, the final vote of the draft of social consumption regulations. Following the vote on the draft of social consumption regulations, we will enter into a 30-minute recess to allow commissioners to participate in Scrum. When the Commission has reconvened, we will continue with the agenda, starting with approval of 4 sets of minutes, then the Executive Director and Commission staff report. There are 9 items in the Commission Discussion and Vote section today. Hopefully we will get to all of them. Job description, Director of Testing, Procedure of Legal Intervention, discussion and vote on omitted data from the 2025 industry report regarding public health and safety, fiscal year 2027 budget discussion, a new metric product catalog with COAs, updates to the testing data on the Commission Open Data website, vote for Commission Treasurer and Secretary for 2026, notices of deficiency process discussion, and final vote of the draft social consumption regulations, revisions to 935 CMR 500 and 935 CMR 501. And again, this may not be the exact order that we follow today given time constraints. We do have someone presenting to us today. Again, I will ask that commissioners wishing to comment or ask questions during any part of the meeting raise their hand to be recognized. If needed, the Commission may enter executive session. If commissioners, first of all, I will start with initial comments, and I will turn things over, and I will do this in alphabetical order today, and we will start with Commissioner Benedon.
Hi, good morning. It's great to see everybody. Thank you. I don't think I have any particular updates or comments, so I'll pass it along.
Thank you, Commissioner Roy.
Thank you. Good morning, everyone, and thank you, Chair. I'll be really brief. I just want to say today is an important day. Today, the Commission honors the will of the voters from ballot question 4 passed in 2016. It took a long path to get here, but today we have arrived. I want to thank Chair O'Brien for her leadership in scheduling an ambitious amount of meetings to get us over the finish line. I also want to mention that Chair O'Brien and myself did an interview recently with CBS News around THC inflation, and we had a lengthy interview. In the news, it gets called down to a quick minute or a sound bite, but it's a nationwide problem. It's not unique to Massachusetts. We have potency inflation and lab shopping. And today we're going to talk perhaps about the economic drivers that lead to that. But what we need is, in my opinion, 3 things have to occur. We need an internal reference lab so we can confirmatory test. We need a secret shopper plan that is being executed. And we need open data with no roadblocks. We need de-anonymized, open data, aggregated for the world to see anomalies and outliers. So no more roadblocks. Let's work on getting this done. In the last few meetings, I said, I don't want to hear how we can't do it. I want to hear how we can. And so this is a public health issue. I sit in the public health seat. I take this very seriously. We've been meeting with the ITLs on a regular cadence. We are in agreement. We need standardization. We all are in agreement, and I've said this for the last 4 years, and I think people were wondering why I was saying it, the need for a standards lab, but we clearly need one. And we need open data, de-anonymized open data without waivers for the world to see. So no more roadblocks. Let's get this done so consumers and patients have accuracy in their labels. Thank you.
Thanks, Commissioner Roy. Commissioner Stebbins?
Thank you, Chair. A couple of updates since our last meeting and some additional comments as we move to close out the year. So it might be a little lengthy. I apologize. Monday, I had the chance to visit with the Mayor of Gardner to share information about our progress with respect to social consumption. We reviewed the current proposed regulatory changes, requirements for prospective licensees, as well as the role and options for any host communities. So I thank the mayor for his time. After that, I had a chance to tour Garden Remedies facility in Fitchburg, meet with their team. Thanks to Samantha Woodman for arranging that visit. Great discussion around badging, accounts receivable, tier relegation, and some other topics. Also had the opportunity to tour a growing and production facility for Fresh Connection, also in Fitchburg, and thank Will Seagard and his team for hosting me. Yesterday, the ED or DGAP team and I were invited to give a presentation for, I hope I got her title correct, Executive Office Economic Development Director Ann Goby, in a virtual meetings that she hosts for rural communities across Massachusetts. We discussed social consumption, we discussed hemp, we discussed the status of cannabis as the Commonwealth's top crop, and developments with respect to delivery. Again, thanks to Director Goby and her team for inviting us. I know she is forwarding us a number of questions with respect to our regulations that she's already getting from some of the municipality officials that were on the call. Finally, excited for today's vote on social consumption. Really wish to express my thanks to the members of the working group, both past and present, who I've had the honor to work with on this effort. Mike, Erica, Jessica, Matt, Andrew, Phil, and acknowledge the contributions from our comms team, EPCO, I&E, enforcement, research, and the rest of our legal team, and to thank all of the stakeholders, communities, other states that we talk to, public health and safety officials, and groups who offered critical insights and ideas for our framework. I want to thank the ED, and I also want to thank my colleagues for immersing yourself in the details in the deliberations. A big first step for this marketplace. Also important to note some of the other changes that I hope we can approve today, which haven't necessarily gotten the same amount of attention, but are changes we're making to badging, which will have benefits across the industry, and specific changes to ITL agent badging that will support our ITLs. And I want to thank Megan Dobro for helping us recognize and make that important change. So, and wish everyone a safe and happy, healthy holiday season. Thank you.
Thank you, Commissioner Stebbins, and I want to echo the individuals that have gotten us to this period. And I also want to thank folks who have been waiting for social consumption, which we will be finalizing today. I know there's been some criticism about when I returned or when Commissioner Benedon joined the commission. And there were some concerns about whether or not that would delay this process. The fact is we kept the promise. This is going to be done and we sent to the Secretary of State's office before the end of the year. Because I think of some of the great comments that Commissioner Benedon has added, even in the first couple of meetings she's been there, we've been able to, in this piece of regulatory writing, we've been able to remove unnecessary regulatory burdens. We've been able to help retailers actually sell snacks, which is a small but important revenue source for them, making sure that we have THC inhibitors that can help overserve people. There are a number of nuances and a number of changes that have happened during the past 7 meetings that we've had since I returned to the commission, and Commissioner Bennett joined us. So I just want to say thank Commissioner Stebbins for working on this for 2-3 years. I think you and Commissioner Camargo were working on this, and I thank Commissioner Roy for the important additions that she made, and again, all the staff who contributed to this. But I do think these last 7 meetings have been especially critical to making this the best bill that we possibly, the best regulatory writing that we could put out there. So I want to thank people for their patience, and I do know that this is just a beginning. We have a lot of work to do. I've already been reaching out to a number of mayors to set up some of the advisory groups that will help us actually make this a reality. So again, thank all the staff for the work that they've done. Thank my commissioners for the work that they've done. Thank the executive director for his leadership, because obviously he stepped in through this process. So again, just want to applaud everyone for the hard work. But now we're going to get to the business at hand. So we're going to be starting on staff recommendations on provisional license. And there are 8 provisional licenses that we will be voting on today. Sue, are you going to be leading this, or? Yeah, okay, thank you. Okay. Oh, I thought we were going to go.
Oh, my apologies.
No. We're going right to this first. There's a time sensitivity to this one, and then again, this is what I was saying is that I read the script about timing, but we have a couple of things that we might move out of order because of some other issues that are occurring outside. We have a very timely approval here. Anyway, Director, thank you. If you could take over that.
So today, we're presenting provisional license recommendations today. The first one on the agenda is Cape Way Cannabis LLC, MRN 285074. The applicant here is Cape Way Cannabis LLC, doing business as Cape Way Cannabis. The proposed location is 120 MacArthur Boulevard, located in Bourne. They're seeking a marijuana retail license. The applicant received general review. Commission staff has reviewed the application for compliance with applicable laws and regulations. I'm presenting it for the commission's review and vote.
Thank you. Do I have any questions or comments? Hearing none, I will entertain a motion. Commissioner Roy, will you approve the staff's recommendation on the provisional license for Cape Way Cannabis?
So moved.
Do I hear a second? Commissioner Bennett?
Second.
Having been moved and seconded, I'll take a call of the roll. Commissioner Roy?
Aye.
Commissioner Stebbins?
Aye.
Commissioner Bennett?
Aye.
Chair votes aye. Cape Way Cannabis is approved unanimously. Cloud9 Visions.
The applicant here is Cloud9 Visions LLC. The proposed location is 5 Cheshire Road, Suite 12, located in Pittsfield. They are seeking a marijuana retail license. The applicant received expedited review as an SEP. Commission staff has reviewed the application for compliance with applicable laws and regulations and are presenting it for Commission's review and vote.
Thank you. Are there any questions, comments, or conditions from the commissioners? Hearing none, Commissioner Stebbins, will you move to approve the provisional license of Cloud9 Visions?
So moved.
Commissioner Bennett, do I hear a second?
Second.
Having been moved and seconded, I'll take a call of the roll. Commissioner Roy?
Aye.
Commissioner Stebbins?
Aye.
Commissioner Bennett?
Aye.
Chair votes aye. This passes unanimously. Moving on to Chief Cannabis.
The applicant here is Chief Cannabis LLC. The proposed location is 10 Canal Street, located in Bourne. They are seeking a marijuana retail license. The applicant received expedited review as a veteran-owned business. Commission staff has reviewed the application for compliance with applicable laws and regulations and are presenting it for Commission's review and vote.
Thank you. Do I have any questions or comments from the commissioners? Hearing none. Commissioner Bennett, do I hear a motion to approve Chief Cannabis provisional license?
So moved.
Commissioner Stebbins, do I hear a second?
Second.
Having been moved and seconded, I'll call the roll. Commissioner Roy?
Aye.
Commissioner Stebbins?
Aye.
Commissioner Bennett? Chair votes aye. Chief Cannabis provisional license is approved. DMS Trinity.
The applicant here is DMS Trinity LLC, doing business as Trinity Naturals. The proposed location is 36 Charles Street, located in Malden. They are seeking a marijuana retail license. This applicant received expedited review as an SCP and minority-owned business. Commission staff has reviewed the application for compliance with applicable laws and regulations and are presenting it for the Commission's review and vote.
Thank you. Are there any questions or comments from the commissioners? Hearing none. Commissioner Roy, do I hear a motion?
So moved.
Commissioner Stebbins, do I hear a second?
Second.
Having been moved and seconded, I'll take a call the roll. Commissioner Roy.
Aye.
Commissioner Stebbins.
Aye.
Commissioner Benedon.
Aye.
Chair votes aye. DMS Trinity provisional license is approved. Moving on to Just Creatives.
The applicant here is Just Creatives LLC. The proposed location is 90 Conn Street, number 219H, located in Northampton. They are seeking a marijuana courier license. The applicant received expedited review as an SEP. Commission staff has reviewed the application for compliance with applicable laws and regulations and are presenting it for the commission's review and vote.
Do I hear any questions or comments from the commissioners? Hearing none. Commissioner Benedon, do I hear a motion?
So moved.
Commissioner Roy, do I hear a second?
Second.
Having been moved and seconded, I'll take a call the roll. Commissioner Roy.
Aye.
Commissioner Stebbins.
Aye.
Commissioner Benedon.
Aye.
The chair votes aye. The provisional license of Just Creatives passes unanimously. Moving on to Melting Pot Manufacturing.
The applicant here is Melting Pot Manufacturing. The proposed location is 321 West Grove Street, floor 2, unit 1, located in Middleborough. They are seeking a product manufacturing license. This applicant received expedited review as an SEP. Commission staff has reviewed the application for compliance with applicable laws and regulations and are presenting it for the commission's review and vote.
Thank you. Commissioner Roy, do I hear a motion?
So moved.
Commissioner Stebbins, do I hear a second?
Second.
Having been moved and seconded, I'll take a call the roll. Commissioner Roy.
Aye.
Commissioner Stebbins.
Aye.
Commissioner Benedon.
Aye.
Chair votes aye. Melting Pot Manufacturing provisional license passes unanimously. Moving on to Paper Crane Provisions.
The applicant here is Paper Crane Provisions LLC. The proposed location is 56 Gardner Road, located in Hubbardston. They are seeking a product manufacturing license. The applicant received expedited review as an SEP. Commission staff has reviewed the application for compliance with applicable laws and regulations and are presenting it for commission's review and vote.
Okay, thank you. Any comments or questions from the commissioners? Hearing none. Commissioner Stebbins, do I hear a motion?
So moved.
Commissioner Roy, do I hear a second to that motion?
Second.
Having been moved and seconded, I'll take a call the roll. Commissioner Roy.
Aye.
Commissioner Stebbins.
Aye.
Commissioner Benedon.
Aye.
Chair votes aye. Paper Crane Provisions provisional license is passed unanimously. And moving on to TMAP1 LLC.
The applicant here is TMAP1 LLC, doing business as Technic Group. The proposed location is 6 Cobbler Drive, located in Fitchburg. They are seeking a product manufacturing license. The applicant received general review. Commission staff has reviewed the application for compliance with applicable laws and regulations and are presenting it for the commission's review and vote.
Thank you. Are there any questions or comments regarding this license? Hearing none, I will ask for a motion to approve. Commissioner Roy?
So moved.
Do I hear a second? Commissioner Stebbins?
Second.
Having been moved and seconded, I will take a call the roll. Commissioner Roy?
Aye.
Commissioner Stebbins?
Aye.
Commissioner Benedon?
Aye.
Chair votes aye. TMAP1 LLC passes unanimously. Now, we will be moving on to staff recommendations for change of ownership.
Madam Chair,
Oh, sorry.
just make one point on the provisional folks who may be under time constraints today and looking to get
Is there
information.
more than one that's under time constraints?
I know that there's at least one.
Oh, all right. Okay.
So just to make a note for those folks who are looking to pay specifically today because they're looking to move their processing along, that when you are looking to pay your provisional license fee online through N-Court, you must then go in and click
COURT, right?
Correct. Yep. N-Court. Yep. And that is the spelling. You must click submit button after completing your payment. This will ensure the payment is properly transmitted to Mass CIP and will help prevent any delays in processing. That is a message that we've worked through with other folks in the past. So just making sure that folks are aware.
And again, just to explain for people who are listening, that this is one of the reasons that we took this upfront so quickly is because we do have at least one social equity provisional applicant that is looking to qualify for funds from the cannabis fund. So it's due today. So, and again, thanking the staff for helping. There was a little bit of a glitch and they did extra duty to make sure this could happen. So I thank them for that. So thank you for that clarification. So again, moving on to change of ownership. Or no, moving on to license renewal, sorry.
There are 25 adult use and 5 MTC renewal recommendations for the Commission's consideration. Commission staff has reviewed the applications for compliance with the applicable laws and regulations and are presenting it for Commission's review and vote.
Great, thank you. And these will be voted on as a group. Do commissioners have any questions or comments regarding Commissioner Stebbins?
Sure. Thank you, Chair. Just a quick point. No condition really need to attach to it, but I believe number 13 DM Orange LLC talked about making a contribution to the Social Equity Trust Fund. They noted that they weren't aware of how they can do it, but they've kept that goal for their positive impact going forward. Obviously, the fund, as we all know, is not something we operate, but the EOED has now set it up that licensees can make contributions. There is a way to do that. So hopefully DM can either go to EOED's website or certainly reach out to us and we can direct them to the right people, but appreciate their interest in making a contribution.
Can you clarify that? In terms of how people know what they can do, because you like creativity, I hate it. And I just think I want people to understand how they can meet their responsibilities as a business while meeting our social mission, but making sure it is as easy and seamless as possible. So could you elaborate a little bit on, because I don't know this, it sounds like because of your inquiry or someone's inquiry that they have now made this process more streamlined, and less creative.
Sure.
But
you know, when we were doing the implementation for Chapter 180, one of the changes in the regulations that we all made was you could meet your efforts under your positive impact plan by making a donation to the Social Equity Trust Fund, which Chapter 180 also helped set up and create. So it was quite some time ago, but EOED joined us for a meeting and said, now there is a way that you can make a contribution. So DM, as I was reading through the material, they might have had a different name that they attached to it, but I think for all intents and purposes, they're trying to identify the Social Equity Trust Fund. They wanted to keep that as a goal in their updated positive impact plan. So it's certainly, according to our regs, is a way that they can meet their positive impact plan intentions. But again, as we all know, the fund isn't ours. It comes out of the Executive Office of Economic Development, and they now have set up a way, account, et cetera, that entities, our licensees, can make a contribution, but it's completely.
But if I can ask, so if the Executive Office of Economic Affairs has allowed this, how do we publicize it? How do we let, you know what I mean? That's I think as people are going through this process and they're trying to comply and they're, obviously, spending a lot of time figuring out how to put together their business plan and the paperwork that they need to send to us. How do we let them know that this is a seamless way that they can meet some of the requirements of their licensing?
I think what we've done to this point, again, we had EOED join us virtually for a meeting to say they are now set up to accept contributions. I think we could certainly talk with our team about what information we make available. I think to your point on our website and our material for licensees to follow, But
that's what I was saying is I think that I think that you've done good work allowing it to be more seamless to happen, but we probably should be making sure that we make people aware of that opportunity. Commissioner Rice.
Thank you. Through the chair to Commissioner Stebbins, and thank you for bringing this up. Could you share with folks listening how they physically do it? Is there a link on the website? How do they physically make that donation?
If I recall, and I didn't look into this, is I was in advance of this meeting, but EOED does have either a link or they have, they've certainly set up the process by which they can receive a contribution. But I think to the chair's point, I'd have to go back and look for the details, but certainly we can share that with folks that are interested in making this part of their positive impact plan.
Thank you. Thank you. So that having been said, If there are no further questions or comments, Commissioner Stebbins, do I hear a motion to review these 20 license renewals as submitted by staff?
So moved.
Commissioner Benedon, do I hear a second?
Second.
Having been moved and seconded, I will take a call of the roll. Commissioner Roy.
Aye.
Commissioner Stebbins.
Aye.
Commissioner Benedon.
Aye.
Chair O'Brien votes aye, and that is unanimous. And now we are moving towards, wait a minute, we've gone through this, right? This, are we on the right page? There are 30 total. I said 21. Okay, because I couldn't see these going back there. Sorry. So, I said 30. Yeah, I would like to amend. I would seek an amended motion from Commissioner Roy.
30 licensees.
30 licensees. I said the number wrong. Commissioner Stebbins, will you second that amended motion?
Second.
Having been moved and seconded, I will once again take a call of the roll. Commissioner Roy, Commissioner Stebbins,
Aye.
Commissioner Benedon, as amended, all 30 licenses are renewed unanimously. My apologies. Okay, and moving on to change of ownership. I'm just looking on the script on the screen. Anyway, we can move to change of ownership, or which Director, which would you like to go to?
Manager, and however you want to do it, it's fine with me.
Okay, all right, so why don't we go on to recommendations for final licenses? There are 4 voted on as a group.
There are 4 final license recommendations for the Commission's consideration, which include 1 EE, 1 SEP, 1 woman-owned, and 1 general. Commission staff has reviewed the applications for compliance with applicable laws and regulations and are presenting it for the Commission's review and vote.
Thank you. Are there any questions or comments on the recommendations on these final licenses? Hearing or seeing none. Commissioner Roy, do I hear a motion to approve these final licenses?
So moved.
Commissioner Benedon, do I hear a second?
Second.
Having been moved and seconded, I will take a call of the roll. Commissioner Roy.
Aye.
Commissioner Stebbins.
Aye.
Commissioner Benedon.
Aye.
Chair votes aye. These 4 final licenses are approved, and we are now moving on to a responsible vendor training renewal.
About change of ownership.
Well, I'm just trying to, only because I'm using different slides, and so I'm trying to just make sure I'm efficient, and we have a little bit of a weird, out of kilter way that we're moving this agenda because we're taking a break in the middle. So I've got 5 different pieces of paper that I'm looking at. So anyway, I apologize for not being very seamless myself. Okay, we'll move on to responsible vendor training renewals.
The applicant here is Bud Education. They are seeking to be renewed for an additional 2-year certification to provide basic core curriculum training in the Responsible Vendor Training Program. Since their original certification date, they have provided instruction for 15,797 marijuana establishments and medical marijuana treatment center agents. Commission staff has reviewed the application for compliance with applicable laws and regulations and are presenting it for the Commission's review and vote.
Thank you. Are there any questions or comments on the staff's recommendation to approve the responsible vendor training renewal for Bud Education? Hearing and seeing none, I will entertain a motion. Commissioner Roy, to approve.
So moved.
Commissioner Stebbins, do I hear a second?
Second.
Having been moved and seconded, I will take a call of the roll. Commissioner Roy.
Aye.
Commissioner Stebbins.
Aye.
Commissioner Benedon.
Aye.
The renewal of responsible vendor training provider Bud Education is done unanimously. So again, so I think that are we through everything here? We do the change of ownership. So I'm just saying I apologize. I'm missing something. So we will move on to change of ownership. My apologies because I have some documents that are not necessarily all in sync. So anyway, change of ownership. Thank you. If we can move to that. Thank you.
All right, the licensee here is Coastal Cultivars Incorporated. They are seeking a change of ownership and control of 2 adult use licenses. They are requesting to add 2 individuals and 1 entity. Commission staff has reviewed the application for compliance with applicable laws and regulations and are presenting it for the Commission's review and vote.
Do I hear any Commissioner Roy?
I just have a comment. Thank you, Chair. I just want to know on the Theory Wellness, it's one of 4 ESOPs operating in Massachusetts today. That's the employee stock ownership plan, where the employees are owners in the company, and they just, I believe, created another entity within that umbrella. But my experience in visiting an ESOP is quite remarkable, actually. Employee morale is high, turnover is low when employees are vested in it. It also provides enormous, I'm not going to give a commercial for ESOPs, but from what I've learned, and offers an enormous benefit with regards to 280E. You're no longer beholden to that. So I know more folks are exploring that option, but I just wanted to point that out around Theory Wellness. And secondly, I would like to put changes of ownership on a future agenda, Madam Chair, if possible. Unfortunately, I'm hearing more about receiverships than I am about renewals. And in a lot of time, these distressed entities are on a time is money, literally. And I was wondering if we could talk about it as a board, whether we want to prioritize those changes of ownership in the queue when we know they're in receivership and these are distressed sales. And, unfortunately, I'm hearing from a lot of folks that we're seeing more and more receiverships in Massachusetts. And again, there's no bankruptcy protections because of the federal illegalities. So I just want to flag that, Madam Chair, for a future agenda if possible.
Thank you. I appreciate that. Commissioner Stebbins.
Thank you, Chair. And just to echo Commissioner Roy's point on these, on Theory Wellness, as you said, going through an ESOP change, and the one Commissioner Roy and I had the opportunity to visit an ESOP licensee. And to her point,
it was incredible.
Just the engagement of the agents is a lot different. You talked about the better tax treatment that ESOPs can pursue with respect to federal tax recognition. And it's also proven to be a way for some owners to try to transition out of the industry and allow their employees. As I was reading through, and I think, we hit on some of these points, I would love to think of how we could help flatten or smooth the ESOP transition a little bit easier when we go through changes of ownership. Because when you read through the report from our team, yes, they're adding an ESOP holding company, but you get through the other questions. The following individuals will be added as persons having indirect or direct control. None. Following individuals will be removed from the license. None. The following entities will be removed from the license. None. So it definitely is, hopefully it takes our team a little bit less time to go through changes of ownership, but we might want to look at how we do that, knowing that it's not considerable change when it comes to the actual ownership. So
I think that both the point that you make, Commissioner Stebbins, and the point that Commissioner Roy makes is that we are at a different inflection point right now in terms of things that are going on with different licensees. It's always been a significant challenge for anyone to enter the market. And again, I thank the staff for helping, because we have some social equity applicants that are looking to take advantage of some of the funds that the legislature has made available. There is the problem with licensees giving up their license, and so we need to be responsive to that and making sure that we are on top of potential opportunities that could help the industry as a whole. And maybe it's one, making information available about how they can make payments and meet their recommendations, or how they could possibly access a different organization model that could be beneficial for the employees and the businesses themselves. So I appreciate the comments from everybody. That being said, are there any questions or comments on the recommendation to approve the change of ownership for postal cultivars? Hearing none, I'll entertain a motion to approve from Commissioner Roy.
So moved.
Do I hear a second? Commissioner Benedon?
Second.
Having been moved and seconded, I'll take a call the roll. Commissioner Roy?
Aye.
Commissioner Stebbins?
Aye.
Commissioner Benedon?
Aye.
Chair O'Brien votes aye. It passes unanimously. Now on to Seven Leaf Sisters.
The licensee here is Seven Leaf Sisters Incorporated. They are seeking a change of ownership and control of 2 adult use licenses and are requesting to add 4 individuals in 1 entity. Commission staff has reviewed the application for compliance with applicable laws and regulations and are presenting it for the Commission's review and vote.
Thank you. Are there any questions or comments from my fellow commissioners? Hearing none. Commissioner Benedon, will you move to approve the change of ownership recommended by staff for Seven Leaf Sisters?
So moved.
Commissioner Stebbins, will you second that motion?
Second.
Having been moved and seconded, I'll take a call of the roll. Commissioner Roy. Aye. Commissioner Stebbins.
Aye.
Commissioner Benedon. Chair votes aye. Seven Leaf Sisters, change of ownership passes unanimously. Moving on to Slang Incorporated.
The licensee here is Slang Incorporated. They are seeking a change of ownership and control of one adult use license. They are requesting to add 3 individuals and 3 entities. Commission staff has reviewed the application for compliance with applicable laws and regulations and are presenting it for the commission's review and vote.
Thank you. Do I hear any questions or comments from commissioners? Hearing none. Commissioner Roy, will you move to approve this change of ownership for Slang Incorporated? So moved. Commissioner Stebbins, will you second that motion?
Second.
Having been moved and seconded, I will call the roll. Commissioner Roy.
Aye.
Commissioner Stebbins.
Aye.
Commissioner Benedon.
Aye.
Chair votes aye. Slang Incorporated, change of ownership passes unanimously. Theory Wellness.
The licensee here is Theory Wellness Incorporated. They are seeking a change of ownership and control of 3 adult use licenses and 3 MTC licenses and are requesting to add 1 entity. Commission staff has reviewed the application for compliance with applicable laws and regulations and are presenting it for the commission's review and vote.
Thank you. Are there any questions or comments from commissioners? Hearing none. Commissioner Stebbins, will you make a motion to approve the change of ownership for Theory Wellness?
So moved.
Commissioner Roy, will you second that motion? Second. Having been moved and seconded, I'll call the roll. Commissioner Roy.
Aye.
Commissioner Stebbins.
Aye.
Commissioner Benedon.
Aye.
Chair votes aye. It passes unanimously. And I believe we have one last responsible. Oh no, we did responsible vendor training. So
Minutes, I guess.
yeah, I'm going to go to the minutes. Yeah, because we just so you know, because we do have a visitor coming that will be making a presentation, and we are going to be taking a break. We are a little bit changing the order today, and again, I apologize for my lack of managing this smoothly. So next, we will move to the minutes, approval of the minutes. So if we can put that up, okay, great. So are we ready for that? Okay. We will. So the first round of minutes that are subject to approval are from the October 1st, 2025 meeting. Are there any questions or comments? Hearing none. Commissioner Roy, will you move to approve the October 1st, 2025 meeting? So moved. Commissioner Stebbins, will you second that motion?
Second.
Having been moved and seconded, I'll call the roll. Commissioner Roy.
Aye.
Commissioner Stebbins.
Aye.
Commissioner Benedon.
Abstain.
Chair votes aye. 3 votes in favor, 1 abstention. Moving on to October 9th, 2025. Are there any questions or comments? Hearing none. Commissioner Stebbins, will you move to approve the October 9th, 2025 AM meeting? Because if you recall, we had another issue with a licensee needing us to put something on the agenda. We had missed the open meeting law filing deadline, so we actually had 2 meetings on October 9th. So this is the AM meeting. So Commissioner Stebbins, will you move to approve for the October 9th, 2025 meeting?
So moved.
Commissioner Roy, will you second that? Second. Having been moved and seconded, I'll call the roll. Commissioner Roy.
Aye.
Commissioner Stebbins.
Aye.
Commissioner Benedon.
Abstain.
Having Commissioner Chair O'Brien votes aye. So it's 3 in favor and 1 abstention. Moving to October 9th, 2025 PM. Any questions or comments? Hearing none. Commissioner Roy, will you move to accept the minutes as drafted for October 9th, 2025, the PM meeting? So moved. Commissioner Stebbins, will you second that motion?
Second.
Having been moved and seconded, I'll call the roll. Commissioner Roy. Aye. Commissioner Stebbins.
Aye.
Commissioner Benedon.
Abstain.
Chair votes aye. 3 in favor, 1 abstention. Now, finally, October 15th, 2025. Do we have any questions or comments, additions to those minutes? Hearing and seeing none. Commissioner Roy, will you move to accept those minutes as drafted? So moved. Commissioner Stebbins, will you second that motion?
Second.
Having been moved and seconded, I'll call the roll. Commissioner Roy. Aye. Commissioner Stebbins.
Aye.
Commissioner Benedon.
Aye.
And chair votes aye. Unanimously voted on those minutes. So thank you very much. So now, thank you very much to the licensing staff. So we now will be moving on to Commissioner Roy.
I have a comment at the end for the minutes.
Oh, please, please make your comment.
Okay. I just have a question, and maybe as the acting secretary, hopefully maybe be reelected secretary today if he wants it. I have a question on the executive session minutes. So I know we're subject to triannual review of the minutes, and we vote as a board whether to release the minutes from executive session if the purpose has expired. So I know that step. What happens? Do the commissioners ever get those minutes from executive session for us to review?
I believe we do. I think it's, if I'm correct, and ED may correct me, we start with the review of what is no longer protected, and there's a lot of stuff that's still even from far before any of us joined the commission, and then the ones that we do decide are no longer protected. I think the subsequent meeting, we see those and approve.
So my question, if Chair, to the executive director, I've had questions. Where can the public find those executive session minutes on our website? Where can the commissioners find those executive sessions? I've had questions around these.
Thank you.
I was actually just having that discussion, and it seems like it's probably going to be, and I apologize to a few different teams that'll probably have to help me do this. It seems like the history here has been the minutes are found within the packets of the meetings in which they're approved. And in some instances, I see them broken out, but for the most part, to find, for example, minutes that are reflected here elsewhere on the agenda, that you go into a packet that had the minutes that were approved. So hopefully we can easily, without a ton of work, separate them so that they're more easily searchable on the website.
Yeah.
But it does seem like it's going to be a little bit of a project to do that, but I will start that process. The chair had flagged that for me previously.
Okay.
So that is, unfortunately, the answer is when they're approved, they're in the packet. So then you have to look up the meeting that they were approved in, whereas they should be separated so they're more easily searchable.
Or they should be with the meet. Well, no, because we don't. Well, because some of them are separate executive sessions.
So another way that we could look at how to, and that's why I'll have to work with the digital team and everybody. But really, if you look at the previous meeting, that's how we would do it in municipal, for example, is you would go to that date on the calendar, and then you would have the original packet, the agenda, and the minutes would ideally be linked through there. Otherwise, it could be all on one separate page, so it's in numerical.
Make it easier to just put it on one separate page, because you now have to. Because I know that there were some minutes that from an executive sessions, and frankly, the executive sessions were held in violation of open meeting law, so they should have been held in front of the public in the first place. And the former general counsel, they were held for months and months and months and months and months. And so, the commissioners need to not only have access to that, but also if we're not necessarily recording those, and do we record executive sessions?
Madam Chair, my understanding is that there was a period of time prior to my arrival that was done. I'm unclear on why. It's not a practice that I'm used to, but in the executive sessions that I've been involved in, we have not recorded.
So it's probably a policy we should look at, because I do know that some of the executive sessions that were held in violation of open meeting law, that there were videos that were taken. And so, just as any of these meetings, you can actually have a videotape to go and see what happened in the meeting. I know that executive sessions are a little bit different because while we all know that everything we do, we're a public agency, we don't get to hide data, we don't get to hide information, that there is probably a different posture when you're in an executive session where you're having a conversation. So it does make it more difficult for the legal team that does have to redact. But it feels like we probably need to take a look at that as a policy. Because if it takes your legal counsel a year to go through and vet those minutes, a year, and I'm seeing as much as a year and a half, at least a year after a purpose is done. If I'm going to go and look at those minutes and I want to be able to vote on them and approve them, I may not remember that from back, and my notes may not be as fulsome as anybody else's if I'm actually engaged in conversation. So it's a conversation for another time, but I do think we should look at determining how we can best capture information from executive session meetings.
If I may, Madam Chair.
Yes, thank
you. Happy to work with you on what a policy discussion might look like. Also, we'll work with most likely GAP and some other teams here on whether or not we can break out. So on the website, it's easier to just sort of go through the ones that have been approved. Obviously, as you mentioned, for executive session, it is when the purpose is up, which sometimes impacts the timeline, but I think you referenced that. So thank you.
Thank you, Commissioner Roy.
Through the chair to the executive director. For the general public, the regular minutes, non-executives, are those also within the meeting packets, or are they housed separately?
If I may, so for example, I was looking up because we have August 14th reference later on in the agenda. So when I just had to find it, I went through the meeting that it was approved on. And so I can provide that link in the chat so people can go to those when that's up on the agenda later. And so in that example, they are not listed separately.
Okay.
But if I can just point out, Commissioner Roy, that there's a difference between a meeting that's held behind closed doors that's not recorded and these meetings.
Absolutely.
Right? These meetings, we are in front of the public. Everything we say, down to, me pushing my hair this way, they can see what we're doing, what we're saying, how we're discussing things. So the minutes are really more a vestige of before we had all this technology to capture everything live so that people know, what's going on. So even if maybe we draft minutes and maybe it doesn't 100% capture everything, you can go back to the YouTube channel and you can see what we did. So that I think is a difference. Commissioner Roy.
And also, just a question for the executive director. For redactions on executive, is there an SOP? What rises to the level of redaction?
If I may, Madam Chair.
Please, thank you.
Everything would fall under open meeting law. I'm sure we could get more specifically into that, but I think if the chair is looking to have a policy discussion, we could probably incorporate that into it.
Yeah.
I would reference the open meeting law. I know obviously we have an open meeting law expert as well, so I won't step out of my lane.
I'm smelling chairman of a subcommittee, but anyway.
But so I think I can certainly provide all of the open meeting law background, but ultimately that is what that is falling within. And I think if we're going to discuss policy related to that, we can certainly put all that information together at that point.
That'd be helpful.
Thank you.
Thank you.
And Commissioner Bennett, someone may have just volunteered you for some additional response.
Happy to do it.
All right. Thank you very much. So I think so we've gone through the minutes. So now I think we will be turning our attention to the final vote on the draft social consumption regulations revisions. Commissioner Stebbins?
Sure. Thank you, Chair. Just quickly before we get to that, thanks to the team, they put in the chat the information about how you can make a contribution they put in the link to the EOED website. And there's actually part of the page which talks about how you make a donation, and it takes you right over to the payment page.
Is that from Anne Marie? I saw something popping up and
Yep.
I couldn't get to it. So thank you. Thank you, Anne Marie. Appreciate that. Okay, now fully switching gears, moving on to the final vote of draft social consumption regulations and revisions to 935 CMR 500 and 935 CMR 501. And we're going to have to switch folks out. Yes. So thank you very much. Please. Yes, we will. If you want a break, would you like to make a motion? So moved. All right. Motion to recess until 10 past 11. Do I hear a second on that, Commissioner Stebbins?
Second.
Okay, having been moved and seconded, call the roll. Commissioner Roy?
Aye.
Commissioner Stebbins?
Aye.
Commissioner Bennett, chair votes aye. We will be back at 11:10. Again, thank you to the licensing team for helping us with this. And again, I really appreciate the extra work you did to help the folks who were under the gun to get things done in time. So thank you.
Thank you.
All right, you heard, Madam Chair, the big moment is coming. Ladies and gentlemen, we are just 10 minutes away. We'll get to do some towel buildup. Oh, yes, have you ever wanted anything more than towel buildup? Oh, goodness, I hate when I have to actually do things. You know what I'm saying? I do things all the time, but I have to actually do things over the next hour. Maybe we'll take the press conference live. I think there's going to be a decent amount of people there because it's such an important vote. We'll see. Maybe we'll take it live. I can bring it up on my computer, and then once they start the press conference, I can bring it up for you on the feed. I think I can micromanage that. You won't hear anything while I'm preparing, but that should be fine. We'll take the presser live. It's a big day. Social consumption, Amsterdam-style cafes coming to Massachusetts. If you are unfamiliar with the regulatory drafting process, you have to actually spend years writing the changes. And the Code of Mass Regulations in question here is 935 CMR 500.000 and 935 CMR 500.001. And you have to spend a lot of time refining the changes because it's all interconnected. So if you're going to change one section, it's got to be reflected in the definitions, and it can't cross-reference another section without that other section being updated to reflect the clauses in the new section. It's like writing a law. Regulations are a devolved form of lawmaking. In the hierarchy, they're below statutes, but they are laws. So these are lawmakers, as a regulatory body, doing rulemaking, and then the final rulemaking gets voted on today, and then that goes to the Secretary of State. And then within 2 weeks, every 2 weeks, they publish the state register, and then once the changes to 935 CMR 500.000 and 935 CMR 500.001 are officially promulgated, then the law is in place, including the ability for stores to buy snacks. Now, does this mean you're going to see Amsterdam-style cafes tomorrow? No, it's going to take a while. It's going to take a while for the licenses to actually get handed out. It is just a license type, okay? You have a license to sell cannabis, you have a license to manufacture, to cultivate, to deliver, to transport, etc., etc., etc. You also need a license to have a social consumption establishment, or, importantly, to have an event. It doesn't matter if you call your event a protest. It doesn't matter if you call your event a convention. You are regulated by virtue of this new language. It's very robust, both by virtue of what it includes and what it incorporates by reference to what is not permitted. So I'm not a lawyer, this is not legal advice, but you will see every event in the Commonwealth, whether it's on Boston Common, in Worcester, it doesn't matter, regulated by the CCC now. It supplants the existing permitting structure, so it renders all previous permits moot because they were analyzed in the 90s by judicial officers, like the local permitting structure for cannabis-related events, under a prior legal schema. So it supplants, it voids all those permits. It creates requirements that anyone running that kind of event get an event organizer license. They have to get a host community agreement. They have to register as agents with the CCC. They have to go through background checks. They have to, this is anyone involved with organizing an event at all. They have to go through a health and safety check and a compliance meeting with the CCC. They have to have a local compliance meeting. They have to get a CCC-issued permit and license to operate, and then they have to get a local permit and license to operate. Just a little towel smirk. Just a little towel smirk. If you're saying to yourself, Grant, were you very poorly treated? Yeah, but, I petitioned the government for redress of my grievances. I'm a beaming little towel. I got a lot going on personally, but I'm a beaming little towel about this. Oh, yes. What a glorious day. But then, yeah, outside of the glorious impacts on events, call it Lisa's Law, there is absolutely going to be a very interesting situation with Amsterdam-style cafes and maybe bowling alleys, I don't know, yoga studios, vape lounges. Who knows? It's going to start as local communities opting in, obviously. But I think a lot of communities want to do it. I think the social consumption is kind of seen as a way for people in public housing who maybe need to smoke to be able to go do it. It's not really like a bar. There are definitely rules about inebriation, making sure people aren't driving, etc. But it's not really like a bar. It's more like a hangout space. So it kind of, I think it will revitalize a few businesses. If people are looking for reasons to go out and be in these environments and be able to smoke, it will really create some opportunities. I think you'll see it tested out initially over the next few years, but it's a big day. It's going to turn. We're not going to turn into Amsterdam where there's going to be one of these on every corner. But the vibe is going to be like Amsterdam in some of these shops, and that's good. Hopefully and I think the CCC is very good at this. It'll kind of like blend into the existing neighborhoods, but it'll be like a bar. You'll be able to go in there if you're 21 plus, and you can't bring your own, but you can get cannabis and you can smoke it. That's what people wanted. They voted for it. It took a long time due to political machinations. The governor at the time in 2018, when it first rolled out, didn't really want it. He asked them to wait. The AG at the time was, the governor was Charlie Baker. The AG at the time was Maura Healey. Now she's the governor herself. They were both constitutional officers with appointment power over the CCC, so it's kind of like a political issue. And so they held off. The CCC held off on delivery for a little bit. They held off on social consumption. They rolled out delivery, I'd say a year and a half ago, 12 to 14 months ago. Now delivery is really cool. The delivery operator license, that's like where you can warehouse products, buy it at wholesale, sell to consumer via an online sale, and then deliver directly. That's cool. The courier license is more like Uber Eats. You got to like run a courier company, pick up orders at retail price from a dispensary, make money on the delivery fee. Only really like retail stores make money with the courier license. Delivery operators, viable, but it's a tough license to break into. I helped create the delivery operator license. I should know. In any event, these new social consumption license types, I think their viability we have to exactly analyze. Like, what are you making money on? Do you have to have a retail store or a production facility that can seed your products to be viable? Probably. Can you license out, like, can you maybe sell off some of your ownership to partner with someone who has those materials? Yep. And, they're just on recess because they're going to do a break. Then we're going to do another recess and then see a press conference live. I'm going to take that press conference live. So if the press team's listening, please know ahead of time I intend on taking your press conference live. Why? Because I'm a towel news channel, and you're all towels. Everybody can be a towel today, except for Kate Peter. Yes. Remember when I started yelling about the Cape Cod chips? Well, did you hear them just say they can sell snacks now? They came to an agreement on it. I one day got so upset that they were debating, I forget who it was. One commissioner was like, I don't know if they should be able to sell snacks. Yes, it's Cape Cod chips. Of course, the dispensaries should be able to sell snacks. The medical dispensaries can already sell Cape Cod chips. So I got on stream and I was like, okay, government, after recess, I was like, you can go back to discussing the Cape Cod chips now. God help us all. But yes, adult use dispensaries in the state can now sell Cape Cod chips. God bless America. It is a glorious day. Yes, our government is functioning efficiently. How do we know this? Dispensaries can sell Cape Cod chips. Yes, that is the headline. The social consumption rules are great. But really, ladies and gentlemen, we all know the big issue of the day is that adult use dispensaries can now sell Cape Cod chips. Bunny would like us to know that Cape Cod chips are their favorite. Bunny, I have great news for you. Dispensaries can now sell Cape Cod chips. Oh, yes, that's going to be the headline. Dispensaries in Massachusetts can sell snacks. The government is functioning efficiently. Oh, yes. Yes. Well, listen. Administrative law is complicated. I'm not a lawyer. I'm a towel. But no one's going to sit there and tell you that an Article I court with a bifurcated rulemaking and enforcement structure operating independently under the appointment power of constitutional officers is simple. That's before you even get into the actual codification of their policy deliberations into the Code of Mass Regulations, which is statutory language. Take all these people, very smart people with ideas, spend 3 years listening to them, and then try to condense it into statute. And then, well, it's a regulation, but it's a law. Then take that statutory language, put it into the existing statutory language, make it align with the other sections, and then get them all in a majority vote to agree on your interpretation into legalese of what they were debating about policy. And that's the process we just went through over the past 3 years. The lawyers probably ran up against a wall and just broke the wall with their head like 77 times. Do you know, I'm not a lawyer, I'm a towel. Do you know how hard it is? 1, to interpret law for a layperson. 2, to have your boss be, some of them are lawyers, but your boss be a political operator, a commissioner who's not a lawyer, who they basically have to learn the law to do this, but not a lawyer, telling you, this is what I want you to do. I don't care what it takes. Don't tell me why you can't do it. Tell me how to do it. And then you have to go in there and take the policy, which, by the way, the policy can start as like, we should allow them to sell Cape Cod chips. It spirals into like, oh, well, what about other things? And can they do this and that? So you have to track all that, take notes on it. Then you have to write it up as an actual regulatory change, but not just a new statute. No, you have to go into the existing 160 pages of regulations for adult use, 138 for medical, and then find changes that you can make, adding new sections, changing existing sections, making amendments, redlining. Oh my God, it is the most complicated process you can imagine, ladies and gentlemen. Oh, Bunny, we're talking about how you allow social consumption. So the end point here is you all can have Amsterdam-style cafes in Massachusetts. But why politicians always say no one wants to hear how the sausage is made, this is why. Do you know how hard it is to take the idea of, I want people to be able to smoke inside at a bar-like situation and make it a regulatory change that then becomes state law so that people can get the licenses to afford you the ability to do that? Oh, goodness. Yeah, hashish den. Hi, Nancy. How you doing? But yes, Girl Scout cookies does not exist as a strain anymore. The Girl Scouts got upset, so that strain is now called GSC. Now, interestingly, Shannon O'Brien, the chair of the CCC, used to run the Girl Scouts in Massachusetts, ladies and gentlemen. What an interesting niche historical.
Thank you.
All right, we're back.
And now we are reconvening.
It's time.
We'll turn this over to our legal team that has been leading the way on the regulatory changes for social consumption. So I will turn this first to Attorney Bruno. You're going to lead the discussion. Okay, thank you.
Thank you, Madam Chair. After the Commissioners' deliberations last week, we have updated a draft, a final draft for Commissioners' consideration. Unless there are any other areas of discussion, we would present that for your final consideration.
That's too easy. Attorney Baker, are there any comments that you would like to make? And I'd just like to start out by, I said it off camera, but just thanking you both. And there were many people, Rachel, we had many people who were working on the team to keep us on track and moving. And I know this has been a long process, and I can't even imagine the hours you've spent and how many pairs of eyeglasses you've gone through looking at the fine print. So I thank you all, and I thank the team that supported them as well. It's a real feat. So I want to thank you very much. Are there any questions, comments? Commissioner Roy?
Thank you, Chair. I want to thank the legal team. DGC Baker has been at this for a long time. He's put a lot of hours and manpower, and then he got incredible Attorney Bruno to help him see this through. And we're very grateful to you. I'm grateful to my fellow commissioners, Commissioner Stebbins, you were part of this working group from the beginning, and Commissioner Benedon, you've come in the 11th hour, but you contributed significant contributions to this. I want you to know that, and thank you for that. As an aside, Chair, you had mentioned in your opening comments about the shelf-stable snacks, and they will be permitted in our social consumption licensees, but after promulgation, let me just step back. After promulgation, they will be permitted in our retail. Could we just take a moment? I've had a ton of questions. Point to for our retailers where in the regulations, so they know that they will be able to, once these regulations are promulgated, to sell shelf-stable snacks, which would provide them a different revenue stream.
Please, thank you, Attorney Bruno. Thanks.
Yes, this is under 500-140, Section 3. Subsection E, which states that a marijuana establishment may sell non-infused food, water, and drink items that are prepackaged prior to arrival on the premises and are shelf stable. The section continues, but that is exactly the PIN site that allows these retailers to make those sales.
That's again to restate that the retailers will be able to do this. It's a longer process for it to get to the actual social consumption grand openings when they do occur, because right now, once we do this, I was going to say the real work begins, but that's not true. You've done so much of the real work, but a lot of the more difficult, and we're going to be basically writing our own roadmap going forward. Using the signs that you have put together and making sure that it's done right, and working with communities to make sure they implement it as we have done, with a focus towards safety, public safety, but also making sure that people can have access to the products they're looking to share. Commissioner Roy.
Thank you. And, once we ratify this, I think it's important for the public, and you've been really good at this, DGC Baker, to just go over what's next with the promulgation, what the timeline looks like for that. I do want to thank my colleagues. There were things for me personally, the THC inhibitors or similar, type products to have that opportunity available for our social consumption. The quick recovery code type technology was, that's important for, consumer information, education. So I'm grateful to my colleagues around that. And, there is more work to do, implementation and, educating not only our licensees, not only our municipalities, but the public at large. And so that's a critical step, public awareness, public education. And so a lot more work to do, but today is a monumental day. Thank you.
Yeah, and Commissioner Bennett, please.
Thank you. And I just wanted to echo what Commissioner Roy said. I did come in at the 11th hour, and I promised that I would not be the cause of any further delay. But I do appreciate so much the staff and everybody here who helped me to get up to speed. And in doing so, I did have some questions, and I did note some points where I just wasn't sure that the language was as clear. And so I may have unintentionally contributed, hopefully, to a very brief delay while we discuss those. But this is very exciting, and truly I feel lucky to be able to be sitting here while we take this vote, knowing that I actually did very little to contribute to us getting here. But I think this is, to echo what everybody has said, an exciting opportunity. Will present new economic opportunities for equity participants and other small businesses. And we also have been very, very careful about emphasizing public health and safety. And I think we're ending up with a really great set of regulations. So it's been a great team effort.
Thank you. Commissioner Stebbins?
Thank you, Chair. And just also to thank my colleagues and a number of us who are going to be doing some work on the different implementation working groups. Again, I think to Commissioner Roy's point about what the next steps are, I think similar to when we made the changes for delivery, let's send a message. You can't run right out after these are voted upon and start having consumption events in your retail space. So just flagging that for any licensee who thought that's the way it works, but it's just a red flag.
No, it's a point well taken. And I shared this story with Attorney Baker when we were in Cambridge, and we were going to visit Diaspora, which is around the corner from a place that used to be called Grendel's. And this is why I knew that my cohort in law school might have trouble with constitutional law because the Supreme Court overruled the decision that allowed the banning of the sale of alcohol within a certain number of feet of school. And so once that was overturned, we figured, hey, the Supreme Court said we're going down and have a drink down there. And it was not legal yet. They didn't have a license. So that anecdote actually is very apropos of what you're saying. And so maybe, Attorney Baker, you can just talk a little bit about, once we vote, what does happen, and then maybe ask the executive director to give a little bit of a synopsis of the committees that we're going to be working with to roll this out and to make sure we have guidance and make sure that we have policies that follow on the regulations. So if you could just walk us through a little bit on that, please. Thank you.
Happy to do it, Madam Chair. Thanks. So the legal team will take this draft and double check it one more time before submitting it to the secretary. We did do that this past week, which is why we updated the draft for you all. But ultimately, we will work offline to submit this prior to the 19th. The 19th will be the day that the secretary receives it, and ultimately, should there be no issues, which we don't anticipate, January 2nd will be the day that they are officially promulgated and finalized.
So just to restate, official promulgation likely as of January 2nd, 2026.
Yes.
Okay. Thanks. And then, the executive director could maybe give a brief overview of the committees that we're going to be putting, we are already in motion right now, but maybe you can talk a little bit about that.
Certainly. Thank you, Madam Chair. So I think a couple things, obviously, we're looking at rolling out 3 new license types. And so there is some mechanical issues that need to be handled in that regard, as we've done as an organization previously. And so I did provide a little bit of history on the last time that a new license type was created, just for context. After the commissioners had done their final crossing of T's, dotting of I's, and the secretary approved, it was about 6 months prior to that license application opened up in the Mass CII system. Just for context, a number of working groups were created at that time as well. In this regard, because we have 3 new license types, we have a few different things going on here, and so we have structured accordingly. So an internal implementation group really focused on the IT aspects, which is creating these within our IT platforms, as well as I&E, which is creating SOPs for 3 new license types, has gotten underway, and that's part of what I'm reviewing now. Additionally, 3 working groups for specific purposes with sponsors from the commissioners, as well as external consulting groups that will be rolled up, are in as follows: the local community advisory, given the municipal aspect of this and the communities that have either stepped up as interested right out of the gate, or those who maybe be watching and asking questions, would have that working group providing direct information and really having that particular lens. A public awareness group, which may be covering a number of different stakeholders interested in public awareness. I'm sorry, I'll go through the sponsors too, just for reference. For the local advisory, community advisory group would be sponsored by the chair, Shannon O'Brien, and Commissioner Carrie Benedon. The public awareness working group sponsors would be Commissioner Bruce Stebbins and Commissioner Carrie Benedon. Both of those groups would again have external consulting. For local advisory, we're looking at MMA, Mass Mayors, the AGO local office, and some community officials, which the GAP team will reach out to. For public awareness, we're looking at DPH, local boards of health, EOPS, which is public safety, highway and gaming, as they have some overlap with us in this area. And a third working group sponsored by Chair Shannon O'Brien, Commissioner Bruce Stebbins, would be for responsible vendor training development. Obviously, a major component of the discussions the commissioners have undertaken, with external consulting from MPTC, which is police training, from EOPS, public safety, Mass Chiefs, DPH, Board of Health. And so GAP will now, at the end of today, with an approval vote from the commissioners, start to put together those external consulting teams. The internal teams have been assembled.
Thank you. Are there any further comments and questions from the commissioners? Commissioner Wright?
I just want to thank my colleagues for carrying these working groups. And I talked to the chair about this. Right now I'm on the lead on secret shopper, and lead on medical. And so my cup runneth over a little bit right now with working groups. But when those get in the rear view mirror, hopefully in the first quarter of the next year, I'd be, however, without violating open meeting law, however I can assist you, whether we call public hearings to talk about things publicly. But I want you to know how much I appreciate. I know the work is enormous ahead of you, and I just want to thank you in advance for that.
Thank you, Commissioner Wright. I was thinking that, but I'm glad you said it. So thank you. All right. For club to know this. I'm very excited about this. Get it done. Anyway, if no further comments or questions, if our legal team has anything further to add, I think that we've given a lot of information and context to what we're doing. So with that, Commissioner Stebbins, do I hear a motion to approve the final draft of revisions to 935 CMR 500 and 935 CMR 501 regarding social consumption?
So moved.
Do I hear a second, Commissioner Roy?
Second.
Having been moved and seconded, I will take a call of the roll. Chair, Commissioner Roy.
We honoring the will of the voters today. Aye.
Commissioner Stebbins.
Only because I know Mike didn't even show up with his laptop, so he's not excited. It's not fast. I'll vote aye.
Commissioner Benedon.
Aye.
And I would be remiss before voting, but we did recognize Commissioner Stebbins having worked on that, but in absentia, Commissioner Camargo for the work that she did on the committee here. So with that, the chair puts it over the top. 4 in favor, no opposed, and now the work outside of here is going to have to begin with the community. So thank you very much, everybody. It's passed unanimously. And so with that, we will be taking a brief break. We are going to be answering some questions from members of the media. We will about half an hour, you think? So we will, I'll give ourselves a little bit more. So I will entertain a motion to recess, coming back at 12:05, or should I say 12:10? 12:10. And then, people can maybe, I don't know if they're going to have time to grab anything to eat. And then we're going to be getting, more into the meat and discussion of some of the other issues that include both updates from the executive director, votes for treasurer and secretary, and speaking about the 2025 industry report and talking about testing. So anyway, I will entertain a motion to recess until 12:10. Commissioner Roy? So moved. Do I hear a second? Commissioner Benedon?
Second.
I take a call of the roll. All those in favor say aye. Aye. Opposed? The ayes have it. Back at 12:10.
All right, you watched it happen live, and we're going to take this press conference as well, ladies and gentlemen. Social consumption has passed. So the commission's in recess. We're going to remove that. We're going to remove that. Now, you are going to hear me for a second as I go into this press conference. All right, this is kind of an experience. You're going to have it with me. We're going to do it together. All right, and then I'm going to take the press conference live. I'm going to just do it. I'm going to take it live. We'll do it live. Channeling Talmom's friend Bill O'Reilly. So we're going to do this together. It's going to be an experience. I can't guarantee it's going to be very stable. And then you'll go back to the commission. Okay, so you'll go back to the commission, and then I will go eat lunch after this. Okay, so this is going to be interesting. You're going to watch a press conference live. Now, we've done other press conferences live, none that I've been involved in. But anyway, here we go. I'm going to try to get involved. Give me 1 second. All right, so I'm going to have this. You're not going to hear anything from them right away. All right, I'm going to leave my microphone on, so you will hear me. And then once the press conference starts, you will hear me asking the it's going to load. I don't know if, oh, I think it's going to load. There are no promises with it. All right, it is load. Give me a second. I got to post to like 4 different sites. Got to let the world know social consumption is a reality. All right, now it's loading. Look at me multi-toweling. But you know what? We're multi-toweling, and things are going to have to figure it out. All right, we are multi-toweling. There is no guarantee this is going to work. It's asking a lot, but we're going to try. We're going to try. All right, little towels. We are going to try our very, very best. You can do it. I know you can do it, little towel. You were born to do it. Forgive me, I'm also sharing the news across the interwebs. Not that you would even hear the press conference, because I'm going to wait to unmute it until it begins, but I am trying to join. Towel Computer is to his very limit, but he's going to do it. I have faith in you, Towel Computer. Alright, there we go. Alright, now let's see if we can get loaded into this meeting. Loading, gentlemen. Oh, it is a glorious day. Let me get this over here, not that. Let me get this over here. Alright, and then do that. Alright, speakers seem to be good. Alright, I'm doing it. You're not going to hear them until we're ready, but you are going to hear Little Towel. pushing Little Towel's computer to the absolute limit of its potentials. All right, it's trying. You got this, Towel computer. We all have faith in you. I have myself muted anyway. All right, I'm going to mute for a sec. Hold on. Okay, good. So the meeting hasn't started. Look at me being efficient, Little Towel. You're going to see double towel. Nothing like double towel, ladies and gentlemen. So we're going to see the press asking some questions, maybe about social consumption. At least me. I'm a member of the press. I'm a Little Towel. So you'll see me. And then I would just for lunch. Can we get them back doing governmental things so I can go eat? I would really like a towel cheeseburger. Okay, and I can't do that while I'm waiting in the waiting room. All right. So let me do that. All right, good. Done. I was posting things. I was sharing the news. Ladies and gentlemen, social consumption in Massachusetts is a reality, and I am a towel. Now, we're still waiting on one more thing to happen, which is the press conference. Have you ever watched a press conference involving towel in real time? Bossy Texas chick, you're hilarious. The funny thing is, some people watch the, a lot of people that, and I'm going to work on that. Anyway, the press conference hasn't started yet. They're probably just preparing, trying to wrangle up the press, get people ready. I am going to share news about social consumption on my Twitter, though. Why? Because I'm a towel. And you might be saying to yourself, sir, you're going into a government press conference calling yourself a towel. Yeah. You know what I'm saying? I'm a Little Towel. All right, so let's get this uploaded. The final vote. 1 second. Done. All right, that's done. Now we wait for the press conference to start. A lot of hurry up and wait in the world of press conferences. Alrighty. Everything seems to be stable, though. The most important thing is the stability of the connection. Now, you won't actually hear anything when the presser starts. I'll let them know I'm going to take it live. Then you'll see the presser on your screen. They're probably watching this. All right, we should probably get started. Grant's ready. Grant's going to take it live. All right. I'm monitoring. I guess I could bring this over here. Hold on. Okay. Well, that's going to get complicated. Well, all right. I'll figure it out. Okay. Everything is ready, ostensibly. Although I have no idea. Oh, here we go. All right, hold on.
Okay, so one wants to raise their hand. You can... Did everyone hear those instructions? I'm sitting. Yeah, I can see you.
on this. So I heard during the meeting that I think that the regulations should be promulgated somewhere in the beginning of January. And so I kind of want to ask, what from your estimates are the timeline for when, let's pretend it's me, for when I will be able to step into a cannabis facility, purchase some cannabis, and then consume it on site. I hope I was able to be heard. Yeah, I am unable to hear the CCC as well.
It could be, because we're running, because normally we don't have the public meeting going at the same time as this.
Got it. Send a message to the all staff, get off the Wi-Fi. So.
Because they're in the Wi-Fi.
It's the,
if you heard the executive director, that one of the last times that we had a new regulation for a new license type, it was approximately 6 months from promulgation, from when that licensee was able to, the first licensee was, I think it was Chris Fevry's a delivery company. They filed that application within about 6 months. There is a lot of work that's going on right now, and it's why we have these working groups. So over the course of the next 6 months, we're going to be working with municipalities to ensure which ones are going to actually, opt in and be involved in this. And they will have to draft their own set of SOPs to make sure this works. So it could be up to another 8 to 12 months after that. So when that last license type was allowed under regulations, it took between a year to 18 months. I'm hoping that some of these things can go more quickly, but there is a lot of work to do with the municipalities to make sure that they are ready, because there's going to be a lot of regulatory framework that is going to be controlled by municipalities, a lot of applications that's going to be managed by them. So I hope that makes sense to you. Could you hear that? Thank you.
Okay,
Yeah,
Katie,
thanks so
go
much.
ahead.
Me rather than Katie Castellani.
Elena, so, yeah.
Yes. So I'm curious, I know there was a few comments today about the idea of respecting the will of the voters. Can you just kind of address the significance of taking this big step towards something that was envisioned in the original ballot question?
Exactly, Katie, and thank you for the question. Obviously, this was passed in 2016, and then the legislature did go in and make some legislative changes to the original ballot initiative. The commission was stood up, and this has been fairly complex. As I noted, the working group, which was led by Commissioners Camargo and Stebbins, they were appointed over 3 years. of work. They did a lot of listening and hearing, and obviously the final version came together mid-year this year, and obviously with my return, and we added a new commissioner. That did take a little bit of time. But the important thing is this is the will of the voters. Some people may have some concerns because this is a little bit of a brave new world. We don't really know, we know what our local pub looks like, but we don't really understand what this looks like. And the will of the voters is also to ensure that those persons who would like to consume product, but maybe they live in public housing and it's against the law. It is more difficult for some people, especially those on the lower end of the economic scale, to access the same benefits to be able to get these products. And so that is part of the rationale. This is part of social equity. It's not just social equity where we're helping licensees. It's also social equity. We're helping those persons who would like to access products, who would like to be able to enjoy it in a social setting. These will be locations where everyone will be welcome to do that.
Okay, Yoga, go ahead.
Thanks.
Yoga from the Boston Hills, sorry.
Yes. And thanks for letting me speak, and congrats on passing the vote. I know it took a minute. I would like to ask about, concerns that were raised regarding whether this will increase impaired driving and what measures the regulation has in order to prevent that.
A couple of different things. First of all, we'll be working with public safety, law enforcement people on the local level. There will be approval there to make sure that there are ride shares, to make sure that people have a way to get home if they have been overserved. We will be reworking, and again, that's some of the challenges that we're going to have now over the course of the maybe next half a year, is looking at responsible vendor training. If you've ever worked in a bar and you're serving persons alcohol, you need to have tips training. So that's one of the things that we will have to create, is making sure that we have that kind of training for those people who are working in this industry. So ride share, making sure that all businesses have a transportation plan. One of the other things that Commissioner Roy spoke about earlier is THC inhibitors. Now, it's a little bit of a homeopathic remedy, but some people do find that if they've been overserved, this actually helps reduce the symptoms or the reactions there. So not to get into the entire regulation, and I do know that you have been sent a press release. There should be some things in there that will detail some of the public safety issues that we've addressed. And again, there's still a lot of work to do. And so some of that stuff will be the nuts and bolts that's going to actually apply to different licensees. We're going to be doing that work to make sure that we have public education, public safety, and public health always at the forefront.
Okay, we're going to go to James Bailey from WAMC.
There's two now, I think.
All right, James.
James Peligalopoulos. What were the biggest takeaways from public listening forums feedback? James, you're gonna have to wait till Commissioner Stebbins gets here, because a lot of the feedback from those public forums took place when I was illegally suspended. So I'm gonna pass on that question. You can raise that with Commissioner Roy, but in particular raise that with Commissioner Stebbins because he was a part of that and I was not. So do you have an alternative question you'd like to ask me, or do you want to wait until either Commissioner Roy can address that or Commissioner Stebbins can? Gotcha. Okay, thank you.
Okay, Brianna from NBC 10.
Hi, Brianna.
All right, we'll jump to Chris Ferron.
We'll come back to you, Brianna. Chris Ferron. Hey, Chris.
Hey, yes. So hello. So yes, congratulations. So I'm wondering. So some of the businesses in other states that commissioners visited, I think that's 2 years ago now, have gone out of business. That some of the models we've seen elsewhere are not working, and I know that your business is regulating, but I also heard some things in the discussions about concern about that sort of thing. So I'm wondering, what can you point to in the new regulations that would that you see as beneficial to people getting into this industry that maybe didn't take place in other states, that would maybe give them a leg up, that could be helpful in this, as we all kind of step into this area where nobody knows what really happening,
Well,
not a lot of experience here.
And Chris, these work will be looking at this. And one of the things you may or may not have heard me say that, we're getting this done to the best of our ability, but we also have opportunities to fix things, and to reset a course. For instance, the 2-driver rule, we saw that. It was an overregulation. I actually, tried to put it on the agenda in early 2023. It did take another year, but those are the types of things that as commissioners, we need to be nimble, responsive, and listening. But one of the big differences right now is that the legislature created a fund that helps people access, because the biggest challenge here, I think, is going to be access to capital. It always is when we're dealing, especially with social equity licensees or applicants. And so one of the things I hope that we can do is have, when the fund was first put in place, I called a meeting to talk to the folks over at Economic Affairs to see how we could work more closely with them. And I do think that there is some regulatory reform.
Anybody else see them frozen?
Yeah, they're frozen for me.
Other one.
Is on it.
Because we're getting short on time.
It's the VPN too.
I thought they were
Make the decision to do this in the middle of the day.
on track.
See if they could update that till 12:30. Longer. Okay, 12:45.
That makes me, is what it is.
Yes, okay.
Okay, Chris.
I just don't know if Chris heard the end of my answer. Did you hear the end of my answer?
But it was interesting. You said you did speak with Economic Affairs and the possibility, potential there.
No. I originally talked with Economic Affairs when the fund was first established to figure out how we could coordinate. And I think that that's going to be something that we need to continue to collaborate with municipalities, but also Economic Affairs. Okay. Katie Castellani.
Hi, can you hear me?
Katie? Yes.
So yeah, you mentioned in the past 7 or so meetings, you guys have made some changes to the regulations. I was just curious, could you walk me through any major changes to the draft regulations that you've made since the ones that were released in late July?
Sure. I mean, one of the changes that Commissioner Roy was fighting for, and a small one, but it's important to retailers, is allowing them to sell shelf-stable snacks. That's one change that was not. Commissioner Roy was able to get that added. Things like unnecessary regulatory language that I thought was not helpful. For instance, the cooling down rooms. I don't think that there was too much support for that. I felt that that could be costly. I also felt that even with a May, that could be undermining public health and safety, also allowing the THC inhibitors. So those are just 3 of the changes that I do think that, 1, gets rid of unnecessarily regulatory burdens, 2, allows additional revenue stream for retailers, and 3, helps us help those that are going to be hosting these events or these businesses, allow them to do a better job of taking care of overserved customers. Thanks, Katie. We're going to keep moving on because we've got a lot of you, and I just want to give everyone an opportunity. Is that Mike Norton?
Same outlets. It says AI. Bill Sheeran from WZBB.
Bill Sheeran?
All right, we can skip to Grant Smith Health.
Grant?
Hello, Madam Chair. Thank you for all of your work on this, and to the commissioners. My question is about event licensing. One thing covered under this change has to do with people who organize cannabis events, host them. Could you talk a little bit about how that will impact the CCC's role in oversight of those events going forward? Thank you.
Thank you. And this was obviously one of the places that we needed to be very, we needed to listen to our investigations and enforcement team. And also this is one of the places where we wanted to make sure that we were improving public health and safety. Commissioner Roy, we actually went back and forth about the issue to make sure that sales and consumption in terms of being behind or not visible to children. That's actually one of those complex things that comes from the statute that we had to work on. But I ultimately think that this might be the easiest one for people to get involved in over the long haul in terms of cost. So the bottom line is we put in place a number of different provisions where we can make this as fun and as exciting that maybe an outdoor yoga goat session or a music festival could be, but making sure that we're working closely with municipalities and law enforcement officers and public safety to make sure that we are consistent with the prohibitions within the statute and making sure that we made that as seamless as possible, but also maintaining public health and safety. And again, I direct you to the press release because I do believe that some of these specifics are contained in there. And if you do have some specific questions, I suggest anybody put this in writing because we have a lot of people asking questions and we're trying to get through all the commissioners. So again, I apologize. This is kind of truncated a little bit.
Will Catcher, Mass Live.
Hi, yes, good morning. So state that gives a lot of power to the local level. What's your pitch to towns for why they should allow these businesses or these licensed events? And then on the other side, what is your message to residents who might be living nearby or in a community with one of these incoming businesses for why it is something that they should not try to block at the local level as it tries to gets passed?
Well, again, you see NIMBY, whether it's they're putting a hair salon 2 doors down from my house, and I like the nature of my neighborhood. I've seen that happen growing up in my own hometown. So obviously there will be that, but there have been a number of items put into place. Commissioner Roy, in particular, was fighting to. I'm trying to remember what the delineation. It was premises versus property line. And obviously there is an odor issue. So we made sure that there's very strict requirements for not only ventilation in the event of smoking, but also odor mitigation. That's going to be something that will be managed by the community. Just in, as now, even with retailers, there are odors, there are smells, and community leaders, are dealing with this, and they're responsive to their local constituents. So I think we tried to strike that right balance to make sure that any of the sort of negative elements of a business or that some people might perceive as a negative element are managed, and we give the communities the right tools to be able to make sure it works for that community. So I hope I've answered your question, at least partially. Thanks, Will.
Thank you.
So WCDB, have we talked to WCDB yet?
We've got 3 from WCB here. So whoever, if one of you could go, if you're here and ask a question.
We have Emily from WCDB. Emily, are you there? Go to 10.
All right, let's WJAR is Tim Scott, Rhode Island City. Tim, you there?
Tim Scott?
Yeah.
Any last questions for the chair? Katie Landon, are you still there?
I'm here, but I'm all set.
Okay, thank you. Oh, we went to her. Okay, who am I? Oh, Brianna Borghi. Sorry. Brianna Borghi from NBC. Any questions? Brianna, if you can hear, can you just let us know in the chat that you can hear? Well, is there anybody that hasn't had the opportunity?
Yeah, anyone else want to ask a question for the chair?
Okay, thank you. Thanks.
One from
Is that somebody? Oh.
That's Philip from APM.
Hey, Hi. I just had one other question. And this is the answer to this could be nothing, but there is currently a ballot initiative that is moving through the state of Massachusetts, which would be a very serious disruption to the recreational cannabis industry. It would pretty much completely dismantle it, and it would impose some new limits on the type amount of cannabis that people can carry. Does that factor in at all for you guys? Does that feel like something that is worth consideration as you sort of move through these new regulations, or is it not something that is on your guys' mind at all?
All I can say is that, as commissioners, we're not really going to be commenting on the ballot question one way or another, at least, in our official capacity. But what I will say is we just have to put our head down. We don't know if it's going to pass. We don't know if it is. We have to put our head down, and our job is to make sure that the public understands that if this is legal in Massachusetts, it needs to be safe. It needs to be transparently priced. And we need to be doing our job to protect the public's health, safety, and welfare. And ultimately, that's what we've done with this piece of legislation, working in concert with the municipalities. But we really don't know we don't know what's going to happen with the bill on Beacon Hill. We don't know what's going to happen with the referendum. So we're just going to do the best job that we can to make sure that all of the recreational and medical cannabis in Massachusetts is safe, and the public's health is protected, and that's what I think we've struck a balance with this set of regulations.
Yeah, she's able to. Question. Let's go on.
Just quickly, what is it?
Can you speak to how these licenses will benefit local dispensaries? Can you speak to how the license?
Oh, well, one of the issues is some of these local dispensaries could apply for licenses. They could partner on events. They could look at the footprint or add to the footprint. So those local dispensaries will have an opportunity to take advantage of, through a supplemental license, take advantage of what they're already doing right now and find new ways to reach out to their customers. There was just a piece on CBS News last night, talking with a retailer, I believe, in the Newberry Street Back Bay area. He's very excited about doing something like that. But again, this could benefit some of those dispensaries, depending on how they look at this law, whether or not they want to do something on site or whether or not they want to create partnerships to develop new revenue streams. Thank you.
Next, going to bring up Commissioner Kimberly Roy. You want to do the same order?
Sure.
All right. We'll start.
No, actually, let's do reverse.
Okay. All right. Well, WCBB, Emily, or anyone from WCBB wants to speak up. Great. Tim Scott, WJAR. If you can't hear us, let us know. But otherwise, we'll go to Will Catcher.
Hi there, Commissioner. I was wondering if you might just be able to elaborate on the question I asked the chair about why a town should want this. What benefit it actually has to the town as a whole, and then on the flip side of that, why a community member who may be irritated by or upset by one of these businesses or events coming in, why they should not object to it.
Sure, and thank you for the question. Well, ultimately, it's up to the communities and the municipalities if they think this license type is a appropriate fit. I had the opportunity to go on multiple municipal tours. I went to Holyoke, Provincetown, and in Somerville. Obviously, Provincetown is a high tourist area. Holyoke is a gateway city, and for different reasons, they expressed to us why they found this license type to be appealing. So ultimately it's up to the communities if they feel this is a good fit. So far, it's my understanding, Will, that the following communities have expressed interest: Cambridge, Chelsea, Fitchburg, Haverhill, Holyoke, Provincetown, Somerville, and Worcester. So those, I've been informed, those communities have expressed interest early on. And, you know, as far as folks who may be concerned, I sit in the public health seat. You know, obviously we never want anyone to drive impaired. You know, when I became a commissioner, that was front and center for me. I helped develop a curriculum, you know, see that through this initiative where young people learn about the dangers of impairment with cannabis behind the wheel. And I bring that lens to this license type. Some of the things that we'll share with the public that licensees will be required. They will be required to have food on site. There will be alcohol prohibition, no commingling cannabis and alcohol, strict ventilation. There'll be public education on the site, inside the licensee. And I advocated for QR codes or technology similar to a quick recovery code. We're going to inform consumers the onset of action on edibles, and some folks can take over an hour to kick in. And so the product types, we'll discuss that as well. We'll also train bud tenders to recognize signs of impairment. We will also allow social consumption licensees to carry THC inhibitor type products, which has, in speaking with smoking clubs unregulated, they find these products enormously helpful. This sales of cannabis products will cease 30 minutes prior to the business closing time. And all licensees will have to have an approved transportation plan to assist folks who may be impaired. There'll also be coordination between the licensee, the municipality, and public safety, and they will submit a public safety plan to the commission, signed off by local, public safety officials. So those are just a few of the items that we baked in to safeguard public safety.
Chris Phillips.
Thank you. Commissioner, earlier I asked about events, and I'm just wondering from the public health and safety perspective, this seems to be a drastic change to the ad hoc events that have been taking place related to cannabis before. How much did the commission think about the existing landscape as you fashion this new set of rules related to events? Thank you.
Thank you, Grant. What we did was try to strike a balance, obviously prioritizing public health and safety with feasibility. I think the original iteration locked folks into a more limited number of days. I advocated to expand that. Someone might have an event where, based on the time of the year, in the summer, they may want to be in the Cape. In the fall, they may want to be in the Berkshires. And so I advocated for the ability to move that around. Obviously, it will be just like alcohol events. There will be a lot of local control on what these communities will, want to see. Obviously, they will have to comply with our regulations in the statute, but there will be an enormous amount of local control over these. And, we put safeguards in place. I know the chair and I, we agreed to disagree. I, wanted to make sure that young people, young children weren't, exposed or seeing this particularly when it came to the smoking. And, there are, secondhand effects to that, as far as the seltzers and the edibles, not so much. You can't tell, from a can if it's a regular seltzer or a THC seltzer. So we put additional safeguards in place. Obviously, we want this license type to be, economically feasible. And Chris had asked a question, if I may, about that and what makes Massachusetts maybe different. And, this is 3 license types. So with a cap of 3 under each one. In Massachusetts, as the current statute reads, you're maxed out at 3. And so everybody's level set at 0. So you could be 3 retailers, 3 product manufacturers, 3 cultivators right now, but you will have 0 social consumption. And what I mean by that is there could be opportunity for partnerships, joint venture agreements, right? So these are equity licensees. So you have to have over 50% social equity to be able to get this license. But that leaves room for underneath that, 49+%. And, speaking with banks, in access to capital, look at, capital, collateral, and capacity. And so even the folks that are maxed out in those other license type, everybody starts at 0. And so maybe that's something that these licensees will consider, a joint venture agreement or partnership to help, these air handling systems are up to, upwards of $1 million. So that's very capital intensive, but I just want to kind of bridge your question, Fran, with Chris's earlier question about how this could possibly be economically feasible. So Brant, I hope I answered your question.
Yes, thank you, Commissioner.
We'll go to Walshe from WCBB if you're here with us. Okay, we'll jump to Kathleen from Data Servers.
Hi, I just wanted to clarify an earlier question that was asked that Chair O'Brien answered about the timing of when these licenses are expected to be rolled out. I understand there needs to be some work with the municipalities and some work groups, but like around when do you think people could start consuming cannabis at businesses?
Sure. Well, it's not set in stone, but generally, these regulations should be, we're hopeful, promulgated the flip of the calendar, January 2nd, 2026. Based on our previous new license type, which was delivery license type, from that day, it took approximately 6 months to get the application portal open. So then, once we received the applications, it took around 11 months for the first commence operation for that license type. So you add that 6 months plus the 11, so a year, so 12, 18 months. I would just, it's a guesstimate, but based on previous license type, that's a rough estimate, and hopefully that helps.
Okay, got it. Thank you.
Okay, Chris, Ron, do you have any questions?
Yeah, I mean, I don't know if this is, I was trying to follow, but you all just went for so long, for so many days. With, as far as alcohol is concerned, I was interested early on to see that, alcohol went from being a completely, let's not even talk about it, to we have to figure out how it factors in. So can you just give me like the example, like for an event, are you gonna have to be choosing a booth event or a cannabis event, or where does alcohol fit in, if it does at all, and what are the precautions?
Sure. And thank you, Chris. And so when the first iteration came through in 2024, there was 100% prohibition on alcohol, 100%. And then I said, I don't know if you remember, and maybe you're watching those days, I said, is this truly practical in the real world? 100% prohibition on alcohol. So what could be practical in the real world? And we have the example of you're at a hotel and, and so with that hotel, just pick alcohol or cannabis that day. So, one wedding could be a canna wedding, and down the hall could be, open bar wedding. And, we have licensees with multiple floors. I visited them. And so, one floor could be, if they get an alcohol license within their community, one floor could be alcohol. And then another floor could be cannabis. Now, having said that in our regulations, you can't put your alcohol floor and your cannabis floor in the same floor, if you will, but they could exist under the same rooftop, just in different areas. So I think that was a nice compromise from 100% prohibition to, okay, we can allow it under the same roof, just not in the same premise, if you will.
Thank you. And can you also just do that list again of the municipalities that were?
Yep, it was shared in I believe it's in our board book too. The following municipalities have expressed interest: Cambridge, Chelsea, Fitchburg, Haverhill, Holyoke, Provincetown, Somerville, and Worcester.
Thank you.
Thank you.
Okay, Brianna from NBC, if you want to drop a question in the chat.
Can you read it?
Yeah. Just in the interest of time, Brianna, we'll get back to you after. We'll go to James from WHMC first, and then if you have a question, just put it in the chat and we'll come back to it. Go, James, good question. Okay. WHMC. What were the biggest takeaways from public listening forums feedback the CCC has received on the drafts?
Okay, so I was not part of the working group, and the working group did fly across the country, met with social consumption states that were already open for business. I did meet with locally with Holyoke, Somerville and Provincetown. And for different reasons, they expressed interest. Those were very robust meetings with all facets of municipal government representatives attending them. Obviously we want to prioritize public health and safety. The police chiefs were actually at a number of the meetings that I attended. Obviously you're going to hear feedback, folks that are supportive of this and folks who have concerns. And as I said in my opening comments, and as I said when I voted today, we honored the will of the voters. And this goes back to 2016. This is a decade almost that they waited for this. So what we did was we tried to listen to the folks that expressed concerns. And as I listed all of the precautions that we baked in. So no one wants anyone to get behind the wheel of a vehicle impaired on cannabis. So we have rideshare plans. We have our bartenders are going to be trained to look for impairment. We're going to have, no serving products 30 minutes prior to closing time. Food and water will be served. We'll have these newer products available, THC inhibitors that I've heard great things about helping people who may be greening out. And we don't want anyone, greening out uncomfortable. We will continue to listen. We're a public agency. If the legislation passes out of Beacon Hill and the purchase limits go up and there's changes to advertising, we're going to have to go in very quickly to make these adjustments to these regulations. So, and the other license types, we've made adjustments to delivery, 2-to-1 driver rule, micro businesses. We allowed them to scale. I'm currently also working on the research license type. So these aren't set in stone. These are always a work in progress, and we will continue to solicit feedback and listen to stakeholders, those who are supportive and those who have concerns.
Okay, we'll jump to Yoga from the Globe.
Yes, thank you. Commissioner, I would just love, I don't know if you can see me.
I can, but I can hear you, so.
Thank you. Commissioner, I would love kind of a big picture comment from you just on what this means for Massachusetts. These are going to be the first regulated marijuana lounges in New England, as far as I know. So this is really huge for the industry, but I would love to hear from you. You've been working on it for so long. What is the big picture here? Like, why should we be excited about it? Anything that you can say to that?
Yeah, and not to sound like a broken record, but again, today we honored the will of the Massachusetts voters, and they voted for this in 2016. Here we are, almost in 2026, and we got it across the finish line. This license type is an exclusive license type for SCP or EEA, and that will, we heard yesterday from a retail licensee in Boston, and he is excited about this opportunity. And so this could be another revenue stream for those folks. Also, as Chair O'Brien alluded to, this is equity on both sides of the equation. This is for the equity license type as well as for the equity consumer, if you will. If you are a tenant and you're in a rental property or you're in federal housing and you have no ability to consume that way, this will afford those folks that opportunity to consume in a safe space where products are tested. So we want to make sure it's a safe space. We have gone through great lengths to deliberate on how do we incorporate public health and safety safeguards. I think we've achieved that. We will continue to monitor that. But today is another milestone, in the Massachusetts cannabis industry.
Okay, Philip from NEPM.
Oh, there we go. Just unmuting my mic. Actually, my big question was actually, and you kind of spoke on this in your last answer a little bit, was I was going to ask social equity. That has been a big part of Massachusetts' push to have a regulated cannabis industry, is to try to sort of make up for some of the impacts on the war on drugs on some, more vulnerable populations. And that was going to be my big picture, is how does the commission plan to continue that initiative as they, enter this new license type and this new sort of arena for the cannabis industry?
Sure. Thank you for that question. And, we always hear the biggest obstacle is access to capital. And so we have this brand new license type under the social consumption umbrella. We have 3 different tracks. Some might be more capital intensive than the others. So you have the supplemental, which if you are SCPEA and you have a brick and mortar retail, you might find that more appealing. Now, having said that, right, the air handling, if you're going to have indoor smoking, then there's a significant requirement for air handling, which is costly. And so then you have your event organizer and then your hospitality, which might be less capital intensive and might be an easier path forward for some of our equity folks. And also, as I said earlier, everybody is level set at 0 right now, whether you're a big operator or a little operator. And what does that do? So for access to capital, that could provide an opportunity for partnerships in the cannabis space to help move it forward. So, hopefully, our equity licensees will be able to take advantage of this new license type. Again, we will continue to hear feedback, just as we have from other license types in the equity space, like delivery operator. They were very vocal to us that the 2 agents in a car was not economically feasible. We looked into the public safety aspect of that, the notices of efficiencies to make sure that there were no glaring public safety issues, and there were not. So we were able to go in and remove red tape. We will continue to examine if there is red tape within this license type. We will examine it. It was my idea to create the red tape removal committee and working with chair. And so that encompasses all aspects of the Massachusetts cannabis industry. And, we will continue to be supportive of our equity licensees. We have the Social Equity Trust Fund. We don't oversee it, but I know a lot of folks have benefited from that as well. And so that's kind of a unique thing. I don't think many jurisdictions have that. So that's another opportunity. But again, access to capital, with the federal illegality of a product, you can't cross state lines. You can't ship it across federal airspace. You can't cross the water with it. You have no bankruptcy protections and limited access to capital. It makes it very, very, very challenging.
Okay, thank you. We're gonna jump to
Thank you.
Commissioner Bruce Stebbins now.
Thank you, everyone. Thank you for joining us.
Bill, if we can start with you. Go ahead.
All right. I think that I would love to, since I understand that Commissioner Stebbins was also involved in some of the working groups and some of the listening sessions, I want to, and I feel like I'm cribbing a little bit on some of the other questions here, but because you picked on me first, I want to ask a little bit about, some of the key points, throughout these listening sessions, that really sort of rose to the top as you were putting together these draft regulations and these now finalized regulations.
Wow. Great question, Philip. For me, one that comes to mind, we heard this not only from the industry, but we heard from it from our public health and public safety stakeholders, and there was a chorus about the need to train agents that are going to work in social consumption establishments. So it was unique that we heard from both our public health and safety stakeholders in the industry say, we want training to make sure, I'm sure it's been pointed out, to recognize signs of impairment. How do you help a customer who might have an adverse reaction? How do we make sure we're checking IDs to make sure nobody under the age of 21 gets into these spaces, as well as how do you make sure you're watching for people that show up at a consumption site with product that they haven't purchased there. So one real quick answer, and there are a lot of them, but the one that resounded with me was training, both a request from the industry and a request from a lot of those public health and public safety stakeholders that we talked to.
Okay, you'll get from Boston Globe.
Hey, Commissioner Stebbins. First of all, congratulations. I know you spent a lot of time working on this. I'm just going to direct the same question that I asked Commissioner Roy about your kind of excitement about it. Why should we be excited about this? What this means for the industry in Massachusetts, in New England? Just kind of your comment on that. Thank you.
Thanks for the question. First of all, it's
really congratulations to the entire CCC team for getting the work done that we did today, and all the work that led us up to this point. I think for me, and because commissioners aren't always all in the same room when we do these, so I apologize, I might be repeating some of my colleagues' answers. But, you know, this is an exciting opportunity to expand the marketplace. This is an exciting opportunity to help our social equity participants, some who I think it's been said have been waiting around for this license type to actually come to fruition. We've heard that a lot in the listening sessions that we had. I'm excited, obviously, the opportunity to create more jobs, obviously the opportunity for more revenue for cities and towns in the Commonwealth, the opportunity for maybe more consumers to venture into the marketplace and try out different products, especially if they haven't been frequenting a dispensary to date. And I also look at a tremendous opportunity for the tourism and hospitality community. We have folks that flock to Boston, Massachusetts as a tourist. Some come from countries or states that don't allow cannabis use. I think there's a tremendous opportunity, and it kind of fits in under that hospitality license model that might be attractive, again, for the millions of people that visit Massachusetts each year. So lots of different success stories. Hopefully we're going to be able to point to from an economic perspective, from a job creation perspective, and just expanding safer use of cannabis and cannabis products across Massachusetts.
Okay, we'll go to James from WAMC.
Chair.
What were some of the major changes the draft saw leading into today? Great question, James. Thank you for that one. You know, I think this is evident every time we've approached regulations. We have commissioners that work on presenting a draft form of regulations, and then the rest of the body gets to sit in and talk about considerations and changes they might like to see. I think the conversations we had around exclusivity were helpful. You know, exclusivity for each license type instead of the exclusivity period starting when one particular licensee would commence operations. I thought that was a good conversation. Expanding events. We started off with a certain number of days of events because we don't want an event organizer to necessarily be competing with a brick and mortar establishment. So I thought those were some helpful changes. A lot of the discussion we got into around transportation plans, I think, was helpful. You know, how do folks support and help a consumer who might either over consume, which we hope doesn't happen, or if they have an adverse reaction. So those were some of the areas that I appreciated my colleagues throwing in their 2 cents, making some changes, and supporting, I think, what at the end of the day is a very strong regulatory framework, and one that we hope will be successful. Hopefully that answered it for you, Jay.
Okay, Christopher Owen.
Thank you. So congratulations to all of you. And, you know, but you, Commissioner Stebbins, have really, you've been at this for quite some time. And it's what, 2 years almost since your trip, or since the trip. And I was wondering, what major changes, like what did you go in thinking about this and what this might look like? You know, any real changes of course or changes of heart, whether it's around where alcohol might be in this, which I just asked Commissioner Roy, or make something more general. And I'll just project, I'll say, you know, for me, I was just kind of surprised from the get-go as to how broad they were and how kind of how much opportunity there is. I don't know if that's how you saw it from the get-go, but you know, what's been your big change since, you know, having front row seats to this whole process?
Great question, Chris. And I know we have limited amount of time, so I'll try to boil it down. I think what stood out for me in the feedback that we got from folks that do want to pursue a social consumption license really is around the evolution of the hospitality license type. That we kind of, pulled together from, the trip that Commissioner Camargo took out to California, the visit I made to a consumption establishment in Colorado. To be honest with you, that to me is where I hope to see a lot of the entrepreneurial spirit and creativity come about. So that was a big one for me. By the way, I have to thank, they probably won't see or hear this, but I got to thank all of the other jurisdictions that we talked to along the way that were a big help. And even the jurisdictions who have since reached out to us and asked us about our framework, which right now only exists on paper. So good to have those conversations. I will tell you, I had a conversation the other day with a gentleman out in Las Vegas who's trying to pursue a consumption lounge. I was listening to what his plans were. He talked about consumption and a restaurant attached. I think that's where, with the help of DPH, we're going to allow that connection to actually happen between food consumption and cannabis consumption. And as we approach the end of the phone call, he goes, wait a minute, do you actually have a trust fund that will help people build out these kind of operations? He goes, I'm blown away by that. So I think Massachusetts is well positioned with the right tools to make this successful. And I'm encouraged by the response that we've gotten. I'm encouraged really by seeing what the potential for the hospitality license type can do.
Thank you.
Thanks, Chris.
Okay, I'm going to Katie from City House Youth Service. Can you hear us?
You're on mute, Katie.
Hi, sorry, I think I got my questions answered. Thank you.
Oh, thank you.
We have next Bill Sheeran and several other WCBB accounts. So yeah, feel free to go ahead. Good. We'll go to Brent Smith-Ellis.
Thank you. Commissioner, you mentioned events a little bit earlier, but one of the big changes here is that kind of an ad hoc event structure that's been around for decades is going to get regulation imposed. How did your experience looking at these events inform the way this new structure is set up? Thank you.
Thanks, Grant. Appreciate the question. For me, when it came to thinking about the event organizer license, I was looking at what can potentially be a license that has a lower barrier to entry. If I'm just organizing events, I'm not trying to build up brick and mortar. Is that an opportunity for one of our social equity applicants to be able to kind of get in on the ground floor? So that's one part of it, Grant. I think the other part of it is we looked at somewhat existing events that go on and who might benefit from this license type. When I think about, what NECAN attempts to do, in terms of, building in, competitions or consumption around their event. I took into consideration Boston Cannabis Week, which I think does things stretched over 5 days. So those were some of the kind of just local organization events that we know already exist. I think the other point that rang true for me is that, and we share this with a lot of the stakeholders we have from the public safety community, social consumption is already happening. It's just not happening in licensed facilities where there is a purchase transaction happening. But we know there are events where people are invited to bring their own. What we're trying to do is, give some regulated grounding to that where folks can go make sure that they're around safely purchased and safely tested products. So I'm excited for that license type too, but I think, Grant, to get back to your question, it really was, some of the things that we knew around what NECAN always would like to see happen, Boston Cannabis Week, people raising the idea of events with us in general. And I think that kind of came up during the team's visit out to Provincetown, how it may not be something that's necessary or viable all year round, but might fit into the heavy visitor months. So it was a lot of those factors that really helped guide the direction, or at least the initial proposal for the event organizer license type.
Okay, next we can try WCBB again, either Bill or the WCBB account itself.
They're just recording it.
Okay. All right, we can go to Tim Scott from WJAR. Okay, I guess we'll go on to Commissioner Carrie Benedict from now on, unless there's anything else for Commissioner Stebbins.
Thank you all. Appreciate it.
Thank you.
Okay, you want to go first?
Sure, Commissioner Benedon. Oh, nice to meet you. I guess my most immediate question is really, you joined this after the commission has already discussed this for months. I'm curious, jumping into this, it's like a 500-word document. What was your experience going over this? Did you come in with any ideas, and I guess what changes you drove in the month that you've covered this? Thank you.
Sure, thanks for the question. When I came in, I had made a commitment in recognition of the substantial work that had already been done by commissioners over the course of several meetings, as well as hours and hours of work by staff, that I would not derail the process, and I would focus really on the provisions that were yet to be discussed at public meeting. I did, of course, review all of the revisions to the regulations, and I did have some questions. And I would say that the perspective and input that I brought, being fairly new to this space, focused largely on strong drafting, clear definitions, enforceable regulations. And so a lot of the suggestions that I made perhaps were less of a policy nature and more of making sure that what the regulations say is consistent with what we are trying to do. So really focusing on my background and expertise when it comes to drafting and enforcement, and making sure that we had a really strong set of clear and readily understandable and enforceable regulations.
James from WAMC. Okay.
You put this in the chats. Is that good?
All right. City Grant Smith-Ellis.
Thank you, Commissioner. It's a pleasure to meet you.
Likewise.
My question is about your perspective on the agency as you came into this role, and how you thought the social consumption process coming to fruition either reflected a commission operating smoothly or with some bumps. Thank you.
That's a good question. And as I have said at a couple of public meetings already and separately to staff, I have just been blown away by the dedication of the staff that we have, the dedication of the commissioners, everybody's commitment to really ensuring that we are carrying out the will of the public, of the voters. And I truly feel like everybody has been working well together. I, of course, came into this role well aware of the press. And my experience has been that everybody here, commissioners and staff, are dedicated and doing truly the best work in order to implement the will of the public.
since that's the end of all the reports are here, but does anyone else have any follow-up questions for the commissioner? All right, well, thank you very much, everyone. Thank you.
Thank you. So, what did you think? Your first ever press conference. It's done. Let me out of that. What did you think? It went pretty well, right? It's interesting to do a press conference. Did you like my question to the new commissioner? That was it wasn't a loaded question, but it has a lot of political resonance. Like her perspective as an expert in open government coming over from the AG's office as the newest appointee after Shannon O'Brien won her lawsuit to come back as chair. Like her answer to that question is going to speak a lot. Like if I were a legislator, that's what I would want to know. What does Commissioner Benedon think about the current efficacy of the functioning of the commission? She gave it a very, very stellar rating, and her opinion matters, let me tell you. So that was an important question. I don't know if my colleagues picked up on it. I know people in the chat picked up on it. Thank you for watching, Bunny. So we are not done. If you're just tuning in, that was a very rare midday CCC press conference. So here's how this is going to work. You all are going to watch the actual CCC meeting, okay? They're going to go back and they're going to have presentations and you're going to learn more about the regulatory agency. But you just got to see a press conference. Normally we record them. I did tell them I was live streaming today, but we've never done a live CCC press conference. Over 80 of them going back to 2018 every month, except for when I got banned from them for a while. We've never done a live one. That was wild, and it was the biggest one we've ever had. Like 18 members of the press at one point. I've never had to wait that long to ask a question. Normally it's like me and then Steph Solis from Axios and then maybe somebody from the State House News Service. That's it. Maybe Mass Live comes sometimes, and then occasionally like CBS will pop in, ABC will pop in. We all know each other, like because of all the years. But the point is, there was 18 people there today. I was like, what is going on? Bossy Texas Chick was like, I remember my first question ever to you. I couldn't understand how you had a Karen cam when no one else did until they all copied yours. Yes, I got permission, unlike the rest of them, to have a Karen cam. And then they were like, wait a minute. He has a Karen cam? We got to have a Karen cam. Then they all started using a Karen cam. Oh, goodness. The life and times of Little Towel. In any event, that was a great press conference. I appreciated that all of you tuned in. I'm going to turn you back over to the CCC. Bossy Texas Chick and Bella are going to be in charge. I'm going to get lunch. So enjoy the rest of the hearing. That was a very big press conference. I've never experienced anything like that. I hope you all thought I did well. Apparently, I have a press conference voice. I didn't know I had a press conference voice, but I guess it makes sense. I don't talk to the commissioners as if I'm live streaming. I think that would be a little strange. I try to get into my erudite voice and et cetera, et cetera. So, No, different O'Brien. This is Shannon O'Brien from the CCC. Bossy Texas Chick, I will get you a article. Let me see. Grant Smith Ellis. Let me see. One of the articles. I wrote about that case for like 3 years. That was like intense. People never even like read my journalism on Twitter. They're just like, Grant doesn't talk about that much. You know, oh, really? Have you read my history, ladies and gentlemen? I am a little towel. I was literally mentioned in the ruling by Judge Gordon multiple times. And Judge Gordon called me a journalist, and I really felt that was spiteful towards the CCC's press team. I just want to say I am a little towel. But anyway, you're going to go back to watching the CCC. I'll be with you. I'm going to go make my chicken. That's what I'm going to have for lunch. I'm feeling some chicken. So you all have a great time. I'm going to turn you back over to the CCC at 12:45. We have social consumption in Massachusetts. It's been a day. I'm an excitable little towel, although it is a sad day. It was easy for me, I guess, to get lost in the distraction of my work, but the news about my grandfather has made me very sad. But that is the nature of being human. We must have our ups and downs. We wouldn't know the down moments without the up moments, and we wouldn't know the up moments without the down moments. Grief is like shipwreck in a storm in many ways. It hits you in waves. Oh, well, I'm a towel in a storm, ladies and gentlemen, and I am here with you. My name's Grant Smith Ellis. As you can see up on your screen, you are going back over to the Cannabis Control Commission. You might say, Grant, I can't wait to learn about more regulatory matters. Oh, I'm thrilled for you. You have no idea. I'm absolutely thrilled for you. I want you to just learn about regulatory affairs. It's technically a court. It's an Article 1 court compared to an Article 3 court. An Article 3 court is a criminal and civil court. But it's a court, ladies and gentlemen. It is technically a court. So you're learning about things. They just happen to be doing like regulatory matters. No, maybe you don't find that interesting. Whatever floats your boat. Always, bossy Texas chicken Bella. I will always continue to broadcast from time to time, no matter what we're doing. I appreciate it. Thank you, Nicola. Thank you for your kind words. I thought today was a good culmination. That was like all my skills together. When I first started doing this all those years ago, oh my God. Want to see a picture, by the way, of Little Towel when he was starting law school versus when he finished? Apparently, I am an adorable little towel. Someone called me handsome. Someone said that I lost weight and hair, which, I mean, stress will do that to you. So are you really surprised that I had less hair and less weight? By the way, when I used to be like bigger, because of my surgery scar, it put so much stress on my back. I literally tore muscles in my back and couldn't walk. Like I had to have a cane for periods of time. It was very scary because of stress that was being put on my back. But take a look, ladies and gentlemen, at this. That's me. That's Towel the day he started law school, and then that's Towel the day he graduated. What do you think? Can you see me in there? Can you tell I'm the same person? Younger Towel at 33, older Towel at 36. I age backwards, if you ask me. You can say someone ages like fine wine, but I think I aged backwards. All right? I'm telling you, someone texted me today, and they were like, I thought you were like 26. I'm like, no, I'm 36. So you know what I'm saying? I am a towel that ages backwards, and I just want to note that for the record. All right, see? Younger Towel, older Towel, but you would think it's the other way around. You'd be like, no, that is not possible. Yes, it is possible. It's clearly still me. Oh, I am healthier. I think I'm healthier. I have different physical issues. So the weight loss, the stress, the colitis all have their own effects. Being skinnier puts less pressure on my back, but it puts a lot of pressure on my throat and my esophagus and airway. It really messes with like my facial nerve, my optic nerve. Like I'm always in pain, but I just try to cope. But yeah, being overweight, there was different. There was like more room for my belly, but less room in my back. And so because my belly had more room, my throat was a little bit better and my face, but I mean, it was still rough. And then as I started losing weight, it got horrible. But when being overweight or just bending over, I was at risk of tearing my back. I was bedbound for 6 to 9 months at one point when I bent over because my belly was so big, but I was sewn together as if I were like the weight of an 75 pound person. You can tell I'm like 240, 260 on the left. Oh man, let me tell you, that was brutal. It's one thing to have like weight loss and gain, but imagine losing 130 pounds, getting an abdominoplasty to have the skin removed when you're 175 at age 19, and then by age 33 being like 260. All right, your body's going to be like, what are you doing to me? You don't have the elasticity to stretch out your skin. So if your belly gets stretched too much after an abdominoplasty, it puts a lot of tension on your back. I literally tore my back just bending over one time. So I have to be very careful. I'm a fragile little towel. But anyway, Bossy Texas Chick's like, yes, I don't know if I want to learn more about Watergate or Article 1 courts. Well, listen, Bossy Texas Chick, it generates hundreds of millions of dollars in revenue. You get to learn about me when I was just a yayo little towel. And now we're going to watch the CCC. And you might be saying to yourself, well, I'm a cat named Bella, and I may as well learn about the CCC because I'm in the kitty CIA. That's the spirit, Bella. You tell Bossy Texas Chick she has to learn about Article 1 courts. This is not a negotiation. You are in the kitty CIA. You have to make sure she understands the government. You can't just have bossy Texas chick out there with no idea how Article 1 courts work. You know what I'm telling you? I think the first day in the kiddie CIA, they tell you got to understand the three branches of government, and you have to understand the Constitution, all right? This is some kind of exam that Bella had to take when she joined the kiddie CIA. In any event, if we could just start again now, that would be really good, government. Maybe they're eating Cape Cod chips. They're celebrating their years of work. They are eating Cape Cod chips on the taxpayer dime. Yes, ladies and gentlemen, they clearly have Cape Cod chips. I may just leave you with this until they come back into session. The press conference did go a little bit longer than they said it was going to go. But, I mean, if you say 12:45, come back at 12:45. You know what I'm saying? But they are also the government. So they're kind of like cats. Like when one of them does something, they just all do something. So if somebody's standing there and is like, yeah, we should probably get going, then all the other ones scurry around and then they just get going. So there's not really I wouldn't really say there's a lot of there's not a lot of cues. It's very fluid, but there can be a cue where then everybody's just like, all right, let's get started. It's government. I don't know how to explain it. It's efficient, but it's very odd, and it's very artificially diplomatic, but also genuinely, authentically diplomatic at certain points. It really depends on who you're dealing with. Yes, bossy Texas chick and the rest of Towel Chat keep me young. That's why I age backwards, ladies and gentlemen. Forget about... Now, listen, did you know that I actually found out a way to defeat the aging process, all right? I've thought about this extensively. Now, here's what we're going to need. All right, bossy Texas chick, I'm going to need you to develop a relatively compact engine, okay? And I need this engine to be able to accelerate, okay, at a rate of 1 G per second, okay, which is 9.8 meters per second, infinitely. So I don't need it to travel 9.8 meters per second. I need it to accelerate at a rate of 9.8 meters per second. Now, you might be saying, why do you need this? Well, I'm going to tell you why. Okay. If you can develop for me a relatively stable and compact small engine that can accelerate an object, a big object, at least I can fit 1 or 2 humans and some food, at a speed of 9.8 meters per second, then we can run into a paradox regarding Einstein's general theory of relativity. Okay, so you leave someone on Earth, all right? You put someone else in a spaceship. You send the spaceship around Earth really, really, really fast. And I mean, by the time you've been going for 6 months at a rate of 9.8 meters per second acceleration, you're going basically the speed of light. I mean, it might take 2 years to get there, but you're going so fast it's impossible to actually conceptualize how fast you're going. However, since you're moving relative to the Earth, you don't actually experience yourself going the speed of light. Now, you can't actually go the speed of light. It doesn't work like that. That's the paradox. What happens is space-time contracts to facilitate your travel at those speeds. Okay, what does space-time contracting mean? It means that you are experiencing time differently than people who are not going as fast as you. Now you got it. The fountain of youth is simply leveraging the paradox that happens when humans travel close to the speed of light in order to have time pass inside their spaceship slower than it passes outside their spaceship. So you leave a bunch of people on Earth, you put a bunch of people in a spaceship going really fucking fast, and then those people will age slower than the people on Earth. And this is basically the premise of the movie Contact. If you want me to learn this, you have to incorporate it into trivia. I'll do my best, but basically, bossy Texas chick, you just got to think about E equals MC squared, all right? And then you got to think about the speed of light. Now, if you as a human were going the speed of light, that would not work. Your body would burn up because of resistance. But if we put you in a big metal tube, all right, and we sent you around the Earth at the speed of light, you over 12 months would only age, and I'm talking about all your particles, all your body, everything would only age 6 months. I'm using very general terms. The math might be different. I'm not a scientist or a mathematician. Don't rely on me for these calculations. I'm talking about Einstein's theory of relativity. You should probably do your own research. in any event, the point is, if you can go that fast, then if you spend 12 months of Earth time in orbit, your body will only age 6 months. Okay, boom. If we just do that on an exponential equation, that's the fountain of youth. And now back to the government.
Okay. Okay, thank you. And again, we apologize for the brief hiatus. We did have an opportunity to speak to members of the media about the social consumption regs, but I need to get another vote from my fellow commissioners because we voted to pass those regulations as drafted, but we need to actually have specific language to authorize the staff and the legal department to make any ministerial edits, basically telling them to send this to the Secretary of State's office and make any minor edits, dotting I's, crossing T's, not changing policy. So anyway, at this point, I will entertain a motion to reconsider the motion to approve 935 CMR 500 and 935 CMR 501, to reconsider that motion with this added amendment. So I will restate what this is. The motion to approve the regulations 935 CMR 500 and 935 CMR 501 as final, including all amendments related to social consumption establishments and all other amendments resulting from commission deliberations. Further, to authorize staff and the legal department to finalize these regulations, to make any ministerial edits necessary and consistent with commission deliberations and votes, and the Commission's governing laws and the Secretary of the Commonwealth's requirements, and to take any additional steps necessary to file the final regulations with the Secretary of the Commonwealth. So, Commissioner Roy, I will entertain a motion to reconsider that last vote that we took with that further amended language.
So moved.
Do I hear a second, Commissioner Stebbins?
Second.
Having been moved and seconded, I will take a call of the roll. Commissioner Roy?
Aye.
Commissioner Stebbins?
Aye.
Commissioner Benedon?
Aye.
Chair O'Brien votes aye. And with that, it passes with them as amended 4-0. Now we will be turning things over to our Chief of Technology and Innovation, Paul Clark, and we will be getting a presentation from Metric, which is our seed to sale technology provider.
Okay,
Paul,
great.
okay.
Thank you. Good afternoon, Commissioner and Chair. As noted, Metric is our seed to sale provider, and they'll be presenting today their updated product catalog that includes the ability to embed COAs within the product catalog. This is Massachusetts was the first state in Metric to have a product catalog, and we've actually not done really any updates to that product catalog since it was launched in our section of the commission. Metric has been working with other states, most notably Nevada in this particular case, to embed the COAs. So they'll be demonstrating kind of how that works today from the Nevada side. And so I'm going to introduce Jessica Painter, our customer success manager, and Brent Doherty, the director of customer success at Metric.
Thank you. We have, and Jessica and Brendan, I'll call on you, but I know Commissioner Roy would like to make a quick comment because this is something that she's been pushing.
Yeah, and this is a big day for me personally. I've been advocating for a long time about more information to consumers and patients. And we had, the product catalog, although was cutting edge at the time and first in its time, it's needs some updates and it needs to provide more timely information and more information, quite frankly. And I always point to Connecticut that they have the COAs housed in a user-friendly format, which shows, where it was tested, what it was tested for, who tested it, and, the pass fail and everything is at your fingertips so you can make informed decisions. So this is a very exciting day, and I'm thankful to Jessica and Brent for being able to join us and share what's been happening in Nevada and what's going to happen in Massachusetts. So thank you so much. And thank you to Paul, our Chief Technology Innovation Officer, for helping support this initiative and coordinating with Metric. So thank you, Paul.
So Paul, I don't know if you've scripted this with the folks from Metric about who's going to talk first, but who should I call on first?
Jessica Painter will be taking the lead on today for the presentation.
Okay, Jessica, you have the floor.
Thank you, everyone. If you don't mind, I'm going to go ahead and share my screen now. Sorry, everyone, give me 1 second. Sorry about that. Okay. Alrighty. I hope everyone can see my screen. And again, thank you so much for having me and Brent today. Like Paul mentioned, Massachusetts is one of the first product catalog users. And since we've launched the catalog with Massachusetts, Nevada also has started utilizing this feature for their state as well. In the past year, Nevada has requested some improvements to the item catalog, including the ability to house COA information and also the ability to see where that product was sold and to which dispensary it was sold at. So today I would like to showcase what that looks like in the Nevada product catalog. So here on my screen, you can see that I have the filtered state for Nevada. I am going to go ahead and type in an example here in the catalog. Let me just make my screen a little bit bigger here. Okay, so as we can see in the product catalog here, I'm going to click an image. Okay. So now we can see one of the product catalog items. This is a Stizzy Flower OG 14 gram pre-roll bud package. I'm sorry, not pre-roll, it's a bud flower package. If we go ahead and see at this top hand screen, you can see I can press that view more button and it will showcase first where that product came from and then any dispensary where that product was sold. Underneath this area, now you can see the packages that were derived from the source package. If I click that button, now I can see, and it may take a few minutes to load here, the COA available for that feature. Sorry, I'm having some Wi-Fi issues today.
Join the club.
I'll just try to go into that. Oh, sorry, wrong item here. I'll try to go into that and pull that up again.
Some live demos.
Yeah, give me 1 second, guys. I'm going to try to go into this. Give me 1 second. I apologize.
Of course. You want to comment? Well,
certainly as Jessica works to get this up, obviously what we come up with is the COA, the PDF, the COA. Each COA is different format based on the lab. Each of our labs uses a different format based on their LIM system, but because it's a PDF, it's able to be displayed at any format, whatever it's being used at that time.
Okay, thank you.
Okay, so here we can see, I'm pulling up the item again here. And like I said, for this item here, we have just an example, the pre-roll Stizzy. As you can see here, we have the originating facility. And then here on the right-hand side, you can see which facilities sold that package. If I scroll down, I can also see the COAs for that package. And so here I will go ahead and click, and now my Wi-Fi is loading. So thank you for your patience. But now you can see the COA information present for that product. Any questions so far?
Commissioner Roy.
Yes, and thank you, Jessica. And this is amazing, and this is, you know, what patients need to and consumers need to have access to. My concern from our existing product catalog is querying a search. It's very complicated. You had to add information that 9 out of 10 people didn't necessarily have at their fingertips. So at some point, if you can just show us, like, is it by product? So if I buy, let's say, you know, Betty's Eddies, I just type that in, and so it's the product that's how I would do the search, correct?
Yes, exactly. You're exactly right there. So you'll go ahead and just type in the brand name there, and then you'll have all those available products that you can search for. In this example, I searched for Stizzy, and now I'm able to see all the Stizzy branded products. And again, I just went ahead and went here for that package information.
If I may, Chair.
Please,
Jessica, could you go back up? So go back up to so you put Stizzy in. Will we have to put Massachusetts in?
Yes, so under the drop down, there is Massachusetts and Nevada. Right now I have the state of Nevada highlighted.
And see, like the stuff underneath, like people don't know item necessarily license number, package ID. So that is not essential to do a search, correct? Because
correct.
Okay,
Yeah,
so they're there, but they're not essential.
You don't have to use that to search for an item. That's correct.
Okay.
Commissioner Stebbins?
Jessica, real quick question. Can you go back to when you landed on the product page?
Sure.
So
is this the view that you would like to see?
That is. So I think getting to the information about where somebody purchases it or can purchase it, obviously I'm assuming all of those numbers are Nevada license numbers. Are you able to click on those? And I mean, for the consumer,
so
how would they find out where I bought it?
Yeah, so this would be the common name on the left-hand side of the dispensary. Like for example, down here, we said P13 dispensary, that's Planet 13. And then on the right-hand side, you can see the actual license number for that facility.
Okay, so just looking at that page, I appreciate that. So I'd be able to figure out what the number is, what the license number is. So some of those, and I know we're just talking about an example, but the 5 who don't have a store name, is that just because for demonstration purposes you haven't filled those in? But those would all be filled in when we're thinking about, you know, adding this to our product catalog, right?
Correct, yes. So and then also the information that's included on the label, they'll have on the physical label, they'll see the dispensary that it was sold at as well. So the consumer would go ahead and look at that label. Okay, I purchased it at this dispensary if they don't know the license name. And then yes, to your point, all of this information on the left-hand side will be populated for each dispensary common name, for the item name. And the dispensary would be populated on this list for where it was sold with the common name of that product.
Thank you.
Yeah, and just I want to point out again, this is the Nevada catalog. This is not the final Massachusetts one. There's some opportunities. I much to Commissioner Stebbins' point, I want to make sure that this is a little bit more user-friendly in the display as well. So there's still some work that we can do to finalize working with Metric to improve it even further. But I wanted to share with you kind of how the COAs appeared and to make sure you understood the functionality available today.
And so I used the Betty's Eddies example. So sometimes like folks will, you know, where do I buy a product? And you just have to go on Google and figure out who sells. They all sell different products, right? And so I think this could be a tool for our dispensaries. So it would drive people to them. So if you want Kim Roy's cannabis pre-roll, right? And you type it in, would that show where I can buy it?
Yes, anything that's out there by the label, you would see what's there.
So now, this could help drive people to particular dispensaries if they're looking for a product.
Yes, I obviously, if you knew a particular product this would give you a list of who it is at. I know from the initial inception of the product catalog, that was not one of the intents. In fact, the goal was not to be in almost like a marketplace and such, but this would display.
Don't do it.
De facto provide that list, but in an unbiased, it's a total list.
It's really not a marketplace because it doesn't tell you inventory.
Correct. It doesn't tell you inventory, pricing.
They have a relationship and it might be there, but it's not. That
It's just basically this package was sold and is still actively being sold at this list of dispensaries.
Yeah, exactly to Paul's point there. So just want to clarify a piece that you mentioned. So any product that is showing on this catalog with the sales from that, here, I'll just close this out. Any of these sales sold out of that product catalog will populate. For Nevada, it's from the last 6 months. So the item itself will remain on the catalog for a year, and then the product sales will remain on that catalog for 6 months. Every single night, there is a job that pushes over that information, so it is populated the next following day. And then Nevada has their catalog set at 180 days total for the items to be populated on the catalog. Because I know right now you guys have the catalog at 7 years. Nevada has reduced that to 180 days.
Can you, I was absorbing. Go ahead, Paul. Sorry.
Yes, so as I mentioned, so the catalog as it stands today is all products that have ever been entered into the product catalog. We never set a retention period as to how long information stays in there. This is one of the criteria that Metric has provided to us, that in order for us to launch this with the COAs, we're going to need to put a retention period on it. It's far less than 7, and it's just 7 years because that's how long it's been out there. If 10 years, it'd be 10 years. So we'll need to put a retention period that makes sense for us to help reduce the size of the database and keep the performance moving, and not just clutter. I think to the point a lot of comments have been is that the current catalog is very cluttered. Part of that clutter is old items that were maybe never even sold, but they were entered in or created or sold once and haven't been sold in years that are still in the catalog.
Commissioner Wright?
Yes, thank you. And you know, as we know, the testing date is good for 1 year. So would that make sense, Paul, to have a year's worth up there?
I would recommend, and I think what Jessica said, Nevada it's the 1 year for their test, and then they'll have 6 months after that, so that if someone has it still in possession after they bought it right at the very end of the 1 year period. My recommendation would be somewhere between 6 to 12 months after the last possible sale date, which are between 18 and 2 years. Yeah, it just becomes, Jessica said, there's a job in Metric that runs every night that clears out that, and they just looks at how long was active for, and after that date, they're removed from the catalog.
So my question is, this is not going to be a burden on you and your team, that Metric would do this if you gave them the guidelines?
Correct.
Okay, so that's not too much. Okay, Commissioner Stebbins?
Thank you, Chair. Jessica, I know, looking at the screen, also, you have titling for description and ingredients. That's all provided, I'm assuming, by the product manufacturer. Is that
correct?
Any constraints around that it's not advertising, it's an actual scientific description, maybe?
Brent, you may have the answer to this question, and Brent has joined me from Metric as well. I believe these descriptions and ingredients are pulled directly from Metric, so whatever that description was entered in the Metric system for that item, that is what's pulled over to the product catalog. But Brent, please correct me if I'm wrong on that piece.
Yeah, I can speak to this a little bit. I actually was part of the team from Metric's end that helped develop this initially for Massachusetts. So the intent here was to there be kind of a encouragement for people to upload photos and then add that description in as well, just to make sure it was clear if there was, particularly basically describing what that product looked like. So for example, if I didn't have it in the packaging. There would be a description that I would be able to identify what, say a gummy was a triangle, but it's no longer in the packaging. The intent was with the description to be able to give a description. So even if I didn't have the packaging, I would be able to at least see if this is the correct item that I'm looking at. And then also obviously to encourage them to upload photos for all these different items. And I do want to just clarify, I think with the clutter piece that Paul had that mentioned, the other thing on that front is we also had a lot of items that are not even final form items. So there's also additional cleanup that would be done to just remove any items that are, you know, from the past that are not necessarily final form items as well, and cleaning that up.
Thank you. Commissioner Stebbins?
Thank you, Chair. More of a comment, obviously, the product catalog and the changes we're talking through today are going to be, I think to Commissioner Roy's point, extremely helpful to the consumer. We also know, I think when Commissioner McBride had the idea for this product catalog, this is also to help folks in the public safety community who come across some of these items. So if we think about changes, maybe some updating or a bulletin or information that we can share with public safety folks about the capacity of the new product catalog and some of the additional information. That's all.
Thank you. Mr. Chief, were you going to make a point?
The only other thing I was going to make a follow-up point on that is that, again, I think that's something you want to consider as we come up with the retention period as to how far out do we want to have stuff available for law enforcement or school teachers or parents. So, you know, cutting it, I think 6 months is on the short side of things. You know, if you find something under your child's bed a year later, to know what was there. But obviously much longer than that now, it's kind of, it's becoming very stale at that point.
Mm-hmm. Okay, thank you. Commissioner Red, I don't know if there's something. Okay, he's just talking about the, okay, that's good. Keep going, Jessica.
Thank you. Yes. So you mentioned a bulletin, and I wanted to mention on the metric side as well, we can absolutely put out a bulletin as well on this information. But this was really the end of my demonstration here. We have the two features that I wanted to mention were the COA availability, and then when those products are being sold, that information is now included in the state product catalog as well.
Thank you.
Thank you so much.
Are there any additional, Paul, is there any statement you want to make after their comments?
No, but I just wanted to thank Jessica and Brent for being able to be here today and give that presentation and share with everyone here in Massachusetts what the work metric's been doing and working with us here in Massachusetts as well on improving the product catalog.
Thank you.
Thank you so much for having us. Have a nice rest of your day.
Great. Thank you very much. Thank you. Appreciate it. All right. So you've had that presentation. So, all right, go ahead.
So,
Commissioner Wright.
it is under the discussion and vote section.
Yeah.
So I don't know if we need,
would you like to make a?
I'd like to make a motion because it is under discussion and votes just to get the work up and running. But let me ask, if you don't mind, through the chair.
Yes.
It doesn't say vote next to it, but it's under the discussion and votes.
So from an open meeting law standpoint, I can tell you that the Attorney General's guidance has always been that if a topic is sufficiently described on the notice, there is no requirement to specify that a vote will be taken.
Wonderful. Okay, so we can vote. Is that what I heard?
Right, we can
That's awesome.
take action
Okay.
or not take action
All right.
as long as
Yeah.
the topic is on the notice.
Yeah, and again, I was getting,
Awesome to
yeah,
have
I was
you.
getting confused because I didn't know I
Yes.
have it in my script.
Okay.
But Commissioner Ray, your
Okay.
point is that this is all under votes.
It's under discussion.
It is already noted as votes, even
Yes.
though it doesn't have votes after.
Yes. So I think we're,
So anyway, we're going to go, this is 5, so would you like to?
well, I think we should take them separately. I think we should.
Well, I'm just saying, that's what I'm saying, do you want to do the COA, do you want to make a motion?
Yes.
Yes, that's what I'm saying, yes.
Yes, because time is of the essence and this, so I just, now we can make, friendly amendments. If I just did this on the fly, but move to direct the executive director and the chief technology information officer to adopt the new metric catalog, which will also contain certificates of analysis for each product with a retention period of 18 months to be published by March 2026.
I don't know if we need a friendly amendment. Is 18 months or?
Well, that's what I want. I don't know.
You put that in the chat.
Yes, and let's do friendly amendments to this. Chair?
Yes.
Would you like it longer?
Oh, I can't even see it. Move to direct the executive director and CTIO to also maintain. So my only question here, and Paul, I would actually ask you for your opinion, only because you raised the issue of law enforcement or parental enforcement. Do we want to say 18 months or no longer? You know what I mean? Can you suggest anything that you think might help us unclutter this list, but also make sure that we provide a tool for parents or law enforcement officers so that this is there that people can find it?
Sure. So I think, and just again, it's interesting. I want to make sure the language is correct because there's a date, but is the date from the date it was first published, date last sold, or date last the testing was last valid for on the product. So I think
the certificate of analysis on each product, which I would assume would be dated when it's
born on date.
Yeah, the born on date. So but born on date, but then now there's a same product is sold month after month, year after year. I think you're going to want a date that's probably 1 year after the last time it was sold.
Wait a minute, I don't know if I can.
So if I Paul's package of weed and Paul's pre-rolls, and I keep selling that same product, I can sell multiple batches of that same product. I can be selling that for 5 years if it's really popular, even though there's multiple batches and
right.
multiple COAs with those batches. But at some point, I'm like, I'm going to change the product and I'm going to make a new one. And that product now no longer for sale, or I'm no longer producing it, but it was sold over a 5-year period. I'm just saying from a year from the last time it was sold or in inventory would be a date. And it's always easier to bring things closer than to expand it back further out. So
Lead to your clutter.
it'll deal a little bit, but again, but by definition, the way metric works, it would be there if it's active.
Well, anything less than 7 years is less clutter.
Is less clutter, absolutely.
Benedict?
Sure. So, a question of clarification. The COA has a time frame.
Correct.
And so, if this is a product that is being made batch after batch after batch for years, there would be multiple COAs. Right.
Correct. Correct.
And so, does that mean that if there's a search, let's say we set 3 years as the time period, the exact same product would have multiple entries
correct
in the search?
Yes.
And so what can we do to make sure that that's clear to the consumer that the one that they're pulling up is the one that they have? Because they will look exactly the same.
That's good question. So, and that's one of the things we want to clarify in that, so there's a list of COAs and those will change over time. And is date oriented right now? It's newest to oldest in the batch. But that's a good point, and that's something we do want to talk to Metric about and just make sure it's, again, as pointed, it's displayed. I think there's the year from the date the COAs expired. I think the year from expiration, whether the last sale date or the last COA, the COAs can fall off over time as well. So if we specify the COAs can be removed a year after they're valid, or they become invalid, and then a year after a product was last sold, because there could conceivably be a product that sits on a shelf no one wants it and then they have to destroy it.
Yeah.
When it may not be sold, but I think a year timeframe after any action on it would make the most sense.
The executive director is offering a compromise here, I think.
Thank you, Madam Chair. Yeah, I just think a couple things that we have on our plate from a staff perspective to get this date. I think Commissioner Roy's target, March 26th, works. I think the retention policy essentially would summarize exactly what we're discussing here. And I think specific to the next agenda item as well, which I know we're separating, would be some type of either waiver or opt-out. I discussed with Commissioner Roy earlier to just acknowledge the change in our process here for our ITLs. And I think we could hopefully turn all of that around on this timeline for a launch in the spring and get, and I know I won't jump to the next agenda item, but just a couple caveats.
I think while we have him up here, I think we might as well just go right to that next agenda item. So let's deal with this and then we can keep you right here and we won't, don't go anywhere. Yeah, exactly. So in terms of how we phrase this, so move to direct the ED and CTIO to adopt new metric catalog, which will also contain certificate of analysis. How would we just reframe that or to come back to us at the January meeting?
Happy to try to bring to you drafts of a retention policy and a waiver or opt-out in January so that you see exactly what we're looking for. And then we can try to stick with the spring timeline of launch for both the COAs and the aggregate data, which is under item 6.
Commissioner Wright?
I disagree with the need for a waiver and opt-out for the product catalog. Does Connecticut have a waiver or opt-out for their product registry?
I will ask them. I do not believe they do. The comparison for Connecticut, having talked to that team over the last couple of days, has been a bit different of what they have under their regs and statutes, and also a bit different in terms of having 2 labs rather than the 11. But I would absolutely, to the chair's point, be happy to bring these back in January so that you kind of see what we're talking about, and hopefully.
I don't think we want to waiver or opt-out. I don't want to. And we already have precedent where we have published significant information relative to products. Commissioner Ray, you might want to.
Just for the public. Chair, may I?
Please.
Yeah, I'm going to share with my colleagues, the public, what is currently out in the public domain. The vaping contaminants testing results, which is aggregated, listing the date it was tested, the lab, the results, and the item name. So I'll just share. There are 2. Actually, this is quite lengthy. There's okay. I guess it's a lot. Wyatt had asked for multiple copies of this. I got them. So, you know what, we'll each take a page. We can give you the general idea. Each take 2 pages, give you the general idea
Of what we have previously.
which we have published.
Level of creativity of naming cannabis products never ceases to amaze me. So this obviously was earlier on in the history of the commission, but it is clear that we had item name, test date, lab identified. I think that, and this is one of the things that I think as a commission, we are a public agency and we have public data and we cannot, and frankly, this will be part of a discussion later on, but we've actually we've actually changed some of our reports rather than getting specific about data and information. We basically said, consumers need to protect themselves and we need to tell consumers they need to protect themselves. And this is actually how consumers can protect themselves. Again, as a public agency, we should be doing less to try to keep data behind a wall and make sure that the public can see it so that they can protect themselves. So I do not think that we should be allowing opt-out or waiver. I mean, again, there are potential exemptions, but any of the arguments that I've heard about exempting any lab from being able to keep this their identification private or requiring consumers to go through a rabbit hole to find that information, I just don't think makes any sense. But
Sure.
Commissioner Stebbins, yeah.
Thank you. Jessica, are you still with us?
Yes, I am.
Jessica, if the bandwidth on your wireless is okay, I'd love to, you flashed it up really quickly and I didn't have a chance to fully look at it. The COA, at least a Nevada example.
Sure, no problem. I'm going to go ahead and share my screen now. Okay. Are you able to see my screen okay?
Yes.
So this is the certificate of analysis for that CCC product that I had previously shown.
And what are you looking for, Commissioner Stebbins? Can
Just
you make it any bigger? Like,
Oh, sure. Is that better?
yes.
So is the name of the lab anywhere, or is it one of those logos?
Yes. So it is this NV Canna Labs is where that was tested from.
Okay. Okay. Thank you. Thank you,
But
Jessica.
Nevada does make that public.
Yeah, Connecticut makes it public.
Actually, make
Yes.
a point to Connecticut.
Executive Director, yeah.
Thank you, Madam Chair. One of the discussions that Connecticut is currently going through as well, to Commissioner Roy's point on Connecticut, is that some of the frustration that they've had from folks is that not all COAs from each ITL are formatted the same way. And so they are looking in some of the changes that they have coming, sort of similar to the topic of some of the things that we need to be doing to prepare for increased transparency and availability of information on the website. Connecticut's currently looking for a standard template for COAs so that they are all the same on the website. So they are still obviously as well as in an iterative process as we're discussing.
But I'd assume that we're also going to be looking at changes to testing and standardizing testing. So that could actually be part of that second iteration of what we do. But ultimately right now, the more we can do to put tools in the hands of consumers to protect themselves, for parents, for law enforcement, but making sure that we're getting as much information as possible out there. I think that that's important. Commissioner Roy?
And also, as a friendly reminder, we just ratified social consumption regulations. That will have the COA through a quick recovery code on the products as well. So, you know, we just voted for that without waivers or opt-outs on the product itself. So, you know, this is public information that the public should have, and we should not give people an avenue to opt out because they don't want the public to have it.
What is the rationale for an opt-out? What is the public policy, open government reason why we would allow this to anyone to opt out?
So, if I may, Madam Chair.
Please, thank you.
And I would invite through the chair, if you're amenable for, I know that Attorney Bruno and Attorney Chatterjee have looked at the actual issues within the regs that we're trying to address to accomplish the intent of the board. Is really related to some of the information, and this is probably more under X6 than X5 on the agenda, which is in the aggregation of the data, a number of items that would be considered confidential records that could be found. Now, we've also had, and Commissioner Roy has been part of the ITL meetings where there's a desire from the ITLs, is my understanding, to have aggregate data out there. And so by having a simple waiver or an opt-out or something to that effect that signifies the ITLs are in agreement with this, then everybody is protected in that outcome, and we meet the intent of the board. And so it is within an exemption of what is considered public records access, is confidential records that can be deciphered through the aggregate data. And so by having that, we make sure that we are.
But the point is, if the information is out there, we're just making it harder to find, right? We're not protecting the data. We're just making it harder for individuals to piece it together. I mean, I will point, we did have a number of years ago a data breach, right? And it was a very scary time for us. And I remember the former executive director being concerned about the fact that with that data breach, basically every piece of information about every single agent was put out in a public records response. And the question was, is this confidential data? And the fact is, there wasn't a lot of confidential data that was protectable under state confidentiality rules. And so if there weren't social security numbers, if there weren't anything, like health information, that's not what we're dealing with here. And I don't think that it is incumbent upon us. And I've actually read the legal brief. I think that it's a stretch. I don't really think that, with all due respect, we have a wonderful legal team, but I think that we have a duty, because ultimately, if this information is findable, just making it harder to be findable to protect what I don't believe is confidential information. I see that as giving the illusion that we're protecting some sort of client list when we're really not protecting consumers from being able to do this. So I just don't think that this is good public policy to allow, again, we right now know that we have a problem holding independent testing labs accountable. We have a problem internally with holding independent testing labs accountable. So to allow independent testing labs to opt out when what we're trying to do, when basically we will be talking later about how we changed a report, and I can give you specific language. Wait a minute. Specific language where we decided to take out language about economic pressure can potentially drive growers, product manufacturers, and labs towards higher cannabinoid results and passing safety screens. However, regulators may further incentivize accuracy and honesty, provide additional consumer protection, as well as fidelity of industry compliance with off-the-shelf testing practices or a state-run standards laboratory. And that was substituted with this language: to provide additional consumer protection as well as fidelity of industry compliance, the Commission may offer consumer education and off-the-shelf testing practices or a state-run standard testing lab. Now, we know that getting a state-run standard testing lab is expensive. It's going to be an uphill battle, but I'm hoping that the legislature will understand why this is so important. But literally now saying we're going to allow independent testing labs to opt out because we're worried about what I see as a red herring in terms of confidentiality, but we've basically exchanged clear language that talks about financial incentives for independent testing labs to not behave and not comply with the law. But we're telling consumers they have to protect themselves, and we're kind of going to do something to help them. That's where, we have to be consistent with giving people the tools to protect themselves and making sure that we're holding independent testing labs accountable. But,
Mr. Roy, again, we just voted on social consumption regulations, a huge milestone where the COAs will be, take your phone, you scan the product, you're going to be driven to the COA. We didn't have an opt-out there. There's no opt-out. It's shall and it's not may. So again, this just goes to protect consumers and patients. And why would we give an opt-out for this and we didn't for that?
Again, everything that you said, Madam Chair, I'm looking to get to the end result of what I believe the board's intent is to be, as Metric now has capabilities that we haven't had access to in the past. And this is my recommendation, but obviously it's a board decision. I'm happy to put the confidentiality language in there for consideration, and I'm also happy to draft and bring back in January both the retention policy, which I think we all understand based on just the significant amount of data that needs to go now in the product catalog that we'll need to make some changes to allow, as well as either a waiver or opt-out, or however makes the board, whatever language the board would be amenable to.
Commissioner Stebbins.
Thank you, Chair. I guess a couple of quick questions for both the ED and for Commissioner Roy. For the ED, is there a concern around confidentiality of either business name, business practices when it comes to the Metric product catalog COA? And is that a separate concern from, I know we haven't got to it yet, but another testing agenda item that we have under number 6. You've parsed the two between confidentiality concern, maybe under number 6 versus this discussion on the COA, because obviously from the example that the folks at Metric shared, the name of the lab is right up there.
Yeah. So if I may,
Please, thank you.
So I believe the intent here is to have holistic changes in the spring. I think we talked March in the motion that was read. So the COA is the customer facing. You can QR code off of a product. And then we would be also through our platform, through Metric with a product catalog, having those then listed as well. On the sort of large aggregate data, within our existing anonymized data sets that say lab A rather than identifying a lab, somebody could then go in, use that, go through the batch number, identify the lab. And so in that instance, what we're basically saying is through the anonymized data moving forward with the COA up, we are basically backdooring that. And so in both of these instances, we should be just saying, we are going to be providing the information that somebody's entering into Metric. We are asking that they acknowledge the fact, based on our confidentiality within our regs under 500-820, that we are now going to be de-anonymizing the lab and asking them to acknowledge that for the protection of the state. I don't have any issue with the...
This is basically saying, I don't think that we should allow them to dictate to us. And what I've heard from the labs is they want more accountability, not less. They want us to do a better job of holding their competitors accountable because it is so costly for them to do their job. It is so difficult for them to do their job. And we're going to be throwing a lot more at them in the coming year in terms of standardization and maybe asking some to buy new equipment that they're going to have to use. We don't know. But I do not think that it is up to us to ask them to opt out when you can backdoor. You're going to be able to find this information anyway. So we're not providing, the opt-out doesn't provide the protection at all that I think you're talking about. Commissioner Roy.
Thank you, Madam Chair. The executive director did share language with me, and confidential records means any electronic or written record required to be kept confidential or protected from disclosure by law, which includes but not limited to application materials, confidential application materials, confidential social equity application materials, confidential investigatory materials, and protected patient records. None of those apply here. We had a summary suspension order, which we're going to talk about in a little bit, where over 7,000 entries were not entered properly, and those that failed for total yeast and mold were not entered properly. And if you watch that news report, that's a significant health issue for someone immunocompromised. Pneumonias could impact the lungs. And so who are we protecting here? Are we protecting public health, public safety, or are we protecting, licensees by keeping them anonymized? And so I would argue that by giving an opt-out, that's not protecting public health and safety here. And I don't see how any of those apply to this product catalog.
I agree. So maybe what we do is maybe the motion, we don't mention the retention period, but we just have the motion directing them to adopt the new catalog, which will contain certificate of analysis for each product to be published by March 2026. If you want some specific language, we're not going to, and again, some people may want to add this to the motion. I think that the opt-out is the opposite of transparency and promoting public health and safety. And the fact that we already acknowledged that people will be able to find that information anyway. And we've just seen that Nevada puts it right out there. So is there a way that we can rewrite this motion that keeps us on track to your satisfaction? I don't know if I'm not paying attention to anybody back here, but.
So you don't want the retention period?
Well, I think that the retention period is really less a problem for us and more it's clutter. So it's not necessarily a problem. It's something that we can address. Do we have anything in our regs that requires that retention, or is that just sort of what we have done and we've just never done the clean out?
As I understand, there's not anything one way or the other on the retention. So the assumption has been to leave it at this point for all time.
So the point is, we're just, the changing the retention is one of, I think, efficiency and clarity, but not something that has anything to do with public health and safety or protecting anything. So, so the motion could be to direct the ED and CTIO to adopt new metric catalog containing a certificate of analysis for each product to be published by March 2026. Are you comfortable reworking? Go ahead, Commissioner Benedon, and then Commissioner Stevens. Commissioner Benedon.
Sure. So I did just want to flag the comment that Executive Director just put in the chat referencing our own regulations regarding confidentiality and further defining confidential records. And so I just want to make sure that when we take this vote, we are clear that, I think I see two sides to this. There's without a doubt the public health and safety considerations, which are significant, and the transparency considerations, which are significant. My concern is whether our own regulations have already advise the ITLs that this information is confidential and will not be publicized. Are we exposing ourselves to liability by publicizing it?
If I can, it is. Yeah. Oh, sorry. I think you're done.
I just want to make sure that we are weighing those two considerations adequately.
It is publicized. It just is not clear, but it's out there. My point is, this is not anything that's going to put anything behind a data wall, if you will. It just makes it slightly more difficult. I mean, the professional and the amateurs, scientists out there can figure this out. And I think that if they have the ability, because they have greater research capabilities, that if you're going to be able to find that information, and we call it Lab A, we don't say the name, right? So Lab A is identifiable. You're going to be able to find it. That's what we have now. And what we've had before, we've had this. So I don't know in terms of our current regs. I mean, maybe those are regs that were written after. I don't know. But this thing that Commissioner Roy just handed to you shows that we do not hide that. So in terms of any expectation, we have precedent. Commissioner Roy, did you?
I made the edit, your suggested edit.
Okay, Commissioner Stevens.
Thank you, Madam Chair. Just, and again, a quick question. Obviously, we've had a lot of engagement with our ITLs over the last year. Has any part of those meeting agendas, Commissioner Roy talked about the metric COAs, our intention to kind of move forward with that? I mean, again, I know we do things that, sometimes buck what the industry wants, but we've also had a good working relationship with the folks, not on just this issue, but a number of other issues. I'm just wondering what feedback you've gotten or any concerns raised if we've talked about the metric COAs and the product catalog expansion.
Mr. Ray.
Yeah, and the ITLs are looking for more clarity, more standards, standardization, number one. They all have different, what's called LIMS systems. So, right, Paul? And so, like Nevada, one lab may have a COA that looks a little bit different than the next lab, but they should all generally have the same information: the terpene profile, the cannabinoids, the heavy metals, pesticides, potency, and so aspirationally, and as the executive director just said, Connecticut's looking to make a standardized certificate of analysis, and on top of it, we also require whether there was pre-sanitization steps taken. Now,
you mean
on the COA.
Yeah.
And so we had a room packed with patients who say, we want that information. Imagine if you're a cancer patient and you just want to know, we're agnostic on it, whether you sanitize it or not, but let's give folks the ability to know whether that product is sanitized. And so the feedback that they're looking, it's not germane to this so much, it's more about the QOP and whether it's still in effect and standardization. And so really there's been no pushback on this, so to speak, that I can remember in all the meetings I've had with the ITLs.
And if I can interject, we're going to be doing regulations around our ITLs. And so I think that getting this up and running getting Metric to work with our staff to put this in place. But again, there's no, because we've already done it, because we already identified by lab, we just don't let the consumers know. Anybody who is lab ABC, they know who they are, and their competitors know who they are. So if this is about, we have to protect their competitive client list, I mean, the problem is we have allowed people to chase someone else's client list because we have not been as transparent to hold the ITLs accountable. You don't protect their client list. You hold them all to the same standard, and then you allow the consumers to get the information they need. But the real reason that there's a problem with competition between independent testing labs is not whether or not their name is listed on something like this, because by the way, we've already done it. So I just think that this is, again, I keep using the term red herring, but we need to do a better job to allow the public to protect themselves. This is past practice. We've already done it. So there's no belief that, this is private information. And again, we're a public agency. We need to be more public, not less public. So that's kind of my last stand. So, Commissioner Wright.
Yeah, and in the stipulated agreement, in the summary suspension order in the stipulated agreement, that 7,000 plus were inaccurately entered into our seed to sale system. They were getting 25% of the business. A quarter of the business for Total Yeast and Mold was going to that one entity. And so let's make this public so people can see the outliers, they can see the anomalies, they can get the information whether their product was sanitized or not if you're a cancer patient. And so I just think this is good government. This is good government right here.
But also consumers, if consumers are being attracted to higher THC promises, yet those promises are not being kept. Now, again, THC is a different thing. It's harder for us to measure, and there are some other considerations rather than having a strict number, because we know that, the efficacy can wane, and the potency can wane. And that's something we probably should be considering in our testing changes. But the problem is we need to protect consumers because they may want to know, well, gee, I'm going here because I think I'm getting this. But if they don't know, if it's lab A, how are they going to know? And so and this is why I would say, and I have not taken a survey of the ITLs, but what I've heard from them, a survey about this, but what I've heard from them is we are competing with the unregulated market. We are competing with entities that might utilize inversion. We are competing with toxic hemp. We are competing. And so I would hazard a guess that this would be welcomed. But we always have the opportunity when we're doing the testing, we always have the opportunity if we want to tighten that up, if someone says, oh my God, this is terrible. But I haven't heard one argument, again, because we already have done it. I don't know why it's now a bad thing to do when we're making it easier. Executive Director.
Thank you, Madam Chair. I think just to kind of reiterate what I hope is clear, I'm not I think that this is the direction that we are looking to go, and I'm just looking to put in place the right steps. So you just mentioned the reg changes that are coming. I think that ultimately, as the regs that I put in the chat, that's what I'm looking to. If there was a reg change, I'd have no concern, right? So, but it is ahead of that, and so I think this might be a legitimate way to accomplish this on a quicker timeline. You referenced the ITL discussions, as Commissioner Roy has been involved in, and I think ultimately that is the other thing here, and I believe you've all referenced it, where if this is the desire of the ITLs as well, I don't see this as a roadblock. I see it as an additional administrative step that I'm happy to take. And then I just really want to separate as well here what we're talking about, which is not about not having the testing data available. It's really about ensuring that we cover the proprietary aspect of the question, not the testing data. It's really the listing of the name. And the reference that you're making is a much smaller sample size of what we're talking about for an aggregate data set that we're aiming for the spring of 2026, which is including sort of the entirety of the data and the goal that we have, which I think the CTIO, I don't know, is actually kind of discussed exactly within the context of the agenda, what the plan is there. And really, it's just answering the question of that data set, what we intend to do for spring 26. It's really just the question of listing Lab A or listing the lab name. That's really the only question that would be answered within the waiver.
But again, if the rationale and the memo that I saw is that we have to protect customer lists, and I'm not even sure. So if you put Lab A, that's not protecting. That's still allowing more sophisticated researchers to know exactly, but we're not allowing our consumers to have that access. And we're not allowing consumers to maybe take a look at something like that and protect themselves. So anyway, I mean, I don't know, how we want to word this, but I think that as we start undertaking those regulatory changes, but I don't see this moving forward with the certificate of analysis, moving forward without allowing the certain independent testing labs to opt out or protect themselves from heightened transparency, which I think is always the best thing to do. I am not convinced that I've seen anything that impacts or protects these customer lists. And again, as recently as March of 2020, we were putting all that out there. Nevada's putting that out there. So Connecticut has it out there. So I don't know why this, again, it feels like we keep trying to fight against transparency and it doesn't make sense to me. So I'll ask Commissioner Roy if she wants to restate her motion. I will say it with the proviso that we will be looking at all standardizing testing labs and processes, hitting the ground running, hopefully in January. But I think that moving forward to make this as public as possible. And by the way, let someone push back on us. I'd like to hear someone push back. I think that we go towards transparency first, and then if someone has a problem with it, let them push back. Mr. Roy?
To your point, so what's the doomsday scenario is a lab takes us to Superior Court. That's right. Is that the doomsday scenario here? Is that a lab will take us to Superior Court?
If I may, Madam Chair, I would defer to the General Counsel.
Okay. General Counsel, would you like to tell us what's the doomsday scenario here? Why don't you grab that, grab it right there. That's
Good afternoon, Commissioners. I think the discussion has revealed concerns about liability that need to be worked through, that you as a board should consider as you make a decision with respect to taking next steps here. Included within that consideration would be the possibility of being sued. Yes.
Of what?
The possibility of being sued.
And again, we have a number of areas, whether it's HR, whether it's violation of people's rights, that we do have potential exposure, right? But the most, and by the way, we do have exposure by not properly regulating the independent testing labs and by keeping public information public. And I believe that we could create greater liability. And I believe we have exposed ourselves to liability because we have not been fulsome in terms of getting data outside. That's where I believe we have exposed ourselves to liability. And again, we do have information that shows that perhaps we weren't as robust as we should have been in terms of managing the oversight and providing the transparency in terms of regulating independent testing labs. So I'm more worried about that exposure to liability than I am this one instance where it's information that ultimately will be public, ultimately will be discoverable. But if we follow what I think you are suggesting, it doesn't protect public health and safety. And I will say the first thing that we have to do is to protect public health and safety. But we did not seem to be worried about liability when we were taking data from public reports and not allowing the public to see and not allowing the legislature to see some of the potential issues that we have to speak about. Yes, General Counsel?
Thank you, Madam Chair. I just want to reiterate the point that the ED had made earlier regarding the, I don't think there's any dispute here. I want to separate the actual data that we're talking about, which is the test results and that information, and contrast that with other proprietary information that we have as a commission that is included in the information that we have. And we have an obligation as a public agency to safeguard confidential proprietary information that has been shared with us.
What proprietary information do we possess that you're trying to protect?
Well, I mean, it could be a whole bunch of different things, but it could include lab names, it could include customer lists. I mean, there's a whole broad range of...
We're not publishing customer lists. General Counsel, we are not talking about publishing customer lists. Lab names are not confidential. They're publicly available information. We are not publishing customer lists. What I saw in a memo is that, well, if we make this too readily available to the public, that somehow with research, people will be able to determine who customers are. But we still will have Lab ABC under your proposal, but that doesn't take away, or that doesn't provide any greater protection for a business who might be concerned about someone figuring out the data. Frankly, as a matter of fact, I remember when I was state treasurer, I remember trying to expand access to information. You don't need to keep your hand. To expand access to information about banks. And I wanted to put together a website. And we didn't have websites before, and they were when they were invented. And I wanted to put together all the information that banks had. And it was bestvaluebanking.com. And I can't believe that my successor didn't keep that website name because it's a great name. But bestvaluebanking.com was putting on a website, and we would allow the banks to promote, and obviously banking products are a little bit more complex, right? But we said you can put on your website what you think are your best value banking products, and we're going to put this on the treasurer's website so that people can see people. And I remember the banker saying almost exactly what you said, which is, well, what will happen to me if customers see that I'm not as competitive as my neighbor? And I said, that's your problem. And then he said, well, what if I'm so competitive that all of a sudden people come to my bank and it causes a run on my bank? I mean, I've dealt with this 25 years ago, and I don't believe that, one, we're putting out customer lists. Two, we are already putting out the lab names. We're just hiding it from consumers. And we have precedent. We've already done it. So there's no reasonable expectation. Okay, and this will be the last one. Thank you. Go ahead.
Yes, thank you, Madam Chair. 2 points to make here. One, let me just respond by saying why, I know the ED has offered a proposal regarding a waiver situation. Why would the commission not want to take the step to protect itself from potential liability in a situation like this?
Because I want to protect the public health and safety. And
you can do that.
We have an issue right now that is being covered in the press.
You can do that. You can do both. My suggestion is you can do both.
What I am suggesting is I am more worried about the liability that the commission could be subject to for failing to be as transparent as possible. Okay, Commissioner Roy.
We've now been the subject of multiple major news stories, one recently in CBS, the Wall Street Journal in October last year, that we have moldy products on the shelves, which was proven in the investigation and the SSO this is consumer fraud. It's consumer fraud what's happening if the THC is being sold at a higher price. So you have that going on, and then you have a public health issue if there's moldy products on the shelf. And people want to know if they're sanitized. Consumer fraud. So we are exposed here on that. If the consumers band together and figure out we have not been providing this information and safeguarding public health. So that's a heightened exposure. I would argue that they could band together and come after us because we have not been diligent enough in our job to provide this information. So again, Wall Street Journal, CBS News, not two minor news outlets that have exposed this and exposed us in this situation. And we would be derelict in our duties not to provide this to the public.
Commissioner Stebbins.
Thank you, Chair. Just a quick question I posed to either to the ED or the General Counsel. Again, I know we haven't yet discussed item number 6, which is also updates to our testing data. But as it pertains to the new metric product catalog, and if we proceed with that, and I think there is some value to proceed with that, not least the which of right now on our website, again, if you can find it, is, product name, who the lab did it. I'm not sure what VEA test results are in D, but
Vitamin E acetate.
Oh, right. Thank you. And ND means
Notice of deficiency.
Not detected.
not detected. Okay. And again, I'm trying to parse out these two agenda items, and obviously, we want to be mindful of, certain proprietary information that a lab might have about their business practices. But as it relates specifically to number 5, the new metric product catalog, do you have concerns about the information that goes up, as we saw with the kind of sample that Nevada is using, and for a lab to attach themselves to that COA in that particular situation? Separate these two, if you can, separate these two questions out. Identifying the lab under the new product catalog, as opposed to, again, I know it's another agenda item, but the updates to the testing data that we make available on our open data website, because we haven't had a chance to get to that conversation yet. But.
Thank you. If I
Please.
may. I guess the response to that is I'd want to make sure that we're reviewing our regulations carefully to make sure that we're complying with them and any applicable statutes so that we are complying with the law as we try to think about next steps. And I would encourage the board to build that into their thinking process here. This is, the legal department has not had a chance to comprehensively review this issue, and it would behoove, I think, not only the department but the agency to make sure that we're approaching this in a systematic and very thoughtful way.
Please.
So if I'm hearing you correctly, again, we're specifically talking about agenda number item 5, the new metric product catalog. You are expressing it, at least from your vantage point, and again, maybe the ED has a similar concern about this overall effort complying with our current set of regulations.
I think, again, if I may, I want to make sure, and I think the ED read some language regarding confidential records that are some regulatory language that exists in our current regulations, and I want to make sure that we are complying with the letter of those regulations.
Could you please identify what confidential information will be disclosed in the difference between identifying Lab A or Proverty Labs? What's the difference?
Thank you, Madam Chair. If I may, I think the issue here is, again, putting information that can be pieced together So it's.
No. If I could back you up, we're already talking, we already do Lab A. We've already published.
I have not seen the document that you're showing to me.
Again, this is a subject that we have been talking about for some time. This is an issue that Commissioner Roy has raised on multiple occasions. And if you're not prepared to answer these questions, I don't know what to say, but I've asked you the very clear question, is that what I have not heard what the confidential data is. You've told me client lists, and we are not disclosing client lists. We are saying we will put Lab A, but we will only put the name of the lab if the lab says it's okay to put their name out there. I don't think that we give labs that degree of ability to stop us from protecting the public's health. So I haven't heard, and when we say they could piece it together, we're already saying that we will put Lab A. We already put that out there. So it is not that hard because people have done this research looking at Lab A. I believe maybe that's how we figured out the problem that we have with a licensee that was the subject of disciplinary action. So this is not something new. And frankly, I think that this is also, and this is something that has been what I have been seeing consistently. I believe it should be incumbent upon the legal team, because we do have, maybe you have a conversation with Matt Giancola, because we are talking about these agenda, for a couple of weeks in advance. We obviously have a 2-day posting period, but I would direct you to speak to Director Giancola, to speak to the executive director, because we are talking about this coming on here. We also, on more occasion than one, I know that we have asked for motion language, and we often are drafting motion language in the middle of a meeting, which is not helpful. So anyway, I appreciate the input. I thank you. I think we're ready to move on now. Commissioner Roy.
I just want to commend the former executive director who took the principled position and put this out there in a public health emergency. This was around the vaping crisis and lung injuries. And so I commend the former team and executive director that didn't agonize over waivers and begging for permission, and just did the right thing to protect public health. And so we never got sued. We never got negative feedback. We didn't get any pushback, and we did the right thing to protect public health. So I commend the leadership at the time who did it and wasn't afraid of being sued in Superior Court because we're protecting public health. And I want to commend them for that.
Executive Director.
Thank you, Madam Chair. And so just along the lines of sort of general counsel feedback, also CTIO feedback, obviously we weren't able to come in here with a waiver to show you or a retention policy to show you. These are things that, and again, just to kind of specifically flag the waiver, given what I understand to be the concerns about the proprietary information and the liability, given what I understood to be the intent of the board of approaching this in the coming months here and having a go live date. These were things that I'm looking to develop and keep us on that timeline. So, to the point, I would intend to develop the retention policy with the CCIO, have that out to you before we would go live, develop the waiver process with the legal department, have that to you before we go live.
I do not want that.
So
I'm only one of four votes, but I will tell you that I have seen the memo that talks about client lists. Are we divulging client lists here?
Madam Chair, I believe we are in the aggregate data, which is X6, right? So in that list, in the aggregate data.
But if we have Lab A, anyway, I think we need to be focusing, just as under prior executive director, we cared more about public health and safety than we do about liability. The one last question I will ask is, do we have any, and then we'll move on, okay? Do we have exposure to a potential class action lawsuit from consumers who feel that we're not doing the right job protecting them, their public health, protecting them from consumer fraud. Do we have exposure there for a class action lawsuit?
If I may, I don't want to comment on any kind of exposure in that situation.
Wait, you just talked about us having liability for hiding data. And I'm asking you, do we have exposure here for a class action lawsuit? Do we?
Yeah, and I will decline to answer the question. I will point to my earlier comments about the fact that you can do both here. You can protect and redress the public's interest in access to this information while protecting the commission's from liability. So you can
First Commissioner, thank you. First Commissioner Stebbins, go ahead.
Thank you, Chair. And again, I'm going to go back to trying to parse these two agenda items. I know we got to get to the second one.
Should we move to the second one first? Did I ask you, should we move to the second one first?
We can certainly leave that up to you. I'm gaining comfort.
Okay, sorry, I interrupted you. I apologize.
No, that's fine. You know, through the discussion, I'm becoming, and again, welcome any of my colleagues' feedback or, staff's feedback. If we're looking at the COA, the product catalog, I'm going to put myself in the position of the product manufacturer. I've produced the product, I've had it tested, I'm happy with the results of the testing and who did it, and I'm comfortable then making it available to the public. So if I'm thinking like the product manufacturer, it's been tested, I'm happy with the results. It's the THC count I was hoping for or had estimated, all of those things. If I'm putting that product out in public via our product catalog, I guess I'm less concerned about the lab's name. And again, I know we're trying to do this by March of 2026, and between now and then we may get a lot of input back from the ITLs, but I guess I'm finding myself more comfortable with that. I've had the product tested. I'm happy with the results. I'm now putting it out on the market and it's going into the product catalog. So as we're looking at this agenda item number 5, feeling a little more comfortable that we're maybe not divulging business practices or client lists or anything else like that, because it's putting it on the product catalog. Our metric product catalog is really being driven by the product manufacturer more than the labs. And obviously they're happy with the results. They're happy with the information that they've obtained. So it's not like it's helping continue to address the issues of lab shopping and other things like that. I have a product, it's been tested, I'm happy with the results. I want to put it up on the product catalog, and I'm okay with who is the product manufacturer I had do the testing for me. Now, if that kind of starts some poaching of customers, in this particular case, as it relates to the product catalog, I somewhat think that's unavoidable, but again, I know we're talking about two different issues, but I'm seeing less of a risk. And, again, going back to Jessica, who I know isn't with us any longer, but the certificate of analysis really is driven by the product manufacturer. If they're okay with the testing results, I think it's okay to list the name of the labs that did that work for them. But
Commissioner Roy.
Commissioner Stebbins, I agree with you. Absolutely. And I'm going to ask that we move the question. But I just want to say to the Executive Director that respectfully, I think that was unacceptable because you shared with us exposure on one side of the coin and you refused to answer about exposure on the other side of the coin. But having said that, I just will ask if we can move the question.
Thank you. We're good. Thank you. Okay. So in moving the question, do you want to, thank you, General Counsel, we're going to meeting it. Thank you. I'm saying we're good, because I may be bringing up someone else in a moment. Thank you.
Thank you. One thought I had is whether, given that the concern is whether our own regulations have essentially provided certain assurances, could we decide to take this action subject to us revising just that one line of our regulations? And do we feel that that would?
The problem is the amount of time it's going to take. It'll be 8-10 months before we can actually allow consumers to protect themselves, because the regulatory process is so. So again, what I would point to is, I don't think that, I think that this in and of itself shows that there's precedent for doing exactly this. And all of the arguments that I have heard about client lists, we're not divulging client lists. We already put Lab ABC. So if anybody wants to, that's already out there now. That's already out there. This has already been out there. So there's nothing that Commissioner Roy is suggesting here that is inconsistent with past practice, because I'm assuming this was during COVID, right? This was during COVID, where there was a lot of pushback. There were a lot, we basically almost put a lot of businesses out of business, right? We allowed alcohol to stay open, but we didn't allow cannabis, and it was a huge problem. Right. And so we didn't ask their permission, whether or not under this COVID emergency, we didn't ask their permission. And so this was done to protect public health and safety. And I think that we're at a point where we do see that there's a public health and safety threat right now that we have to address with alacrity. And when we have language that is provided by legal that tells consumers, consumer education, and we're telling them, go educate yourself. All this does is let people educate themselves, and they don't have to have a PhD in data science to figure these things out. They know what they're buying, and they know how to protect themselves. And again, we talk about losing business. We've already seen that there have been competitive advantages to those independent testing labs who might not be doing the right thing. So this is a little bit like secret shopper. It's allowing individual customers to be secret shoppers. So I don't think we're violating regulation. I don't think we're violating past practice. And I don't think we're violating any sort of level of confidentiality in the arguments that have been put forward. It just doesn't jibe with what this actually will do. So anyway.
Madam Chair, if I may, and that's a great question, Commissioner Bennett.
Yeah, very good.
But statute trumps regulation, and we're protected in statute 94G. The commission shall have all the powers necessary or convenient to carry out and effectuate its purpose. If you go to subsection I, prepare, publish, and distribute with or without charge, as the commission may determine, such studies, reports, bulletins, and other materials as the commission considers appropriate. That's in statute.
So anyway, you've moved the question.
Yes.
So would you like to reformulate the motion? I mean, again, I think the retention period is something that merits additional conversation. I think that our Chief of Innovation and Technology raised some very good points there. Because again, retention isn't making people safer, right? Retention is a bigger headache for our team. What I would say is, I think that if you take out, sorry, I haven't seen that.
Commissioner Stebbins, do you have any language you'd want to nuance in that?
If I might, Chair.
Thank you, please.
I think your motion right now is it sits a little bit maybe too broad or too general. I think there is some information that we definitely need to consider when it comes to that retention period. It's not just how much it clogs up our platform, but again, and I think, Paul, you've given, our CTIO has given us some good suggestions of when a clock should start ticking and how long we should be able to.
If I don't mean to interrupt, but if I heard, we don't have to do anything on retention. That's what I was just saying, is that we don't have to do anything on retention. That's really, we could do that without a vote. right? We don't, this is not in statute or in regulation, how long we retain it. Yes.
As I understand it correct, it's not in regulation.
Yeah, that's, I don't mean to, I apologize for interrupting, but I just want to make sure because that's what I heard him say. And I don't even think we need the retention language.
Okay. Yeah, I
did throw some, it makes Commissioner Stebbins, you think that's.
Could you tell him, Commissioner Ray, could you tell Commissioner Stebbins what yours
in the chat?
Okay. You have more? Oh, I have that there. Can you see that from 144 in the chat, Mr. Stebbins?
I can. I guess a friendly amendment would be subject to, if we're asking the ED and CTIO to adopt the new catalog, then I'd love to see the proposed retention period also configured by the ED and the CTIO.
By ED and CTIO?
Yep.
Okay. Is this okay?
Okay. So I'm going to read this out loud and make sure that you are happy with it. But again, we've raised the retention because we heard that, but this is not anything, you know what I mean? It's really more making sure it's current, making sure that we don't have clutter. So moved.
I just want to, I appreciate having that because I think it gives us guidance on what the board wants to have as to how much that data is there, because you said there's public safety, there's police, there's family, you know, teachers and such. So having that guidance is helpful. So thank you.
Thank you.
You, Paul?
Oh, that's okay. All right. Okay, Commissioner Ray, would you like to read your motion? And again, moving the question, I'm probably not following Robert's rules because we have gone far astray.
The motion language reads as follows. Move to direct the Executive Director and Chief of Technology Information Officer to adopt the new metric catalog, which will also contain certificates of analysis for each product to be published by March 2026, subject to a proposed retention period by the Executive Director and the Chief Technology Information Officer.
Okay, Commissioner Stebbins?
If I can ask a question.
Please.
Before, just quickly, the ED and CTIO, and I might have missed this, I apologize. Any cost associated with the build out of the metric catalog?
No, there's no cost that's included in our current statement of work with Metric.
Okay, thank you.
That's awesome.
Good work.
And may I add, also no bandwidth issues because they do it. So no bandwidth.
That was one of the questions.
You and your team and the data team. That's awesome.
Yes, correct.
Okay, so we have the motion. Commissioner Benedon, do you have any further questions? I mean, I've learned a lot today, and I think that this is very helpful. I appreciate the presentation by Metric. I'm really pleased that it's not going to cost us more money to have a better, more transparent system. I appreciate the robust conversation, and I appreciate the input from the legal team because I understand concerns, but I think that we've had a good opportunity to discuss this, and we will have another bite at the apple in Q1 in 2026 to do some of these things. But I think that this is a good compromise, and I appreciate the debate from everybody here. So do I hear a second on this amended motion? Commissioner Benedon, will you second that motion?
I'll second the motion.
Okay, having been moved and seconded, I'll take a call the roll. Commissioner Roy?
Aye.
Commissioner Stebbins?
Aye.
Commissioner Benedon?
Aye.
Chair votes aye. It passes unanimously. Whew.
Thank you, team.
Thank you.
That's a
Thank you
team
very much.
effort. Thank you, everybody.
All right, so again, we have movable. I keep moving people in and out of these chairs, and I know that we have Supo and others who have to come back. What are they coming? Are they coming back for more?
They are going. Yes, Madam Chair, they would be under ED. Just noting that that was the
No, but
to number 5.
Yeah, so what I want to do is, all right, so we've just done 5 new metric product catalog. That's what I'm saying is that since you're in the seat and we don't have to move you around, because I do, yeah, thank you. Yeah, no, but I'm saying you can stay there, and I think that that's, and then we'll have other people come up. So then we will now take up 6 updates to the testing data on the Commission Open Data website. So you're in the chair, you got the floor.
Great, thank you, Chair. So wanted to report to you that the data team and the part of the IT team is preparing to be able to update our testing data on our Open Data website, going back a 2-year look back, so it would be 2024 and 2025, publishing it by March of 2026. Again, we're looking for, guidance on, the contents, but Marianne, our Director of Data Analytics, has recently, just this week, completed automation on pulling information from Metric that'll aid in this process, that allow us to then update this information going forward on a quarterly basis.
And we thank Marianne for her help on this too. So if you're out there, Marianne,
She's definitely, she's listening. I know
she's just happy we haven't put her in the So, okay. Anything further? Any questions? I know this has been.
No, I think this is a monumental shift and more increased transparency and piggybacks on this new product catalog. And, no more lab A, B, C, D, E in a file that is very difficult for the, average person to read. And I mean, including myself, I have difficulties deciphering that. And so I just think that this will be patient, consumer friendly at the end of the day. And I want to applaud you and Marianne for all you're doing to protect the public's health. So thank you.
Thank you. Hold on, just like Commissioner Stebbins. Oh, sorry.
Anything you want to add?
And I did want to provide some clarity, but if you have a question or a point, feel free.
No, I guess I was, I guess this is a separate issue, as I talked about earlier. And, for me, Madam Chair and Commissioner Roy for sponsoring this item, this is certainly an issue I'd like a little more time with. I know we're looking at, I believe, is this following a March 2026 implementation schedule as well?
Executive Director, I'm not sure. I'm not following the question, so you probably understand it.
Thank you, Madam Chair. Yes, I think ultimately item 5 that we just finished and item 6 ultimately would have generally the same timeline. The retention policy was specific to the COA because that is an issue for getting that data intensive material up there. On this timeline, based on the work of the Director of Data Analytics and the CTIO, we would look for the same general timeline. Again, this was also where I had been looking at potentially having some type of waiver, understanding that discussion on the COA has been had. I just put the motion back in there. But yes, we would look to do all of this ideally around the same timeline so that all of the new information on the website is up generally in the spring, March 2026.
Commissioner, do you have an additional follow-up question?
Just if I can, thank you, Chair, to finish my point. For me, I think I need to personally do a little more homework on this agenda topic, knowing that March of 2026 is kind of our goal. I'd feel comfortable, or at least asking to put this off until the January meeting, but don't feel comfortable being able to vote for it today, but certainly if being afforded some extra time to reconsider or take up in January.
Commissioner Roy?
To the Executive Director. So I'm just going to read, even though I definitely hear you, Commissioner Stebbins. The suggested motion language was to move to approve the proposed plan for quarterly releases of raw testing data from Metric with a 30-day look-back basis for an estimated launch of spring 2026, and to direct the Executive Director to work with the legal department to develop, I'll go with opt-out, including indemnification for labs, to acknowledge that labs will be identified and aggregated in raw testing data from Metric and released on the Commission's website consistent with applicable statutes and regulations. So my question to the Executive Director, if on this case you had the opt-out, are you completely comfortable?
I would prefer it on both, but certainly in this instance for the aggregated data, if we had those ITLs that we've obviously been working with to recognize that this is the change that is going to be in the raw data, that would make me much more comfortable.
The opt-out.
Yes.
Okay.
I need to develop it, obviously, as I mentioned earlier.
So we will put that on the agenda. When is our meeting? When's our next meeting?
January 15th. If somebody could fact check me on that.
Commissioner Stebbins, does that work for you?
It works.
Yeah, okay. Right, then we can table this and we will take this up on January 15th. Thank you for that. And I think that is point well taken. All right. So let us take a 5-mile break. Yes. 11. But anyway, yeah, so I will entertain a motion because not everybody took advantage of the opportunity to eat me lunch. I enjoyed my wheat thins, although they did not have salt. But anyway, so I will entertain a motion to go into recess until 2:45. Commissioner Roy? Oh, so moved. Commissioner Stebbins?
Second.
Call the roll. All those in favor say aye.
Aye.
We'll be back at, or it's 2:45, not 1:45. 2:45. Thank you. Yes, yeah. Thank you. Thank you. And we're back from our recess, and this is a little bit longer than the 1 o'clock we promised you guys. So sorry about that. But anyway, we're going back in the agenda, and we will now have the executive director and commission staff report. And Executive Director Ahern, you are up.
Thank you, Madam Chair. And we will start with our licensing folks here, manager and analyst with us, and I will turn it over. The next slide, please.
Oh, sorry. Next slide, please. Thank you.
Oh, I'm sorry. Well, I believe after the executive director report slides, which we'll come back to, we have the license. Perfect. Thank you.
Oh, sorry. I'm sorry. I misunderstood. Sorry about that. Okay. Thank you. Licensing data updates.
Next slide, please. Okay. For our highlights for licensing data, at the time the data was collected, we had 10 applications waiting first review, 22 applications awaiting supplemental review, and 77,689 certified active patients. Next slide, please. Current license applications by approvals, our totals went from 1657 to 1668, which was an increase by 11. Next slide. Our pizza tracker slide, we increased from 1915 last month to 1934 this month. If there's no questions, I'll hand it over to licensing analyst Jamie Wakefield.
Might be asking a question. I was going to go ahead, Commissioner Stokes.
Thank you. Thank you, Chair. Actually, not a question, but since we're on this fun slide, and look to the ED to do this, because we've had conversations in the past about our cultivators, who's kind of in line, who's in the mix, what the potential is. I think Commissioner Roy has brought this up too, like what is the extra square footage that could come online, because we're concerned about price compression and other topics. I did do a request to our data team to get an idea of where all those people are and maybe how long they've been lingering there.
In the queue, you mean?
In the queue. Data provided that information back to me. Can I send it to you to share with other commissioners? Is that appropriate vehicle? Okay.
Thank you.
All right. Thanks. Sorry, Suko, not a question, but thanks.
Thank you.
Excuse me. Sorry, Commissioner Roy.
And thank you, Commissioner Stebbins. I look forward to getting that. My question I brought up earlier with licensing around receiverships. Does the commission get notified when a licensee goes into receivership?
I want to say that we do. I don't really handle the receivership.
Okay. Yeah. Okay. And I don't mean to spot you. I don't know who does.
I can get that information for you.
Do you know who handles receivers?
Licensing manager. Yes, we do.
Okay. And if I may make a request, Madam Chair, could we have a slide in the future of how many licensees are in receivership?
Sure.
Thank you. That was going to be my question that I thought you were going to ask, but then she asked it instead. So really? Yes. Yeah. Thank you. Sorry. Go ahead, Manager Defoe.
Okay. So I'm going to hand it over to licensing analyst Jamie Wakefield to take us through the active cultivator slides.
So as we see here, I guess hello commissioners. Thank you for having me. Great to meet you, Commissioner Benedon. This slide here is our active cultivators broken out by tier. And these are all active currently. So these do not have expired or other statuses listed within it. And as you can see, the total maximum canopy is 4,355,000. That is not the total canopy necessarily that's in use, but rather could be in use based on the tier levels. If there are no questions on the slide, I think we can go to.
I have just a quick question, and I probably, so we have commenced operation, and then we have total maximum canopy, and obviously talking about the issue of relegation. And can you just explain, how we go through that process of looking at whether or not a licensee is growing? It's what is that? I think 75%. And this is terrible that I don't know this, but can you walk me through a little bit, and maybe this will help Commissioner Bennett as well, but a hiatus also makes me forget some of these things. So if you could walk us through that and what that means, because we may be, with your assistance, looking at the potential of caps, which other states have done, or putting a pause. Again, it's not anything, and obviously it takes 3 votes to do any of these things, but it's just something looking at price compression. Are there some things that we as a commission can be doing? So if you could just walk us through that process of relegation that is not related to Ted Lasso. So what is it here?
Let's see. So I know that is a collaboration between licensing managers, Moriarty's team, and our investigations, I believe, or other folks from I&E as well. I personally don't handle them, and I'm not quite exactly sure what that all looks like. But I will.
That's okay. I didn't mean to put
Madam Chair.
That's okay.
I was going to bring up tier relegation, and thank you, Jamie, because we assume all of you do everything, and we don't know, but thank you.
You're on that side.
Just as a reminder, it's going to be enforced January 1. We did vote on that as a board. And so to your point, Madam Chair, under 500.050, the commission may reduce the licensee's maximum canopy to a lower tier if the licensee sold less than 70% of what it produced during the 6 months prior to the application for renewal for an indoor cultivator, or during the harvest season prior to the application for renewal for an outdoor cultivator. The factors, I think that's what you were alluding, cultivation and production history, including whether the plant's inventory suffered a catastrophic event during the licensing period, transfer, sales and excise tax, payment history, existing inventory and inventory history, and sales contracts are some of the factors.
Okay.
Okay.
Right. Thank you. Again, I apologize for putting you on the spot there, but thank you for reading something I could have looked up. So thank you. Go ahead. Thank you. So moving on.
If there are no other questions.
No, that was good. No, again, it's a good conversation. And again, we don't know who parses which parts of the thing. So thank you.
We're happy to get any other information for you that if it's outstanding.
We will be talking to you and other members of the team as we kind of look at this in the coming year as a potential issue to pursue. So thank you.
Absolutely.
Go ahead, Manager DeVoe.
Could have the next slide, please. So this slide here that is broken out clearly into, I'll say, top half and bottom half. The top half being our active cultivators that are indoor and outdoor totals, along with their maximum canopy. So we can see here there's 4,260,000 square footage of total maximum canopy with the 176 active cultivators.
Okay, Madam Chair.
Yeah.
Just to flag, this was requested at the last meeting of Manager Moriarty when she was presenting the licensing update. And so the question was in terms of expirations to break that out. So the numbers on the bottom demonstrate who has been expired for more than a year and who's been expired for less than a year. And I think it also speaks a little bit to the question of still remaining in the queue potentially for canopy. So I think we can try to summarize this, but this was in specific response to a question from last meeting.
Commissioner Roy.
And I'm going to apologize to Director Moriarty, or did I give her a promotion? Director, please. That's your time. Manager. Okay. And she did email me after this because Commissioner Stebbins brought up something like if they're frozen because they expired, can they get unfrozen? And we said, well, provisionally, yes, but if they're a final license. So she reached out to me, and I haven't had the bandwidth to go back into this conversation, but we do need to figure that out as far as if you're expired, you have your final license and you're expired, are you permanently expired or can you resuscitate out of that?
Please.
I think to Commissioner Roy's point, this is a discussion that we should be scheduling. The data has now been sort of answered so that we are able to have that discussion, and I'll work with the chair on an agenda item potentially in January to sort of discuss specific and any changes to process of what we currently have going. The answer that Manager Moriarty provided you was basically that there are ways in which somebody who's expired can continue on with the process. There's certainly steps that they have to take, but if that's not the intent of the board, I think we would put together an agenda item, go through the data specifically that was pulled to answer the questions and discuss if you'd like to see a change in that process.
So to clarify, it's basically if it expires, do you have to start at ground square one, or can you re-up? That's what I just want to clarify the question.
Not at ground one. And if that is the intent of the board, we can certainly change that, and we can go through all of the data to that extent.
I don't think it's necessarily the intent of the board, but I know that there was, I do think there's a little bit of lack of clarity.
Yeah, and if I may mention, where I got confused is that's why we had to go in and give a directive to CIE because the provisional folks that hadn't paid, if that expired, they had to start from scratch. So that's where I get it's gray. I don't understand.
And that was before your time. That was when the license fees were not collected, and then that raised a whole series of cascading questions about what happens to people who believe they were told they didn't have to pay. So.
Thank you, Madam Chair. And I think as of now, all the work that came out of the discussion from that other meeting, I think we'd be prepared for a more in-depth discussion and potentially any updates to process.
Thank you. Great. Keep going. Thank you.
Thank you, Mr. Executive Director, for pointing out those two added points at the bottom of the slide there. The average number of days expired and those who have been expired for more than 1 year. We additionally added a total minimum canopy line for your review as well. And likewise in the previous slide, the total minimum canopy is not necessarily the amount of canopy that's in use, rather the total minimum canopy that could be in use.
Thank you.
And then the last footnote that we would just call out in terms of, just for evaluation purposes is between tier 1 and tier 3, there's a range of 4,999 square feet in between the tiers. Versus when it gets to tiers 3 and 11, there's a difference in between each tier level of 9,999 square feet. So just wanted to call that out, and if that is something you'd like to consider.
Thank you. Thank you. Okay, appreciate it, Jamie. Thank you. It's hard to say your first name and turn. Right? But I keep giving out promotions, So.
I'll take one.
All right, here we go. Before Christmas. That'll be the second best Christmas gift anybody got today.
Let's send it back to.
Okay. Thank you.
Next slide, please. And Madam Chair, may I just go back to the receivership quickly?
Oh, please. Thank you. Yeah.
So legal also receives the receiverships, and currently they're monitoring 4.
They're what, say that?
Currently, legal also receives the receiverships, and they're currently monitoring.
Oh, monitoring 4. I didn't catch what you said. Yeah.
So I just wanted to.
So there are currently 4 receiverships right now. Again, not that I'm sure that most of the 137 people who appear to be watching right now, understand this, but because cannabis licensees do not have access to bankruptcy protection, it makes it more difficult to reorganize, sell a business. And I think this was a point that I don't know if you want to raise it now, but it was something you talked about in terms of when we do have these receiverships and there are license, ownership changes, that is one of those things that.
Yeah. Sometimes we have expedited review, as you know very well. And what I'm hearing from so many people is that we're going to be seeing more, unfortunately, we're going to be seeing more distressed entities and more receiverships. And perhaps the board should contemplate for changes of ownership in these circumstances for expedited review, because these deals are fragile. We're talking about bud tender salaries. And so, maybe that's something that we should contemplate and vote on and give you directive on expedited review for those circumstances.
Thank you. And I think that Executive Director, that might be, I mean, obviously it's not something that we necessarily put on the January agenda, but I think we should, we should think about putting that on the January agenda to have that conversation again. It sounds like, and I don't want to be putting extra pressure on you guys, but ultimately we either have a policy where you guys do it or we're saying, oh my God, we need to do something at the last.
If I may,
Yeah.
we did that talk, state of the cannabis industry, the moderator is very well versed in receiverships, not only Massachusetts, nationwide. And I want to commend licensing because at the very onset, the beginning of the agency, it took for changing of ownerships. It took a little bit of time. We probably had limited staff, and that's shrunk. That window now, we're turning them around much quicker, which is fantastic. But for these really distressed situations, perhaps those need to go expedited.
Okay, thank you. Again, it's just a point that just making sure that because of open meeting law, we don't have the ability to, all four of us, talk at the same time. So just letting people know that this is something, and and again, this is coming back to our newest commissioner. This is also hopefully an opportunity that you, if you have a question or you just want to, I just hope that you will take advantage of that. Again, not here, but sometimes we tend to go a little bit astray from the agenda, immediate agenda, to make sure that we are talking about things that we can put on the agenda for the next time. So thank you. Go ahead.
So, continuing on, this is our host community agreement data. We have the compliant HCAs have gone up to by 82 since last month, and we have reviewed a total of 1,351 HCAs since March 1st, 2024. Next slide, please. Okay. These are detailing the number of HCAs reviewed as well as host community agreement determination notices that were sent out. Below are the extension. Below are the extension information. Extension requests have gone up by 65 since last month, and the average number of days requested is still 87.
Thank you. I'm just reading this again here. I don't know if I had a question here. That's fine. Thank you. I had a question, but I can't remember what it was. So keep going.
And that's all for license.
Okay, good. All right. So our executive director, are these folks all done?
If you are all set.
You can go. Thank you very much.
Thank you.
Thank you.
If I may, Madam Chair.
Please, thank you. Yep. Thank you. So going now to the executive director report.
Yes, thank you, Madam Chair. And if we could reset the slides to the beginning for the executive director, thank you. We're bringing licensing back for that item, so that one is all set. So general, I'm going to go through goals. I do have two just broader updates prior to getting into the goals specifically. One is that I just returned from Canada. Unfortunately, I wasn't able to stay for the entire time. Canada was kind enough to cover my travel costs given our current budget situation. And so I am looking to write up all of my notes on all the wonderful materials, provide those to the commissioners and staff. Would obviously prefer to have additional staff be able to go to Canada. It is a wealth of information, but obviously at this point they needed me there as the voting member, and we will hopefully look to be able to get other folks there in June when they also have another annual meeting. The other item to update the board on, which I sent this morning in a little bit of a time-sensitive issue and just notifying more for the public's sake at the moment, is that under the delegated authority from September 10th, 2020, I've authorized Enforcement Council to modify the payment due date for the second payment currently due this Friday, which is December 12th, 2025, for a date that is not to be beyond the current due date of the third and final installment currently due in February 10th, 2026, related to Assured's stipulated agreement, noting that all of these payments are prior to the renewal date of the licensee, which is August of 2026. No changes to the final amount are authorized, And the extension is specific to the second payment, not beyond the third. And I will work with the chair to discuss the appropriateness of a future agenda item should there be any additional changes related to the stipulated agreement. I'm going to write this and have it also added to the website with the stipulated agreement. I've provided that delegated authority as well in here, and the issue of it being a minor change and on an emergency basis is why I am not comfortable moving past an extension beyond what the third date referenced in the stipulated agreement is.
So if I could just point out, this falls under business not anticipated at time of posting. Again, I think it's really important that when we do have these emergency situations that we're able to have these conversations. But it also does bring me back to the issue, and we had this conversation previously, that the board has delegated, I believe it's 73 discrete powers, that what you're able to do, you literally have the unilateral power to do that, right? We did, I believe, approve this this repayment scheme, and the basically the penalties that were assessed for the potential violations of law that regulation that occurred. But this will be something, I know that Commissioner Concepcion, it was probably 3 years ago, had been thinking about taking a look at the 73 items that we as commissioners have delegated to staff. And I think that it's timely to have that conversation, especially when it comes to things like disclosure, especially as it comes to things like accountability. One of the things that was in the auditor's report was disparate treatment of licensees. We have people on the front line, and this is not any sort of criticism of you, Mr. Director, but there was language in one of the legislative versions of the bill looking at reorganizing the commission that actually would have prevented commissioners from asking any questions to staff while there is an ongoing investigation. And I will point out that, and Commissioner Stebbins remembers this probably clearly, that we did have the death of a cannabis worker, and that death was purposely hidden from commissioners by staff. And Commissioner Roy raised important questions and was able to determine that significant licensing fees had not been paid. So allowing the commissioners who actually have the responsibility for these investigations, for the accountability with which we hold our licensees. And I believe that sometimes we have paid more attention to 30A, which is something that licensees can utilize to protect their due process rights. But we always need to make sure that as commissioners, we are supporting public safety, we are protecting consumers. And so I do think that in the coming year, it will be something I would like to explore, determining how we as commissioners can be more accountable to the licensees, more accountable to the public, and more accountable for public health and safety. So again, I just wanted to make that brief because again, I know that this was not something that we had posted on the agenda. I'm happy to have this conversation here. It truly is right now, your authority to do this. You've made this decision. We have not. So anyway, I do think that it sparks a further conversation about what the commissioners can and should be doing to hold themselves accountable, but to protect public health and safety. Commissioner Ray, thank you.
Yes, thank you, Madam Chair. My question is the executive director. What happens if this licensee comes back again and says the same thing? We're unable to pay.
Thank you, Madam Chair. Right now, the anticipation would be, should I not have extended this within the parameters of all the three payments? So it was three payments of $100,000 at three specific periods of time. The second one being this Friday, the third one being February 10th, 26th, that we would have begun the enforcement action within the stipulated agreement, going after the business for not living up to the stipulated agreement. my point on the minor change within this is that I'm not comfortable prior to having this potentially on a future agenda for the commissioners to discuss if you'd like to change the agreement that you signed off on, that I'm not comfortable extending beyond what that third payment is currently set out, which is February 2026. So as of right now, without this decision, we would begin the enforcement action laid out in the stipulated agreement for them not living up to that agreement.
Is that revocation? I'm sorry to interrupt you. Is that revocation?
That would be ultimately an end result.
And I would like to point out, and this is also, we need to make sure that we're getting good guidance on, disclosures on, I know that, one of the representatives from the company had reached out to speak to me, and I was given guidance that because of 30A, I could not have a conversation with them. So this is part of the reason why we are now discussing something that is not on the agenda, but certainly something that, we know that right now you currently have that unilateral authority to do so, and you have that unilateral authority to speak directly to the licensee. So I just raise this because I do think that there are, I do think that there have been a number of silos that have been created in this organization over the course of a number of years, lack of the ability to have free-flowing information. Open meeting law is an issue. We know that that's an issue, but also 30A has been used to prevent commissioners from getting fulsome information. And when we are responsible for the overall oversight of the commission, and due to 30A issues, we are actively prevented from getting information so that we understand what's going on. That is something, and that drives my concern about whether or not we have delegated too much authority to individual staff, especially as I continue to see roadblocks to getting information about public health and safety issues, that are being handled directly by staff, and ethical issues, making sure that people are making the proper disclosure if there are appearances of conflict or there is disparate treatment. So again, we will raise that in the new year, but I just wanted to make that commentary. I thank you for that. Obviously, I think that that's it's a decision. I know that this is under duress, and I know that this is last minute, but anyway, obviously right now that's your authority to do as you determine. So I thank you for the update and letting us know.
Thank you, Madam Chair. And I would just say as well, the list has gone down by at least one delegation. There was a vote in recent months on specific to a delegation related to petitions. And so within that instance, obviously at that time, the only thing that I'm concerned about in that area is that I am clear on the board's intent. The process was laid out. We had that in the motion. So
just so you know, this is not a criticism of you. It is an acknowledgement, and frankly, it's the legacy of former Commissioner Concepcion. She's not here, but it was something I know she was very interested in doing. So I think that it's just one of those issues that kind of has languished for a little while, and I think it's worth conducting. But thank you. This is no criticism of you, and I think you did what you could, last minute decision, and I think that saving jobs is important. So I'm pleased that you're reporting that. So thank you.
Thank you, Madam Chair. Getting into this, and I will be quick, but obviously can answer any questions in the interest of time here. Just again, a little bit of a summary here. The original goals for 2025 were voted in April of 25. Obviously, part of that was related to my start in March of 25. A full report, which is available in the public meeting materials from the October 1st meeting, is available online. I did do an interim report in November, and I provided an interim report here with the intent to have the final sort of full report through December 31st of 2025 available to you all in January. Just want to highlight a couple things really quickly. There were 5 short-term goals which were substantially completed by June 30th. A couple just updates under those that I'll go through very high level. And then for the 7 full-year goals, we do have 3 very significant deliverables in December and January that I want to highlight. Obviously, you just took one of the major steps today, which was voting social consumption regulations.
You're welcome.
And yes, thank you very much for accomplishing that goal. And then further authorized the legal team to put together all that material for the Secretary. Under policymaking support, the delivery exclusivity report has been received from the UMass Donahue Institute in draft form and is being finalized to be submitted to the commissioners in December with a potential review in January, all with the idea of giving the commissioners the ability, should they want to extend that deadline, that we have the time to promulgate prior to the April 1st, 2026 deadline. And the third one, and I'll go into other slides as well, but under lab testing guidelines, looking to get recommendation to the commissioners in December for potential review in January, which the chair and Commissioner Roy discussed with ITLs and their potential ability to review that and provide feedback within that timeline.
Thank you. Commissioner Roy?
Thank you, Mr. Executive Director. Could you, for the general public, generally summarize the 5 short-term goals you substantially completed?
Certainly. So the governance charter finalization was accomplished in May 22nd, 2025. The 26 budget, although it was not what we were looking for, was completed and started on July 1st, 2025. The establishment of the medical program working group was completed, and they are one of the updates that I'll go through briefly in a moment is to make recommendations on a variety of things, including vertical integration. Oh, thank you very much for going to the next slide. For 3 and 4, I'll have to pull those up. I just didn't, in the interim report, I didn't have everything, but I can pull that up if you're interested. For number 3, it was to hold a Cannabis Advisory Board meeting, which we were able to do. However, we have not been able to set a quarterly cadence due to failure to reach quorum at our second meeting. And the 4th was to conclude implementation of Chapter 180, which is at 94% task complete, with the remaining tasks all under the header of needing to enhance or replace our IT systems.
Thank you.
Absolutely. Thank you.
Thank you.
And I will continue. Thank you, Madam Chair. So just really quick updates under these 3 that have been otherwise substantially completed, just for folks to be aware. While the charter was completed in May 25, the chair and I have engaged Anderson Krieger with a statement of work, including some review of governance questions. So that may provide some updates to the board, and we'll follow up accordingly. Under number 2, for the budget development, it's noted here, obviously, what our budget was at $19.7 million as opposed to our $30 million request. We have submitted a supplemental budget request, FY26, on October 3rd. We have not resolved that issue as of yet. We have also submitted a supplemental bond bill request for FY26 to EOTS to update the MMJOS system, which is the medical IT platform. And if we get any updates on that, we will share them as soon as possible. And then under the number 5, at this point, obviously, the recent Senate bill would impact some of these items, but the working group itself has put together some regulatory recommendations that have been vetted by the external consulting group, which involved a member of the CAB. And it involves vertical integration, although now there's some other things for that group to consider, including medical reciprocity, although the group did have some very significant discussions about wanting to accomplish that. So hopefully we can be ready as needed. If we could advance to the next slide, just some updates under the full year goals here. Again, the certificate of analysis discussion was discussed today with a target launch. I have February here. I think we discussed March, but spring of 26. The quarterly uploads of the raw testing data, we'll just update that may be followed up on in January, was the discussion from earlier today. And the recommendations for changes to testing regulations, protocols, policies are due to the commissioners in December. And we will discuss the best way to engage the ITLs in that discussion as well, at the behest of the commissioners. Under research, data, and policymaking, we are looking to formalize a working group under the CCRP. There is there's quite a bit of information that's been compiled by the Chief of Research. And so I will look to engage the Chair and Commissioner Roy with specifically the CPO, CFAO, and Chief of Research to get that process going. And then other stakeholders would be included thereafter, with the intent to create and implement an autonomous or semi-autonomous research center. So more to come on that. And again, the certificate of its analysis, raw data was discussed earlier. And finally, the delivery exclusivity report is due to you all shortly. If we can move to the next slide.
Do we have on both the delivery exclusivity report, do we have a date? that we're having that. There's also the one that was on the prior page, the testing, you know, the 13, I think it was recommendations. When do we get before?
I have December here. Let me just check if I can commit to a specific date here. I know UMass Donahue is committed to turning this around very quickly on the recommendations. I believe there's a couple things that are just being reviewed. So let me see if I can get you a specific date.
Thank you.
Absolutely. I can move to the next slide. For equity programming, a couple items that have happened. We need to be rolling into our 5-year strategic plan that we should be presenting. One of the items that sort of changed from the initial was discussion of the DIA map. If we want to come back to that and include that, I will look for direction from the board on that as we move forward. For regulatory modernization, this is probably the largest shift from April, which is to change that sort of process to what is the red tape removal working group. And so as of right now, the staff has been assigned to that, and I believe the external stakeholders are being reached out to by GAP, and then we will set an initial meeting of that group. And ideally, what we'll do is put together a very comprehensive list of the regulatory changes that are desired, associated policies, and then look to prioritize that as we get through social consumption today, exclusivity theoretically thereafter, and be prepared in 2026 to get into regs. For social consumption regs, again, that was checked off today. And finally, for organizational structure, I did provide a bit of a summary of where we are at the moment, comparing our FY26 headcount to what was requested, putting some context for our 27 request, which is obviously subject to change, as well as giving some context for what the hiring freeze, where the hiring freeze has impacted various departments, including where leaves are currently causing us to have some bandwidth issues that we are managing through.
What would you anticipate that in terms of, what would you say the percentage of employees that are out on leave extended? You know what I mean? I mean, because it's also, because we don't get to talk about this, but it also reminds us the added pressure that we have on, we're still doing the job. What would be your guesstimate right now? I mean, I don't even know how many people are on leave right now.
I believe in the list that I sent, we have 9 in that category. And I would do some quick math if you're looking for a percentage.
No. It's 9 out of technically 150, but we have a lot of openings, so probably closer to 9 out of 130, would you say?
That's roughly, yes. And so again, I'm looking to provide a full summary of kind of everything that may, and quite honestly, as we do this exercise with the full report in January, after we go through the full calendar year, that may, direct where the commissioners want to prioritize goals going into 2026. Obviously, in approving these goals in April, that was probably more related to the executive director starting in March. So when we want to attack the 2026 goals, I would say can be right on the heels of you receiving a final report in January from the 25 goals.
Okay, thank you. Mr. Roy?
Thank you, Chair. I just want to confirm, it's my understanding for the testing that the outside consultants will attend a meeting where commissioners will be able to ask questions.
That's correct.
Just like the UMass Donahue Institute will attend a meeting for us to ask questions.
I will confirm with the working group. I believe that UMass Donahue would generally be available to answer questions on their.
And then back to the testing, the ITLs will have a minimal 2-week window with the recommendations.
I'm happy to discuss that right now. I think ultimately getting it to you is my number one priority. And then from there, we have 2 major items that theoretically have timelines that we've discussed previously, exclusivity and testing protocols. So I'll work with the chair on scheduling how that looks in January. But ultimately, if we would like to put out the recommendations prior to when it is on the agenda, if we want to have you discuss them with the consultant, I think we want to probably maximize the consultant, right? So if we want to put them out for ITL feedback so that the consultant is speaking to you in a public meeting with the feedback from the ITLs, then I'll work with the chair to accomplish sort of that cadence.
Thank you. Thank you. All right.
And I believe that's all that I have. And so again, the interim report, and I will look to have a final report in January.
Thank you. Okay. Let's see. So we've done that. All right. So I think we're going back in terms of the It's been printed. Okay, so we will now move on to the job description of the director of testing. And I just, one of the things I will say is that I'm not, I saw inside one of the memos stating that it sounded like the directors of testing were leaving because we don't have a standards testing lab, and that's not the feedback that I've gotten. So that was the only thing that I had a little bit of a question about. But I think we should just get right to the job description and get your thoughts on what you think we should be doing right now. And we may or may not, we can vote on this, but I'd just like to get your thoughts about how we. Obviously we have some significant issues. We haven't had consistent leadership at director of testing for a long, long time. And this is such a critical role. The CPO, W. Hilton Creek is here. So I don't know how you want to handle this conversation. Are you starting it, or is the chief people officer going to do it?
Thank you, Madam Chair. I'll start and just kind of go through the memorandum itself. I'm happy to take questions and also follow up, although I know that there may be some desire to get this posted and filled as soon as possible. So happy to go that direction as well. I think ultimately, after 2 instances where we had an individual in the role, which takes a lot of bandwidth from our HR team in recruitment, that we want to make sure that we are looking holistically at the position prior to simply reposting. The definition of insanity is doing the same thing over and over again and expecting different results, right? So really the intent here was for the CIE, the CPO, and I to review a number of elements within this and discuss some options. And within that, I would say a significant portion within this memo is talking about the long-term solutions that I think, may be with the expansion theoretically in the future as it relates to where the direction of hemp goes. Obviously, major changes at the federal government mean that we're not staring that down at the moment. And then also a reference lab, which when you look at the history of this position, was an assumption at the time that the director of testing would be part of rolling up a reference lab. That doesn't mean, to your point, that requires a change in the position, but I think it's something that we need to consider.
It indicates that was why some of these people left so precipitously, and that's not my understanding. At least one of them, why they left. So within any process of losing an individual, our HR department will do an exit and interview. And so while I'm not going to go through the contents of that, I think at the same point, some of those are the elements that we're also looking to include here. So we've had some changes, and we also have some budget issues right now. So where I may, want to go for a long-term solution with the approval of the board is not necessarily what I'm looking to discuss today. More so making sure that we have the appropriate staffing level and support for testing at the moment. So there were 3 short-term solutions that were provided for consideration. I would point out that one of them, the third option listed as Deputy Director of Investigations, is not necessarily one that should theoretically be voted on today. As the chair mentioned, it is not noticed on the agenda, which I agree with. And yet it sort of overlaps within the conversation only because it has been requested. It could be part of a management process in a short-term solution. But I think that the first 2, which is simply reposting the position with some potential changes to the recruitment. I've had a discussion with Commissioner Roy potentially about a bonus structure, those types of things to entice and pull candidates. So really that would be the status quo option of recruiting the same job description, same title, but trying to make some adjustments in the posting. The other option was really, again, referencing some of what we've seen and some of the realities of how we're operating without a reference lab, which is the Director of Testing Compliance, which is recognizing that we are using third-party consulting and a variety of other sources to supplement our program. And that really from what we see on the horizon here in terms of updating in early 2026, regulations, protocols related to testing, that we are looking for somebody who is very comfortable in the compliance space and regulatory space. Both of those 2 options, status quo or testing compliance, we would view as budget neutral. So obviously worth discussions in that regard.
And I think one of the interesting things too, from some of the states that I was able to talk to who have gone through reference labs, is that they would generally have a testing compliance position and a lab director position. So where I did put one of the cons that this position could theoretically become outdated if we went in a different direction in the future, I also think theoretically, if the commission were to have a reference lab, that individual may be more of a lab director type position in that instance, and that a testing compliance position may still be relevant. And so really just presenting the commissioners with some options just for reference as well, as we talked about delegations earlier. If the position were simply vacant and being reposted, I'm not looking necessarily for action from the board. That has been delegated to the executive director to simply fill the position that's already been created. To make a structural change to the job description, the title, the org chart, that goes back through the commissioners per the delegation. So that is ultimately why I would be looking for a vote if you would like to support a change to the position itself. And if you will, Madam Chair, I would ask the CPO to catch anything that I missed or misstated.
Thanks, CPO Hilton Creek.
Good afternoon, Commissioners. No, I think you covered everything. The only comment that I would add is that there's a huge compliance component here. And, you know, I've listened earlier today, the commissioners talking about public safety, and this is a huge burden for the commission right now. And I think, you know, taking that lens and that focus, I think maybe will guide us to a decision today, because we do really need to make sure that the testing department is capable of, you know, conducting the work that they're supposed to be conducting. And I'm not so sure that we can do it right now with the staffing that we have. And to the ED's point, all three of these positions are viable options for us on a short-term basis. I think any of these roles can be transitioned into the larger scheme of things when we look at compliance from a broader perspective.
Thank you. I'll just share my opinion. I think that, you know, if we take any vote, I think it, you know, is a title change only. I think that we can't wait to get someone in that position. I don't know how my fellow commissioners believe. You know, I was looking at the org chart, and I think that we, you know, one of the things that had this conversation with CPO Hilton Creek a long time ago about doing a management audit, you know, looking at what our mission is and making sure within our limited dollars, we have a focus on meeting that mission, you know, public safety, making sure that we're, you know, fulfilling our regulation or our regulatory responsibilities. I think that we've had enough news stories that are coming out that say we don't have time to wait. And I do think that we're almost not controlling our own fate right now. If indeed legislation is passed that changes the you know, structure of how this place operates, I think that that is probably a time, you know, to maybe make a more profound change. But I just don't think that we can wait. And this is one of the things that the executive director and I had talked about is sitting down in the short term, trying to find ways that we can make sure that we have the resources to meet this need. I mean, again, that's just my thought. That's what I would support right now. Is I think that we should be going out and doing a search immediately, because I don't think that we can leave this position open much longer. And I think that because we haven't had that consistent leadership, because we had a shocking departure of our last director of testing, I think that we need to, you know, figure out, and now we have your leadership in partnership with CPO Hilton Creek. I think that filling this position sooner rather than later is important. But I do think that overall we need to do a management review. It doesn't have to be an audit, but a management review to see, do we have the positions that we need to meet our mission? Do we have some positions that we may not need? Do we have some positions that we need to fill? And having a conversation with, you know, AGC Baker about the huge regulatory challenge that we have ahead of us next year. I said, how many new lawyers do you think we might hire? And, you know, not that I probably shouldn't be repeating it, you know, an offline conversation, but he said 3. And I think that, you know, I don't think that that is incorrect. So anyway, I'd love, you know, my fellow commissioners to kind of weigh in with their thoughts, and maybe we can, again, we don't have that other issue on the agenda, so I'm not sure we can take that up. But Commissioner Stebbins, what are your thoughts?
Thank you, Chair. thanks to the ED for thinking through a couple of different options. I'm comfortable, and it thinks I might be comfortable with the track you're taking of reposting this position. I think changing the title to Director of Testing Compliance, because as you point out, it'd be great to have our own lab, but somebody who can manage the process when we're doing third-party testing of any product that we pull off the shelf, and somebody who's just stepping in at a time where we might be changing regulations, might be changing protocols. I think that might eliminate any confusion that somebody might have about what the intention of the job is. I did go back and look at the job description, and I would support some changes to maybe the first line that we use, since we're going to change the title already. But it says the Director of Testing, under the direction of Chief of Investigations and Enforcement, is responsible for the overall operation and administration of the ITLs. I think that needs some more clarification. If I was reading that, I'd be like, am I running these places? Am I overseeing them? Am I regulating them? So, obviously words might make a difference, and I'm sure anybody who goes through the vetting and the interview process probably would have come to a different conclusion. But that language, to me, I would encourage us to change it before we repost it.
Thank you. And that's something that you can do through your, authority. But I don't know if there, Commissioner Benedon, do you have any thoughts or feedback?
I agree with the urgency of moving forward with this. And I did want to question the point of, whether there would be a concern about changing the job title in light of what was posted for today. And I don't know that I necessarily see concerns if we wanted to focus more on the compliance piece to voting to change to Director of Testing Compliance and change the job description somewhat accordingly. That to me seems reasonably encompassed by the noticed topic for today's meeting. And I think in light of what we currently need and what the focus seems to be of the role, that seems the more appropriate way to go to have that focus on compliance. Now, we could, of course, change the job description to focus on compliance even without changing the title. That would be an option as well. But it strikes me that if we wanted to add a word to the title so that it's very clear up front the nature of the role, that would also be appropriate.
Thank you. Commissioner Roy, do you have any?
Yes, thank you. Having sat on two of the panels to hire the Director of Testing, I am sensitive to the amount of work it takes to bring somebody on board. And we didn't get desired results, very quick tenures. And so it is desired results. We just didn't have great tenure. That's true. And so I agree with my colleagues. There is a sense of urgency around this. We had a meeting the other day, and I don't know if the job description speaks to, we're trying to transition to not only inspections, but audits. So I think that's an important aspect for whoever's interviewing for this position, that this is where we're trending. What we did today with the product catalog will only help the Director of Testing Compliance. What we're hopefully going to do in January with the raw data will only help this person in their role. And when we review the new proposal for regulations and we move to standardization, all of these things will help that person succeed in that role. And I want to thank the Chief of Investigations and Enforcement, Noam Jones, and the entire testing task force for the yeoman's work that they have done in a short amount of time. I know this was, the vision is that that's temporary, but I want to thank them for what they're doing to safeguard public health and safety. And Director Enos is overseeing the testing team right now. So the work is happening, and we're providing more tools. This board is, and so if we have standards and everybody's playing by the exact testing by the exact same rules, and we have raw data for the world to see, and we have a product catalog for consumers to see, all of these things will make us a even healthier industry and hopefully make that person succeed. So I know that was kind of long-winded, but thank you. And so I'm in agreement. We need to definitely move forward. I guess we'll take a vote. I think there's
Okay, so, what are we voting on? So you do it, okay, so,
You'd like me to read it, Madam?
yeah, if you,
I think one other thing I would note, obviously, a couple points that were made by Commissioner Stebbins and Commissioner Roy, the relation to audits of sort of the laboratories, the reference to this role with the ITLs, if you'd prefer sort of the word laboratory rather than testing. I think those might be interchangeable here to a certain extent, or we could try to incorporate both. But whenever job descriptions get so long that they don't fit in one line, that always is a little confusing for folks. But the suggested motions here, which I can amend with any feedback from the board through the chair, is move to approve a change in title from Director of Testing to Director of Testing Compliance with associated minimal changes to the job description and posting.
I think that's eloquent, succinct. Well done. All right. Commissioner Stebbins, would you care to make that eloquent, succinct?
Sure. I would move to approve a change in title from Director of Testing to Director of Testing Compliance with associated minimal changes to the job description and posting.
Commissioner Benedict, do I hear a second?
Second.
I've been moved and seconded. I'll call the roll. Commissioner Roy.
Aye.
We're getting to the time where I'm forgetting names.
I know, it's all right. No worries.
Commissioner Stebbins.
Aye.
Commissioner Benedict.
Aye.
It passes out. Chair votes aye. It passes unanimously.
Thank you, ma'am.
Madam Chair, may I make a comment?
Oh, please.
So good. I'm glad that it's passed and everything. I just wanted to say that one of the things that we did get the desired outcomes when we were recruiting. However, we were chasing the scientific component of this position as opposed to, trying to get a blending of what we really needed in the commission. And that's the reason why we need the revision on the job description as well. So I just wanted to say that, the scientific piece was coming at us and we just sort of ran with that train. So we're trying to make.
Oh, but thank you. But I think the most important thing, whomever the candidate is, they be given the freedom and the ability to speak freely about what the problems are so that we can address them. And that is important. And if I can also acknowledge, we had a wonderful presentation by our Chief Innovation and Technology Officer last week, but you also put on a nice event for the staff, which was sponsored by the Executive Director and myself, given the budgetary constraints that we have right now. But I want to thank you and your team for putting that together.
Rocco's Donuts.
Rocco's Donuts. But anyway, I want to thank you because I think everybody enjoyed it. I think it was a great team building exercise and it didn't cost the Commonwealth anything.
Thank you. And I think the staff enjoyed the commissioner's presence as well. So
yeah,
that's great. Thank you.
If I may, just 2 comments into the Executive Director. To your point, Madam Chair, this next person needs to be able to say the words lab shopping and potency inflation. They need to be able to talk about those issues. And so I just want to make sure you're in agreement with that this can be discussed.
Certainly.
Okay, thank you. And then also, Debbie, if you could share your vision for where this would be posted and then when it would be posted.
Yeah, so we can post it right away. There are a number of areas where we can post this. We've been trying to develop some relationships with some, more lab type, cannabis type organizations and staffing firms that can help us to search. And we also post on Mass Careers, and believe it or not, Mass Careers it has a very wide reach, and it costs us hardly anything to do that. So, and we can explore other areas too, where we can post.
Okay. All right. Thank you. Thank you. And again, thank you for all you did last week. Appreciate it. So I'm just still mad that my team didn't win the picture drawing contest, but I had a lot of fun.
We have some pictures there.
Oh, you do. Oh, and I want to applaud Mark for having won the best
Sweater.
Holiday sweater, so you did a great job, so congrats.
That's right.
Yeah.
It was original.
It was totally original. I'm gonna tell you, when he walked in, I said, "You win." It's that good.
Although I kind of like the ED's light up sweater. I was a little partial to that too.
Very good. So anyway, so we have, so again, I thank you. I think it was a good team building exercise, and I also thank Paul for having done a good job presenting that report on the audit. So anyway, so it's about 4:00. One of the things I suggested to the executive director is that item 2, procedure of legal intervention, which may cause us to go into executive session. I told you, I'm already at I'm forgetting people's names point of the day, so I just want to make sure that we have enough time to give this the attention it deserves. So I'm just going to suggest that we table this right now. We take this up in January. And, you know, we still do have a couple of more things, and I would like us to be able to conclude, you know, by 5 o'clock or 5:30. So anyway, so we will, if with the, you know, consensus of the commissioners, I'd like to move that to January. Commissioner Roy, do you have any comments?
I do. Number 8, we got an email. So we might have to table 8 because I want to be able to have opportunity. We got an email from a constituent on the NODs.
Mm-hmm.
Are you comfortable with that?
And now that we're here, can you talk about it with everybody? Or
oh yeah, I can read it into the record. I just want to have more.
But anyway, just officially, we will take that up in January. We will put that on the agenda in January. So,
Thank you, Madam Chair. I'll update our tracking with GAP as well. So we.
Okay, thank you.
Sure. So I received an email. I'm going to share it with my colleagues. I'll read it into the record today during meeting. It's from Scott Murphy, who Scott, you emails me fairly regularly. So thank you, Scott. He's the Director of Operational Quality Assurance and Compliance for Parallel. It says, good afternoon. I hope all is well. I am not sending this email too late for you to see. On today's agenda appears a walkthrough of the deficiency process. Typically, these types of discussions only present the CCC's perspective, but miss the industry's side. I think it would be useful for everyone to understand a few key parts. First, once a corrective action is submitted, who approves or denies? Is it the regulator, their manager, the director of investigation, and the chief of investigations? Does this process ever change? Lastly, on the few changes the regulators have made mistakes, how does a company resolve that? To date, I've received 3 in error. 1 was officially retracted. However, it took a good amount of effort on my part. 2 other deficiencies, the inspector still made us write a corrective action. We had no recourse to further debate the merits. Thank you for your consideration to this matter, Scott.
Thank you, and thank you for reading that in, because I think that, you know, that it may well be part of even a broader discussion about delegated authority, you know, and questions like that. But it also makes me think about Director Enos and the meetings that he's having. So one of the things I would ask the executive director is to, and maybe you and I and Director Enos can have a conversation, because as I originally anticipated when that position was being proposed, it was passed when I was not here, but it's part of the learning process for our investigators, that if we can clarify regular meetings, because again, the reason that I wanted to create that particular position was after a conversation with the director of the Alcohol Beverage Control Commission, who told me that within 6 months of them having begun regular meetings with their licensees where people could come and ask questions, they had reduction of violations by 50%. And so I think that it does 2 things. And I think it could save us money, because if we also make sure that we do have the opportunity for licensees to ask questions and to make sure that they're compliant, we are going to help them. We're going to save them money. We're going to save headaches for our staff and follow-up. But also, I think that's supposed to, and again, it's part of the training as well. It's training for our staff to hear and listen so that they know, and I've heard this again, this is not to disparage anybody, and obviously because, we don't have, we have people all over the state. We have people out in the Berkshires, out to Provincetown. And so there isn't always the opportunity that we had last week where everyone's in a room and they can talk and collaborate and share. So if we could have a meeting with you, Director Enos, and myself, and I don't know if anybody else would like to come, one other person, but understanding how we regularize those meetings. I believe that he's having quarterly meetings with the ITLs, but I have not reached out to him directly, but I would like to have a meeting with you and him and me to understand how can we make those even more effective and more helpful for our licensees and also for our staff, so that they can on a regular basis go out and hear and learn, or maybe our newest employees, they will get a lesson in understanding what it means and what it means to the businesses. Commissioner Stebbins.
Thank you, Chair, and thank you for bringing up this point. And I had the opportunity to I don't want to say take, but drag Director Enos to one of those ABCC sessions, and I agree with you. They're helpful. I'm happy to sit in on those conversations with you because, not to get too off topic, but when we think of a topic we've all talked about, changes to our RVT program, it might be interesting to allow us to use some of those RVT training hours to be compliance hours, or have compliance programs that we can help put out.
Attending these meetings count for RVT?
Or reviewing, material that we put out, but having it count in some way. But I think, again, I've gone through RVT sessions, and I would think after the second year, I get the information. But if we want to encourage continued compliance, finding a way for us to insert ourselves with some compliance training might be helpful.
But that's what I'm saying, is that that's actually what these could turn into, rather than an RVT training that we know is stale and doing the same thing every year.
And it's based off our curriculum. It's not our trainers.
It is not our trainers. It's based on the best efforts with limited staff that we had to stand this place up with very little time and very little money. And initially it was, it was state of the art across the state, but we now recognize, because now many of these licensees or employees have been there for years and years and years, and they're hearing the same thing. And it's on us to make sure that we can do that. So thank you. But that could end up, it's almost like continuing education where, maybe we do have a topic, and maybe we go to the Berkshires and we have one topic, and we go to Cape Cod and we have another topic. So, you can come and get some, I don't know if that's what you were offering.
Yeah, no,
but
it's along those same lines. So I'm just saying, happy to participate in those conversations.
All right, thank you, Commissioner Roy.
I think that's a great idea, Commissioner Stebbins, if we folded that in to some sort of training. And the reason why I had requested the chair put this on the agenda is I've gotten requests from folks out, licensees, stakeholders, what are the most common NODs? And so, along the lines of today's deliberations around transparency, folks have asked, can we publish the NODs? Now, there's two ways to look at that. We could publish the NODs, just saying like, cameras are, or wasting, or, we can post those, or we can, like our other enforcement actions, post them in their entirety, identifying the licensee. Now, I don't know if we want to go down that route, but I think folks are just clamoring for that information. What are the most common notices of deficiencies by license type, quite frankly, right? Because what the ITLs get NODs for is quite different than what the cultivators get NODs, but helping them stay in compliance by sharing what the pitfalls are. There's a commonality, because when you read the post-provisional license inspections, I read the same NODs over and over again. So let's provide that information to our licensees to keep them in compliance.
Thank you. Executive Director.
Thank you, Madam Chair. I just reference the Chief Jones and Director Enos are here for that particular item. And I understand that the discussion might be about tabling it But obviously, we read one item into the record, so if you want to hear from them, they are here and ready to speak to it.
Yeah, you know what I would like to do? I would like to take a brief break until 4:15 and then 4:15 on the dot. And we can give them an opportunity to respond because they'll be coming down here. So if I would entertain a motion for a brief break until 4:15. Sure. Do I hear that motion? So do I hear that seconded, Commissioner Benedon?
Second.
Moved and seconded. Call the roll. All those in favor, aye.
Again, I know we're
Okay, thank you.
It's going
To discuss
Okay, all right, thank you. We're back live. Okay, so,
We have all kinds of documents.
we're completing the conversation on notices of a deficiency. Yes? Thank you. And if I could make a quick thank you to Mike Baker. I may not see you before the end of the year, so wishing you well.
Madam Chair, if you'd like, so I know we were just discussing NODs and
Yeah, that's what I'm saying. So
They have.
yes. So
Okay, thank you, Chair. Well, I'll just talk high level in terms of our NOD process. So basically for the enforcement of 94G or 94I, if we identify or determine that there's a deficiency, we are required that we need to provide, pursuant to the regulations, to provide the notice of deficiency so that they can be able to then put corrective measures, come up with a timetable of how they'll be able to come back into compliance. And the process of doing so, the investigator or compliance officer, they draft the notice of deficiency. The investigations manager is the one that reviews the notice of deficiency. In instances where it's complicated, because there are instances where sometimes they face their questions in terms of the investigator or the IM, then it is overseen by the director of investigations. If the director of investigations is uncertain about how they should proceed, that's where I get involved to also look at the NODs. So on average, we are issuing a lot of NODs per year, like 580 or so on average. So we do not want to stall or delay the licensees in terms of them receiving these notices, which is why pursuant to our SOPs, an NOD is issued within 48 hours, except in extenuating circumstances, wherein if things are gray or complicated, we might also require that enforcement counsel has to review due to a regulatory interpretation. It might take time. So in a nutshell, that is how the process works. However, in instances where we have to rescind an NOD, if we identify that we issued an NOD in an instance that we shouldn't have, we take ownership and accountability and rescind the NOD and then proceed accordingly so that we do not hold the licensee to that deficiency. Also, what the board has to realize is that when we're looking at our enforcement actions, we do look at mitigating circumstances as well. So those NODs do play a role, which is why if we have to rescind it, we need to proceed with the rescission because we do not want those NODs to be on the record when in fact they shouldn't be. And then there's a conversation today, and this came up. I think, Chair, you've talked about this in different public meetings related to the position of the Director of Enforcement Training. We are in agreement. We do see utility. There's a value add for the Director of Enforcement Training to, in fact, be able to be out there and providing these trainings to the licensees. As a matter of fact, we also are interested in ensuring that as part of our affirmative relief, if we're seeing that there's a pattern, in terms of what the licenses are getting involved in, for us to then, have a mandatory training as part of our affirmative relief. So we are interested in moving in that direction. And we're looking forward to the conversation between you and the Executive Director and Commissioner Stebbins to that.
Thank you.
Then the common NODs that we see are related to inventory discrepancies, signage, advertising. Those are the common NODs that we see, and I believe storage as well.
Thanks.
Sorry, if I may, Madam Chair, I think as well I think a point that the CIA just made is very relevant to the red tape removal working group that will be meeting soon, which is some of those things, some of the NODs that require a lot of administrative burden on our staff and impact the licensees. should, changes be made under the header of advertising, which is relatively broad, that could really move the needle for those in the industry as well as our staff.
So have you made suggestions for red tape removal?
If I may, Chair, we are in fact, we've compiled some information that when you all get together, you'll see, what our proposals are related to that. We have had an ongoing list that we have been sending to our counterparts in legal department, so we are pulling from that and also, looking at the climate or the environment where we are right now to ensure that at least based on implementation, the issues that we're seeing, we can also, provide those during this process. And then we've had from licensees as well in terms of what their needs are and what their concerns are during inspections. So we are including those or incorporating those proposals, through the red tape removal process.
And Commissioner Roy has a question.
Comments and questions. So, Chief, you and I have had this talk. So we don't assess a fine with an NOD. Other jurisdictions, some of them do assess a fine, right, with an NOD?
If I may, Chair.
Please, thank you.
Yes, we are, at this particular time, we're not assessing, as far as our fines assessment process, we are not assessing a fine with the NOD. However, we have been working very hard, diligently to put that information together. Enforcement Counsel and his team, they've worked super hard to put that together. And we are presenting that before we'll be presenting that or advancing that to the Executive Director. That way he can then advance it to the board for the board's consideration and contemplation. So we have been working towards that as well.
Thank you.
The other question that's come up is, can folks appeal an NOD? Is there any process for that? Please.
Yes, if I may, Chair, we do not have, there's no hearing right related to a notice of deficiency. And the reason why is because a notice of deficiency is not meant to be punitive, right? It is giving them an opportunity to correct the issues so that they can come back into compliance, which is why there isn't a hearing right at this particular time. And then also, as you mentioned, we don't have a process where we're issuing any fines related to the issuance of that specific NOD, unless if there's an enforcement action, right? So that's why through enforcement actions or administrative process, there is a hearing, right? But for the NOD specifically, as I mentioned, we're issuing at least 580 NODs per year. That hearing officer or those hearing officers will be pretty busy if that's the case. And also too, which is why we move towards, if we find out that we cited there's a wrong regulatory citation, we rescind the NOD for that reason, for those specific reasons as well.
Thank you. Director, Commissioner Bennett.
Thank you. I have a few questions just for clarification. You mentioned a couple of times 580 deficiencies a year. If multiple deficiencies are identified during a single inspection, is that considered one NOD or are those separate?
If I may, Chair.
Please, thank you.
Commissioner, it's one NOD. So that one NOD talks to that inspection on X date. This is what we observed. And then we identify what the non-compliance issue is or what the violation is. And then we tie it to the regulatory citation so that, the licensees also while it's also a corrective measure, it's also an educational tool, for the licensees as well. We've had licensees who have actually, in fact, have told us that they were not aware of certain regulations and things like that. So that's why we need to be able to connect. There has to be a nexus between the violation and the regulatory citation. It's one NOD.
Please, thank you. Oh, yes, yeah, go ahead. Yeah, thank you. Sorry.
Another question that I have is, provided that the NOD is corrected, so they take corrective action, which it sounds happens most of the time, does the fact that there had been an NOD have any impact on subsequent renewal or on future new licensure by the principals? Or as long as it's corrected, is it, like you said, it's not punitive in it?
If I may,
thank you.
Right, no, the NODs are not a factor when it comes to renewals. They're not a factor, that's why prior to even final licensure, while ensuring that they've actually they're now they have corrected the deficiencies and they're actually compliant. So they're not a factor as long as they're corrected.
Please keep going. Yep, please keep going. Yep.
Yeah, this is my last question, which I think is more pertinent to our discussion today. Is do you have a sense, putting you on the spot here, approximately how many of the deficiencies are overturned or rescinded? Is it very, very few?
If I may, Chair, it's very few. And then I'm relying on the information that I have since 2020, since I was the Director of Investigations. It's rare. It's a rarity for that to happen. But then also it speaks to our process, right? Our process of transparency, which is if we find out that we have the wrong regulatory citation or that we shouldn't have issued an NOD, we take accountability. We're willing to to rescind it for that reason. So it's a few, it's not a lot. Yeah.
Thank you. Okay, thank you. Commissioner Staff, I told you. Oh, I'm sorry. Go ahead. Thank you. Yep.
Thank you, Madam Chair. Chief Jones kind of touched on this, but I just kind of wanted to revisit that point about the educational nature of the NOD. Again, that is a very, very important aspect of the NOD. Obviously, we use the NOD with specificity with the narrative linking to the regulatory citation to obviously give the licensee the most accurate information regarding our observation, our discovery. So there is really kind of no confusion on their end where we're coming from. Obviously, with the aim of getting them back into compliance as quickly as possible. But again, as Chief Jones says, it's a teachable moment for the licensee. So if the honest answer was we were not aware we couldn't do that, we were confused about that, the NOD is the perfect way for us to clearly kind of identify and clear up that understanding of the licensee there. So again, I just want to stress the educational aspect of the NODs is paramount, and it's a big aspect of what we do and what we hope to achieve with the licensees.
Thank you. Right, Commissioner Stebbins.
Thank you, Chair. And I just want to I'll give them a chance to answer the question, but just want to thank you both for the time you afforded me yesterday when I saw this was on the agenda. I appreciate you carving out some time, answering some questions that I had about NODs. NODs are tied to inspections, and I think sometimes all of us get the question of why do so many investigators sometimes show up for an investigation? I'll give you the opportunity to share the answer you shared with me because I think that's important not only for all of us to hear, but also for the industry to understand and get some clarity around. So, Chief or Armin, whoever wants to take it. Okay.
Thank you, please.
Thank you, Madam Chair. Thank you, Commissioner Stebbins, for your question. Yes, so let me start by saying the number of participants on an inspection, I would say, is not purely indicative of anything in itself. There are various reasons for why we would have a larger number of individuals on an inspection. If you can imagine a co-located facility, that is a tier 6, tier 7. And if we're talking about a medical facility, that you'll have the grow operation, product manufacturing, potentially the retail arm, all under the same ceiling, same umbrella. Obviously, to increase efficiency on our staff, we have constant collaboration. So if we have a medical lead and an adult use lead for a co-located establishment, they will conduct those together. But again, if we have a tier 6 facility, we also need to speak with staff, might need to review records to increase efficiency and obviously to kind of cut down on the amount of time we are there. We might need 4 people to go and scan plants and inventory. We might need another 2 people to go to review records. We might need another 2 people to go and look at historical security footage dating 60 days back. So it's always with an aim of how do we increase our efficiency. As in addition to that, our training program for our new investigators, shadowing inspections is a central component of what we do. So in some instances, you might have individuals there that might be within their first 30, 60, 90 days. They are obviously going to be shadowing kind of our more seasoned, more experienced investigators because I think as we can all imagine, there is really no substitute for that on the field training and that experience. Now, again, there are some instances where we might be having a certain aspect in mind, or we might have a certain investigation where we need the certain numbers we do. But I would just say off the bat, just because we have a large number there is not indicative of anything in itself. Training opportunities, the scale, the size of these facilities, there are a number of reasons why you might see a large number of individuals on such inspections.
You let people know when you come in with a tour de force here, a force.
Absolutely.
that it's a training issue and not scaring. And so, please, thank you.
Madam Chair, the other part to this is that, in addition to trainings and everything else that I would say, also, we want the public to understand this and the licenses to understand this as well. We're not always there, right? So our unannounced inspections are not happening all the time or frequently. So there are instances when we conduct that unannounced, we haven't been there for 9 months. So you might see that there's a large number of people that are there, like Alan said, to create that efficiency. And also, we don't want it to be a situation where if we have less staff, let's say, for example, we're at tier 11, that's a big cultivation. We don't want to be missing certain components of certain aspects of the, of that facility because we don't have adequate staff or sufficient staff to be able to cover certain parts of that area. So that's also part of it as well.
Thank you. Commissioner Wright?
Thank you. Thank you both very much. I have two questions. When an investigator goes on site and then comes back and writes their report and their NODs, is there a checks and balance? In other words, does their supervisor sign off on the NOD?
If I may, Chair.
Yes, thank you.
Yes, I had mentioned that earlier. Yes, the investigations manager is always the review.
It's always a sign off.
They sign off. And then if it's a situation where the investigations manager has a question and is not sure, then it's reviewed by the director.
It would go to you.
And then it will come to me if the director of investigation. But that's rare. Honestly, I have not, the whole year, I've not seen a single NOD because they are that competent. We have a competent group. And as a matter of fact, they also have peer reviews between investigation managers where they do peer reviews on their NODs or on their, inspection.
I like that. I didn't know that.
Yes.
Okay.
We do have that as well. And then if I may add as well, and this speaks to our process, how efficient it is, failure to adequately address NODs or the plan of corrections or, instances where they do not implement what they've articulated in the plan of correction can lead to, administrative enforcement action.
Right.
And to date, I don't believe that we've had to really do that. I would have to check because that's how, efficient our process is and competent, as far as our staff is related to issuing these NODs and communicating with the licensees.
Madam Chair, Sure. So, Chief Jones, you might remember when we had the two agents in a vehicle discussion. And I don't know if you remember, I had asked you and your team to put together the NODs for delivery before to make sure there were no glaring public safety NODs. And you guys did that amazing job, and we were able to make an informed decision. How difficult would it be, and not saying it needs to be done tomorrow, but to do that exercise across each license type, so that, because that's what the public is looking for, like the top most 5 common NODs per license type that we could put on our website so they can see, like, then that would drive Armin, Director Enos, to teach to what's, constantly being violated. That would help shape what he would do out in the community. So I don't know. I know you're short staffed, and I know, a lot of folks are on leave. We already talked about that, but I think it would be an enormously helpful tool for commissioners, for licensees, and for Director Enos to help shape out there in the community. So I don't know if it would take you a couple months or whatever, and I don't know if it's like at your fingertips or how much work it would take to get that.
Please,
thank you.
Commissioner Roy, can we get back to you with that? Because I really do not want to respond and say we can do it X amount of days or months without conferring with the team.
Right.
But if I may suggest too, is that for the trainings, because it hasn't happened yet, right? Armand has not had an opportunity to be able to do some outreach related to trainings. And what that will be part of the framework, looking at those NODs internally to see what are the pressing issues, what are the issues that are, the frequently asked questions and things like that. That will help inform Armand in terms of how he'll be, I'm sorry, I'm so used to calling him Armand, Director Enos, in terms of how he needs to tailor the trainings, for the licensees. So that's all part of it. That's all part of the framework in order for him to be able to do that. And by the way, he's going to need a team Right now, he's just a team of one.
I know,
Right.
and he's overseeing a team of
Yes.
one overseeing a team.
All right, thank you. Just because I'm sensitive to the time and trying to make sure that we have, so do people have any additional questions? I think that.
Well, I just would like, so next steps would be give you some time to, the question I just asked about, aggregating that and then come back to us when you're ready, I guess.
If I may,
Please, thank you.
yes, yeah, we will look into it and then we'll communicate through the executive director what we find and all that. And then while we have the floor for the licenses that are listening, please, the signage is also a big deal. Let's make sure that the signage is up there on the door, on your doors or wherever you need to have it so that when we come in, to inspect your entities, that at least we see those limited access signs, signage, and also, hand washing as well.
Thank you. Are you, yeah, thank you. And obviously we'll be interested in this and look forward to working with both of you in the new year to do even more. So thank you. With that, I do want to get us to be able to talk about the 2025 industry report. But CFAO, we might, because I don't want to give short shrift to any conversations that we're going to have with you. It's now 20 minutes of 5. And so we can get through the vote for commission treasurer and secretary. I don't have a hard stop at 5, and I don't know if anybody else has a hard stop, but if you don't mind being a little patient to see if we can get to that. Otherwise, I think you had mentioned to the executive director that we could deal with this in the first meeting in January.
Correct.
Okay.
The vote, the submittal to the Joint Ways and Means is until the end of January, so we have some time.
Okay, all right, okay. Because I also want, I do want to have the conversation with the executive director about looking at sort of our structure and what we need and what we need more of. And so I would like to have that conversation, frankly, in advance of the budget, because I think it might shape some of the conversation. So that. All right, thank you.
Madam Chair, we are scheduled with the CFAO and CPO, I believe, next week.
Great, thank you. So I'm moving around a little bit to just make sure you get everything done. A vote for commission treasurer and secretary for calendar year 2026. I'm not going to make this a big issue, but I don't know if Commissioner Stebbins would like to nominate anyone to replace him after he has capably served as the secretary. Given your deep knowledge of secretarial duties, do you have any nominations that you might like to make?
After a coin toss and I lost, I would be pleased to nominate my colleague, Commissioner Benedon, to be the commission secretary for calendar year 2026.
Excellent. Congratulations. Do I hear a second?
Second.
Would you like to give him an acceptance speech?
Just accept. We got a voter in.
I don't have, but in the interest of time.
Good answer. Good answer.
We can always put that in January too. Okay, having been moved and seconded, I'll take a call of the roll. Commissioner Roy?
Aye.
Commissioner Stebbins?
Aye.
Commissioner Benedon?
Aye.
And chair votes aye. That is unanimous. And I will nominate Commissioner Roy to continue as treasurer for another term, unless anyone else is really
Right for it.
take on that additional work. Any questions and comments? Commissioner Stebbins?
I'm happy to second that. I'm also happy to, where the treasurer has the opportunity to pull me in, I'm happy to kind of be I don't want to say a second set of eyes, but just because of budget issues, happy to join her in the meetings where we're not violating the open meeting law, but still second your motion to elect her for calendar year 20.
Stuck with me, Lisa.
Excellent, thank you. Having been moved and seconded, Commissioner Roy?
Aye.
Commissioner Stebbins?
Aye.
Commissioner Benedon?
Aye.
Chair votes aye. We unanimously reappoint Commissioner Roy as treasurer. So now we will be moving on to the discussion and vote on omitted data from the 2025 industry report regarding public health and safety. And this, I know Commissioners Roy and Benedon have had an opportunity to dig deeper, but I will ask Commissioner Roy to begin this conversation. And I believe you do have a motion that we can consider as well.
Yes, thank you, Chair. And I want to thank my colleague, Commissioner Benedon, for joining me in this. And I want to thank the Executive Director for also scheduling the meetings. In our meetings, there were two areas where we focused on, and this is in regards to the 2025 industry report that our research team is statutorily mandated to produce and provide to the folks in the legislature. And so doing a deep dive on this, we wanted to look at two areas. One is content that was redacted or edited, and two was process. And we found, significant issues with the process and how this worked internally. Chair, I don't know if you want to talk which one you want to take first, but one is content and the other one is process.
Well, I think, I think I already read the most concerning thing to myself, because as we are looking at the issue of, compliance with our testing regulations, and I see that this was to me, this is the most glaring example, is that we've gone from economic pressure can potentially drive growth. This is the original language. Economic pressure can potentially drive growers, product manufacturers, and labs towards higher cannabinoid results and passing safety screens. However, regulators may further incentivize accuracy and honesty, provide additional consumer protection, as well as fidelity of industry compliance with off-the-shelf testing practices or state-run standard testing laboratory. That's replaced with to provide additional consumer protection as well as fidelity of industry compliance. The Commission may offer consumer education and off-the-shelf testing practices. To me, this was a very important message to be sending to the legislature, especially because we are constantly advocating that we need a state-run standard testing laboratory. And the reason we need that is because we need to have consistency, we need to have transparency, and especially when there was information that was derived from our research team and frankly from outside investigations that says that there is some data that show that economic pressure can drive some players in the industry towards behavior that does not allow us to protect public health and safety. So that is one substantive change that is troubling to me. But I think that, rather than looking at the substance, and maybe you can address that, but we can get to the process if there's not,
Yeah.
Go ahead.
And if I may, I do think it is to take out the first half of that sentence makes it inaccurate or at best incomplete. And what I mean by that is in October, we got public records requests from the Wall Street Journal, and they did a piece about moldy products in Massachusetts. And our research team actually wasn't included in that process at the beginning, but then it was pulled in. And so I'm just going to highly summarize, if that's okay, what the Wall Street Journal concluded. According to reporting in the Wall Street Journal and related industry analysis, cannabis cultivators and product manufacturers and labs are driven to manipulate potency and safety screens primarily by intense economic pressures stemming from oversupply, high taxes, strict regulations, and a flawed market structure that rewards high THC percentages. Key economic factors driving this manipulation include consumer demand for high potency, intense competition and oversupply, lab shopping, high regulatory costs and taxes, lax or inconsistent regulatory oversight, and safety screen manipulation. And so I guess my concern is that knowing this, why this was recommended by legal to redact it or remove it, when we could have put a citation, left it in, so it would be not an incomplete picture of what drives this, but a complete picture with a citation perhaps to the Wall Street Journal or MJ Biz Daily, who had it as well. Also, my concern with removing this and not providing this information to the legislature is at the same time that this was being recommended to remove by legal, our task force was conducting an investigation about manipulated data at the very same time. And so this doesn't paint a clear picture to the legislature legislature. In matter of fact, it paints a half picture, an incomplete picture, and I don't understand why we could have just put a citation to this to the legislature as we're advocating. We need more money for confirmatory testing, and we need funds for an internal reference lab. So I think this was misguided to remove this. And we say data, but data can mean facts and information. It doesn't have to necessarily just mean numbers, but this was removed and it changed the messaging to the legislature, this consideration number 5.
Commissioner Stebbins?
Thank you, Chair. And quick question, if I can. Commissioner Roy, you're suggesting that the testing consideration number 5, the pre-legal edit recommendation out of report version 10, I guess, are you suggesting that whole paragraph shouldn't have been altered and removed?
Exactly, I'm suggesting, because when you read for folks listening, it was, quote, economic pressure can potentially drive growers, product manufacturers, and labs towards higher cannabinoid results in passing safety screens. And then in the post edit, it got rid of that entirely. So it's to provide additional consumer protection as well as fidelity of industry compliance, the commission may offer consumer education, off-the-shelf testing practices or state. That's a very different thought than what research had recommended. And we have to paint an accurate picture to the legislature when we're asking for funds. And so we could have just provided a citation from the Wall Street Journal or other reputable sources to bolster so it doesn't come across as subjective. It is objective, right? We don't want to be subjective here, but so I don't understand why this thought was removed when we could have just bolstered it with citations.
Executive Director Ahern.
Thank you, Madam Chair. I just want to highlight a couple points. So obviously what we tried to do was put the different iterations, and obviously all of these reports go through a variety of edits through a process that the research team works with other folks. And so I just want to clarify as well, because the agenda item is obviously omitted data. And so just want to clarify as well that content when omitted was mentioned earlier, and data can mean facts and information. I think that clarifies.
I'm reading the dictionary, okay? And it says data, as in information, a collection of factual knowledge about something. And so for people to hide behind the word data is, once again, obfuscation. Data is information. And I will point out that our director of research had requested information. And that's why we have a motion to improve the process, because if there was not clarity, not sure if there wasn't clarity, but there is, that's information. And the only reason that she found out about some of this data, the numbers, is because an outside party did a public records request, and she heard that speech, and then she took that information and then was able to add that into her deliberations. And so I also want to say that information was changed in this report. So I'm hoping that in your memo, which states that somebody here made a misstatement, I don't think that it's a misstatement of fact by either, myself or anybody else as a commissioner. And it is not a misstatement to say that information was changed. And the fulsome spirit of what we're trying to do, which is protect public health and safety, that did not occur. So I don't think it was a misstatement on my part. And I can find other places where the report was edited with an eye towards liability rather than public safety. And so that is troubling to me, that is not a misstatement. That is what happened. So, and if you have a comment.
Thank you, Madam Chair. So I think clarifying that, again, what I tried to do here was lay out the different versions if the commissioners would like to discuss those as well. I understand that this has been discussed before my time, the timeline of data. I completely, and I tried to reflect in here as well, that I think, what would have been an obvious process improvement, what I think that we can do moving forward is if data is being pulled at the request of external stakeholders, that be shared always as a process standpoint with internal stakeholders. But obviously as well, what I tried to lay out here is that the information that was requested was provided. I completely understand your point on the timeline of it, so I tried to lay that out as well. And in terms of when using data as facts and information, I think that's an important clarification. So thank you.
Commissioner Roy, oh, sorry, back Commissioner Stebbins, I stand up.
Thank you, Chair. And just to finish up our point, and this is a good conversation for us to have. Certainly, I want to hear more about process improvements for the next time we need to do this, because this is certainly not going to be our last research project. But kind of getting back to the changes in language we were just talking about, even if I had seen this version, economic pressure, not sure how I would have landed on whether to include that or not. I would have had a problem with regulators may further incentivize accuracy and honesty. As a regulator, my job isn't to incentivize accuracy and honesty. That should be demanded, or that should be required. So I would have had problems with some of that language already. I appreciate my colleague's point about what might be missing in the final version that we all voted on. Not you, Chair. I know this was before you returned, but I would have had problems with that segment of that language if we're speaking first to that paragraph. But anyways, sorry.
Commissioner Roy.
Thank you. I would just like edification under consideration 6, the clear bullet. It says comment from legal on consideration 6. Quote, edited to try and reflect the research perspective without clashing with the testing compliance monitoring perspective. Can someone provide edification what that means?
If I may, Madam Chair.
Please, thank you.
I can certainly ask for that. I believe that was referencing a former staff member. I obviously don't want to reference individually. And I believe that the reason that's in here specifically was the conversation that we had, Commissioner Benedon, Commissioner Roy, research, data, reviewing this. I think the request was to add any additional notes on the change. And so that's what research was able to pull from their notes. I don't know if there's anybody who could speak to the specific point that was made by that individual.
Is the general counsel? He was at that meeting.
Yeah, why don't you, would you mind joining us up here at the microphone?
And I would just obviously, not having been there, but I was reading that as obviously legal is not the only other department that is requested to review this through the research team's iterative process, I&E, community, a variety of different folks, the executive director. At the time, it was the acting executive director, are all asked to review and provide feedback. And so I had looked at that as feedback that may have come from the I&E perspective.
Madam Chair. Thank you. My question is to the general counsel. So if you could provide with specificity what this comment from legal meant, edited to try and reflect the research perspective without clashing with the testing compliance monitoring perspective. My other question is, this had a legal review in August with attorney Ladazinski. And so why did legal feel the need to go back in at the 11th hour and pull this and make more suggested edits? And privilege has been lifted, so we can talk freely.
Thank you, Madam Chair. Yeah, just before I get into anything, I do want to just clarify that privilege has been lifted, and so I am. In response to your questions, I would reiterate what ED just said in terms of trying to harmonize comments received from the different departments during the review process. And without looking more directly and added, I can't add anything more to that right now.
Okay, and my second question was, it was reviewed by Associate Counsel, General Counsel Ladazinski in February, and why did, in August, which was on the timeline, and why did you feel the need to go in February, right before it's going to be presented, shortly before it's going to be presented at a meeting, to make further suggested edits?
If I may, Madam Chair, again, I have to check earlier notes on that. I'm recalling that the August review would have been before I arrived. And so there was I wanted to make sure that I had a chance to review it myself and, add input to it. So.
May I ask, Madam Chair, why did you feel it was necessary to remove economic pressures can potentially drive growers, product manufacturers, and labs towards higher cannabinoid results and passing safety screens?
Again, Madam Chair, if I may, again, making sure that we have waive privilege, and so I am free to speak here. There were considerations, again, liability considerations with respect to ongoing litigation that, made us recommend changes to that language. I think primarily, and that was certainly one of the factors that went into the change that we recommended there.
You say ongoing litigation. We are not parties to any ongoing litigation that I'm aware of, are we?
If I may, Madam Chair.
Please, thank you.
We are not a party to ongoing litigation, but there is a litigation that is pending that, as General Counsel, it is part of my job to try to limit the liability of the Commission and to try to manage and mitigate risk. So as part of that, obligation, I make certain recommendations to the board to consider.
Did you consider the liability risk of hiding information from the general public about and the legislature providing that information?
Again, I guess I take exception with the suggestion that we were hiding information. I think the issue was we wanted to be accurate with what was being stated in a way that protected the Commission. So I would not call that hiding information.
Did the information as developed by the research team point towards potential testing inconsistencies and testing fraud?
If I may.
Please.
I think the question is better directed to testing to answer that question. I do note that as part of their Q&A document that they released after the report was released, they did indicate that there were no changes made to the data sections of the report, and that the only and I'll leave it at that.
The information. So the reason this information was kept out of the report and the characterization is because you were concerned about liability. That's what I'm hearing.
That was part of the consideration, correct?
So again, I'm raising the question because we, at the same time, were apparently investigating one independent testing lab that appears to have had significant problems with testing accuracy, had economic incentive, and as a result had grown its business to now be doing 25% of the testing across the entire industry. And then we found that they were not doing the right thing. So at this time, when I hear that you are concerned about liability vis-a-vis an external vendor's lawsuit, I don't think we're party to that lawsuit, so that's not our liability. But our potential liability could come by failing to protect public health and safety, by failing to do the regulation that we need to make sure that there is consistent reporting on THC levels, to make sure that we're protecting patients so that they can get the proper dosage of medicine they need. Are you concerned about that liability?
If I might just respond to a few things that you said there. First of all, I will get to your question, but let me just first state that as General Counsel, there's a firewall that exists between Enforcement Counsel and General Counsel. So I don't get information related to ongoing investigations. And so there's a reason for that. So to the extent that you suggested that the GC had knowledge of enforcement actions while these edits were being recommended, that's not correct. I will also add, in response to your question, that while the Commission is not a party to that ongoing lawsuit, that could change. And we could be added to the lawsuit. So I am trying to make sure that I'm answering the question in a fulsome way where the thrust of the changes that were recommended were offered in an effort to limit the commission's liability and to avoid it from being added to this ongoing litigation.
Okay, so can you answer the question that I asked?
Could you repeat the question?
The question is, given the fact that the information that was being put forth when our director of research was not given appropriate access, I believe, to testing data, that an outside licensee had done a public records request asking for this public information. And the whole point of our research mandate, read this. The Commission shall develop a research agenda in order to understand the social and economic trends of marijuana in the Commonwealth to inform future decisions that would aid in the closure of the illicit marketplace and to inform the Commission on the public health impacts of marijuana. And it goes on. We have a mandate, a statutory mandate to report, which I'm not sure when you first arrived, I'm not sure you understood the context of what that research, why it was being done. It is to protect the public health and to inform policy decisions. When you approved the removal of a statement that literally lays bare the economic pressures that can drive growers, product manufacturers, and labs towards higher cannabinoid results, that language is meant to say to the legislature, we need to do more to protect the public's health and safety. It's an issue. And you took that out. But further, part of what we're trying to do here is to convince the legislature that to do our job, to protect the public's health and safety, we probably need a standards lab. And so when we take that critical nugget of information, which by the way, our director of research, that was not given to her. It was not given to her after the public records request happened. Now, again, that's what I think the motion we're going to put in place here. But when I hear you say that you removed that language to protect us from liability, yet I ask you, we know that there has been significant problems across the system in Massachusetts and in other states, that it's a public health and safety risk. So are you not concerned that by taking that information out that specifically names the problem, that you have not exposed us to liability because we're not doing everything we can and should be doing to protect public health and safety? Do you have concerns about liability? You previously said you couldn't comment about it, but I think it's incumbent upon you to protect us from that liability.
Thank you, Madam Chair. I stand by the edit. I think the edit was offered in good faith, and to Commissioner Roy's earlier point about the Wall Street Journal having reported on the phenomenon, obviously the information about that phenomenon was out in the public, and so the fact that that sentence was not included in the final draft of this report did not somehow prevent that information from being released to the public.
So do we just count on the Wall Street Journal to do our job?
Is that a rhetorical question, or?
No, that's a real question.
Well, I think the legislature would look at all the information that is out there available to it in making its determination.
Okay, thank you. Right, Executive Director Kern, I think you probably can move to the process.
Thank you,
now.
Madam Chair. I just want to also sort of reference in here, we did look at some other considerations based on our discussion with Commissioner Roy and Benedon and the research team. And I just want to highlight one of I think some of the comments that were made from the research team in that discussion, which was that through this process, that, these considerations were improved for for clarity was the wording. Now, that was not specific to this when you were discussing one where you're asking if something should have been removed or not. And so for that, well, I also want to reference the fact that the research team was very clear that they felt that the considerations with the feedback from their colleagues were improved through the iterative process that is carried out for all these reports, that in a number of these instances.
Can I just say that commentary came after the original conversation?
It did.
Yes.
Yes.
Yeah.
After the original conversation.
The original conversations with former Assistant General Counsel Bergquist. What you're saying was
an evolution.
Later conversation, an evolution of the conversation.
In the discussion that came out of our meeting on the 18th of November, and reviewing this with Commissioner Benedon and Roy, that was sort of, again, a statement made about this process. And I think one of the things I just want to add is that the final considerations as they're worded here, there were references made to the testing data, and I do have that in here, and the dissemination of data from the data team, that has nothing to do with the legal department, so I just want to make sure people have clarity on that. And the other point would be, in reviewing this, if the board is looking to update the considerations, that's certainly within your ability to do. But I think in terms of looking at how we approach this process, I think just making these, the iterative process of document production available is also just a process improvement that it sounds like would address the majority of these concerns.
Right, Commissioner Roy?
Thank you. And I think Commissioner Benedon, we agreed on commissioners should see track changes. I think we agreed on that. I don't know if you have any thoughts on that. So we really didn't have an opportunity to look at the track changes until after the fact. And we kind of, now that goes kind of to process, like during the next process, we should be availed that opportunity. I don't know if you have any thoughts.
Do you have any comments?
Right. So that was something we discussed. I know that we did not discuss at length the impact in terms of efficiency of that, but we did talk about whether the board should review the track change comments, not only from legal, but from all chiefs, so that we are aware of what the changes are, what the different iterations are from what was purely put together exclusively by the testing team and what input or changes came.
But it's my understanding that there's an SOP about how these reports are put together. And that was followed, and there was input. And then after the fact, at the 11th hour, that SOP was second guessed. And so that's what I think we need to do here today, is make sure we have a process, making sure that our research team is clear in its language when it's making a request. But also, if we have an SOP, we don't allow last minute changes when it's gone through comms, when it's gone through legal. All of that has happened, and we have a responsibility to go to the legislature, and we have a responsibility to the public that we have a process, and this process was not followed. It was changed. So, Commissioner Roy.
Yeah, and to that point, this report, the first request was in September of 2022. This report ended up being 2 years late to the legislature, 2 years. So this will go to the process end of this discussion, but we can't have 2 year late report to the legislature, which helps guide and inform. I mean, we testified in front of House Ways and Means, and they referenced, some of the legislatures referenced our reports. So they do read them. And so it's incumbent upon us to give them all the information, including the economic drivers of what causes THC, potency, inflation, and lab shopping. So I don't know if we're going to hit the process end of this discussion, but.
And Executive Director Ahern?
Thank you, Madam Chair. No, I think that just to kind of reiterate some of the processes in here, certainly, again, I know it's going to reference the timeline here that I was not here. One of the elements I had indicated was, again, I think just to make clear, legal as well as other departments provide their feedback. and that, within the Q&A that research put out in March, which I was here for and was able to review with the chief of research, it is not that the edits were made, it is that suggestions are made and then the research department finalizes it. That's within the Q&A, but that within this process, what I would have been looking for at the time was to make sure that I was supporting the research team. Obviously, I was not here at the time, to indicate that the schedule that's put out at the beginning of that process is adhered to if they feel like they need support in that. And so that is one of the items that I have here in the conclusion. The other element that I mentioned within the timeline for the research requests, I did not find that research that was requested was not provided, but I did find that was referenced earlier by the chair when a PRR went out for information that would have been relevant, sharing that particularly with not just research, but I&E and other departments would be a better process for us moving forward, which data is fully on board with and will incorporate into their process updates. So I think there are lessons learned from this, and yet I don't want there to be an indication, and I think there were some people who misinterpreted the discussion on the 18th to say that data sets were removed from this report. That is not the case. I understand the clarification that you've made today, and I think that these process improvements will be implemented moving forward.
Commissioner Roy?
And I appreciate that because I know you are making every best effort to improve the process. We're going to have a different report. These reports alternate from year to year. So we want to make sure that process applies to all the reports. But some of the information that was requested in cannabinoids, Delta-9, THCA, CBD, CBDA, the heavy metals of arsenic, cadmium, lead, and mercury, vitamin E acetate, and testing by finished plant material was requested and not provided.
Are you aware of that?
In which one are you reading? It is the notes that you had provided as well.
It's from the research team.
I believe that is within the discussion that was had earlier. Madam Chair, if I may.
Yes, thank you.
Sorry, it's late.
I know we're
Forgetting my Robert's rules. I think that is certainly within the discussion that we've had with the Director of Data Analytics and the CTIO with reference earlier of what we're hoping will be able to be done on a consistent quarterly basis. That at that point, the amount of data and sort of the lessons learned again for doing these things for the first time is that a lot of those reports can be written so that they're repetitive and can be handled more easily. So I believe that has been addressed by data so that they'll be able to make sure that all of that all requests can be fulfilled. And again, there will be new questions that come up in the future and we will have to adjust. And certainly one of the takeaways that I have from Canada is that these are struggles that basically every jurisdiction has been dealing with. And so I think, taking a reflective look at this process and making improvements is absolutely necessary.
Thank you. Anybody else? Commissioner Roy? You take a motion about the process.
I'm sorry, Chair. Is it?
Oh, sorry, Commissioner Benedict? Are you good?
I'm sorry, Chair. Is the motion in bold?
That's what.
Okay, so I'm bringing this on the fly because I haven't had an opportunity to read it yet, but thank you, Chair. Making a motion, the Executive Director, Chief of Technology and Innovation, Chief of Investigations and Enforcement, and Director of Communications will work collaboratively and in a timely fashion to assist the Research Department in gathering needed information to complete all reporting which the CCC is required to complete on an annual basis under Chapter 94, Section G, subsection 17. This will be done in a collaborative and timely fashion once the Research Department has communicated the information and timeline needed to do the statutory reporting. Further, staff will adhere to all Research Department SOPs. And if I may, the commissioners will have the opportunity to review track changes.
Okay. You made that motion?
Could you put that in the chat, please?
Do you have that in writing?
No, I can type it out. No, people that do it. Just give it to me. I'll type it.
I can type it. Okay. Do you want to take a 2-minute break? I can type it. Or just type.
I was trying to think if there's anything else. While you're doing
Next
that,
meetings?
yeah, why don't we get on to, let's see, Executive Director, is there anything else? There is no new business anticipated posting because we fixed that. So if we could put up now the next meeting dates while she is tracking that. And so this is, again, I will, only because we've had major back and forth. These are all tentative and subject to change. They have been put in place so we can regularly meet, generally twice a month. It is done with the feedback from individual commissioners and some of our top staff so that we avoid any personal time or time away. So anyway, what we have is our next meeting date is going to be January 15th, 2026. It'll be a public meeting here, held hybrid, starting at 10 o'clock. And again, you can see the list of tentative meeting dates for 2026. So,
Anything else? Anybody sing or dance?
well, I'm just happy to see Attorney Schreffler is back. He missed us.
Please don't put words in my mouth.
No, but I do want to say, and I will recognize Attorney Bruno, because I did not make it to all of the presentation in the felicitation, these speeches, but I did find a copy of your poem congratulating Attorney Schreffler. So I read it, and the hilarious thing is I knew who wrote it. So it was on the floor. I mean, apparently everyone didn't save it as a keepsake, but congratulate you on your new role, but congratulating Attorney Bruno on being just I don't know if it's haiku or what, but it was very well done. So I really enjoyed it. So
Thank you, Madam Chair.
Yeah, it's the poetry part of law school.
the poetry part, no, it's the opposite of poetry. So how can you not be poetic? Yeah, as a recovering attorney.
Chair,
Yes.
I want to flag that the April 9th date is not a date that works for me.
Oh, okay. So we just intend to that. So we will work with that. Again, that's why I want to tell folks that this is just, we've tried to get this with all of the executive assistants to check with people. So this is still certainly subject to editing.
Almost done.
It's okay, sorry.
Madam Chair, while we're waiting, if I may, so we have tabled legal intervention, the 2027 budget discussion, and we will come back to potentially the notice of deficiencies once we review those materials.
Thank you. Yep. All right, Commissioner Stebbins, if you want to just take a minute to read what she's typed or what she's offered.
You can use that for just save you some time.
Yeah, you keep talking Gap, and I have to like think twice about
Shopping at the Gap.
Yeah, well, that's where my brain goes. I told you, he said DOT, and I think it's Department of Transportation. So I live with someone who pays a lot of attention to the DOT. Mr. Stebbins?
Thank you, Chair. Just quick clarification. The inclusion of Director of Communications. Why do we include that person?
Because they have always been, this is a public
Facing document.
Excuse me.
I think they're involved in any public facing documents.
Okay.
Excuse
Okay,
me,
sure.
if you recall the conversation about how difficult it was to get the driver's ed, you tell me. So.
Okay. Fair enough.
That's fair enough.
Fair enough?
Fair enough.
Present company excluded, so.
Yes.
Yeah.
I have another
So yeah, no, but it's a public facing document, and what their job is not to remove content. It is really to make formatting and stylistic. And again, that's part of why we put in here the SOPs, because there is an SOP. And again, we can always work with anybody here to amend those SOPs, but that was, I think, part of the problem is that the SOPs weren't followed and there were too many cooks, and this had gone through all of those processes, and then at the last minute, which is why it got delayed for so long. So, Commissioner Bennett?
Yes, so regarding the language that was put in the chat, which I know we'll discuss further, but there is a line in here. Commissioners will also have the opportunity to review all track changes to research reports. And I wonder if we might want to clarify that we are not, presumably by the time a research report is circulated to the chiefs, it has already undergone maybe a dozen iterations within the research team. Right. And so we are not suggesting that we should be reviewing the research team's internal track changes, but rather the changes made once it is reported out of the research team.
How we can bolster that?
Sure.
Sure.
Please, thank you.
Yeah, I'm comfortable with all of it except down to that last point. And again, I want to make sure that we are not treading on the integrity of the report. I know that's important to the research team, right? I'll wait and see.
No, but this is also part of the integrity of the research team, and it's also why we spent an additional $75,000 with the Donahue Institute when the actual research that was supposed to be done in real time regarding the extension of social equity exclusivity. And we couldn't just have, there are, as we know, there are standards under which this research is conducted and done. And so because we couldn't do that internally, because we were now doing it after the fact, and there could be confirmation bias or all these other, issues that we're worried about. So this is also why making sure that the research team is able to take the data, take the information, and just report, call balls and strikes, and to protect public health and safety. So that is a very good point, and I think that's something that maybe got lost in the process here. So clarifying this is a good thing, Executive Director.
If I may, the only thing I think looks inconsistent with the SOP is that it's not referencing general counsel being part of that process as well. I just would want to reiterate part of my role as well is supporting the research team, that commissioners in their review are also adhering to a timeline. So I think overall, this fits within the SOP with the exception of the last line, which is additional, and I agree with. And I would point out that obviously my role as well is to make sure that commissioners are also getting their feedback to the research team in a timely fashion.
Do the SOPs, I think the SOPs includes.
Yes. So I don't know that this is inconsistent with the SOP. It just may not be as elaborate. And I think the last line about the track changes going to commissioners is probably the change in process.
And again, I think that what we're putting in here is this is the gathering of the information. This is helping them inform, and then there are processes afterwards that's not what we're necessarily addressing here. We're talking about making sure that that small team, which is highly regarded across the country, that they have access to the information they need to have a sound and well thought out report. What happens afterwards in terms of how we dot the I's, cross the T's, making sure that we're not doing anything that violates any privilege, that's later. But this to me is just the process that I think was troubling to the team, was what happens leading up to some of that. So it's how do we make sure they get the information they need? Commissioner Stebbins?
Thank you, Madam Chair. And I think to your point, the first part of this motion, I think, speaks to that, to make the process more clear, the access to research and data. I'm a little concerned about the follow-on pieces and the reviewing of the track change. I'm okay with the motion as it reads up to the language.
She put better language, which is the opportunity. If you don't want to, you don't have to. It's just making sure that we can see if you want to.
And I guess I'm looking at these as two different things. The access to the information, getting it in a timely fashion, and then subsequent to that is data is folded into reports, kind of how that review process goes. So I'm comfortable if we stopped it at further, because I think Is I'm hearing all of you talking about, again, the need to access data in a timely fashion and the procedures for doing that. I think all of us agree is.
Can you clarify? What you're saying to take out?
I'm comfortable up so far with the motion up to I think it's about 3/4 of the way, 2/3 of the way down. Timeline needed to do this statutory reporting. Period. Everything else, I'm not happy to revisit, but I'm not quite comfortable with right now.
Commissioner Roy?
So in this process, we found out that SOPs necessarily were not adhered to. So that bolsters that. And for instance, if I would have had the track changes earlier, I would have argued or advocated to keep the economic drivers in. You might see something in market participation in your seat that a track change has been made that you might want to advocate to see that information on market participation left in. Commissioner Benedon might see something about agent registrations that she would see in a track change that she might want to advocate. So we just want that opportunity to say, at least have a discussion as, okay, maybe it does deserve to be edited out, but why? And we, so that's why I would like to keep that in.
Commissioner Stebbins?
I'm sorry.
Commissioner Benedon, sorry, I think you had your hand up. I will just on the SOPs, I'd like you to just sort of address that because that I think was the real problem here. That's sort of the kernel of the problem is that we didn't follow SOPs and we didn't follow timelines.
And that is actually what I wanted to speak to. And I apologize if I missed it, but I'm not sure that I actually reviewed the SOP itself, although we did talk about what the process generally would be. One thing that I do want to note for clarification is that my understanding is, and I think this is consistent with the SOP, that chiefs make proposed changes in track changes or via comments, but that ultimately it's up to the research team whether to accept them. And so is that an accurate statement that ultimately the research team remains final ownership and independence, and so they could reject a proposed change. And so one thing that we did learn, which the executive director alluded to earlier, was that the feedback from the research team that we heard through this process was that overall they felt that the input received, not just from legal, but overall strengthened the report and the considerations. But I think it's important to emphasize that ultimately the research team needs to retain independence, and if there is a recommended change in track changes, they could reject it.
Right. Yeah.
I think that happened. I think that happened here. So I think that we should be clear that there isn't a suggestion that a change was kind of made and forced on the team, but that all changes are recommended changes.
If I may, Madam Chair, just to that point, I believe the Q&A too, which is a link within the document, also specified that, which is the timeline, I think, is certainly something that was brought up and a request from the research team for my support moving forward to make sure that we stick to the timeline, but that ultimately they feel, the way that this is written is that they have the ability to accept or decline feedback.
Okay, thank you. All right, so do we, go ahead, Commissioner.
Sorry. And thank you, Madam Chair. And after Commissioner Benedon's comments, I'm feeling comfortable about going down to further staff will have adhere to all research department SOPs, but I'm still not comfortable with the language after that about reviewing track changes because, again, I appreciate the kind of independence of the research team to produce a report, and I don't want to send any signals that we as commissioners have our hands in it, even though our names are all on the report when it goes out. But I just to share with you, I'd be comfortable with the motion again after hearing Commissioner Benedon's comments up to the research department SOPs.
Okay, Executive Director, what's your name? Thank
you, Madam Chair.
Right.
And just to that point, I think Commissioner Benedon mentioned this before, we haven't gone through the actual SOP. So perhaps the review of the SOP to incorporate that, because I don't want to create additional work for research either. I think the answer is that the commissioners are looking to understand the feedback that was submitted. I think track changes over multiple iterations is going to be a document that will not make sense to the human eye. But in a lot of these, there are comments, there's those types of things. So if I could work with the research team to try to incorporate what the intent of the board is into the SOP and bring that back, would that work for the board?
Are you comfortable with that, Commissioner? Because you and Commissioner Bennett were more directly involved in.
Yeah, and I know you said they, accepted the changes, but if you read that meeting between Attorney Berquist, General Counsel, and the research team, basically they were pushing back, and it was explained to them, we don't want to be subpoenaed, and we don't want to be in a lawsuit. And this is going to the legislature. I have it in the notes, not my notes. I didn't write the notes. So there's also a pressure on them to have to accept, and I don't like that pressure. They felt like Commissioner, you're saying you don't want the research team to feel pressured by us, but there was enormous pressure because we don't want to be part of a lawsuit that we're not a party to. And this is, and multiple times it said the audience is the legislature, the audience is the legislature. So they were under pressure to accept these edits.
Madam Chair. Yeah, and I think within the Q&A, I think it answers sort of some of those elements, what is done and what is maintained. But I think when I'm saying this as it relates to the SOP is just, I think the intent here is to ensure visibility and clarity for the commissioners. And I just don't want to create something in this motion that creates a lot of work for the research department when they might be able to tell us how to do this better.
So how about we keep the language all the way up to SOPs, and then we can deal with the SOP
and maybe incorporate, commissioners can look at it and find before the very.
I just want the research team to be able to tell us how to work it.
All right. So are we comfortable? Because again, in a moment, I'm going to start forgetting my name. So anyway, it is. We've had a long day here, and I think we've had a very productive day. So I am going to reread for the record. We do have this here. We will stop at SOPs. So it's the executive director. The motion per Commissioner Roy.
Commissioner Benedon.
Oh! I thought you were.
Well, she fixed it.
Oh, she fixed it. Okay. Commissioner Benedon's motion, the Executive Director, Chief of Technology and Innovation, Chief of Investigations and Enforcement, Director of Communications will work collaboratively and in a timely fashion to assist the Research Department in gathering needed information to complete all reporting which the Cannabis Control Commission is required to complete on an annual basis under Chapter 94G, subsection 17. This will be done in a collaborative and timely fashion once the Research Department has communicated the information and timeline needed to do the statutory reporting. Further, staff will adhere to all Research Department SOPs. Having been moved, Commissioner Roy, do you second that? I second it. Having been moved and seconded, I will call the roll. Commissioner Roy.
Aye.
Commissioner Stebbins.
Aye.
Commissioner Benedon.
Aye.
Chair votes aye. It passes unanimously. So with that, I will entertain a motion to adjourn until, did I say January 5th?
Before we do that, these were the packets I knew, and thank you, Abby. She had printed them out. Remember? So just you have them for future reference. I know she had printed up this. Yeah, but I don't know if that has everything. So I knew she printed up Abby. Thank you. But anyway, so there they are. Oh yes, yeah.
So with that, I will entertain a motion to adjourn until January 15th, 2026 at 10 a.m. Commissioner Stebbins, do I hear that motion?
So moved.
Commissioner Roy, do I hear a second?
Second.
And before I call the roll, I just wish everybody happy holidays. Be safe over New Year's, and I hope everybody takes some needed time to recharge because we're going to have a lot of work in 2026. So with that, I will call the roll. Commissioner Roy.
Aye, but happy holidays to everyone as well.
Commissioner Stebbins.
Aye, and happy holidays.
Commissioner Benedon.
Aye. Happy holidays.
Thank you. Chair votes aye, and with that, we are unanimously adjourned until January 15th, 2026.
We're all tired.
All right.
Thank you. Good job. Thank you.